Mic testing, check, check, check. Okay, fine. Hello, mic testing. Oh, it's... Hello, hello. Yeah, no, it's fine. Alright guys, happy evening. Happy afternoon. How are you doing? Yeah, yesterday I said bye to you. You're like, okay. Anyway, torture over for you guys also is what I thought. Actually, honestly speaking, I did not have any schedule because they told me I only had to take BCR and they informed me that law is already over via online. Is it correct? No. Okay. What was over? Companies Act and Partnership are over in 2 units. Companies Act over. Companies Act was done. Okay. So I was thinking, I thought that, it is how it is, but yesterday evening they informed me. Actually, I had no class today here with you guys, but they told me that your torture should continue, right, with respect to Indian Contract Act. So, whatever you have material is the notes of the Indian Contract Act. I've sent it to you. You can use your phone to go through the notes. The thing is, only the notes. Don't text your girlfriend. Like this fellow has allowed us to do, darling, how are you, saptingla, yes, all that not allowed, right? If that is the case, then again, Krishna Gana Sabha 2023. Yes. So, Indian Contract Act is one of the most important chapters in your CA Foundation. Proof, your May 22 paper. If you see, first question, Sheila Auntie's sister, Sheena, yes. What? 4 marks question. What is this? Indian Contract Act. 4 marks Indian Contract Act. Then go down. This is Companies Act. Sale of Goods Act. Again, 7 marks Indian Contract Act. 7 plus 4, 11. 7 plus 4, 11. Then again, you see Partnership Act. Then here, again minor. This is Indian Contract Act. 11 plus 6, 17. 17 marks already. 17 marks already. 17 already. And again, if you see Indian Contract Act, 5 marks. 22 marks. 22 out of 60. Even if you take 20 out of 60, it is 1/4. 25% of your entire syllabus is going to come from Indian Contract Act. So the most important chapter standalone in your entire law, for your foundation law, is Indian Contract Act. Extremely important subject. Extremely important, chapter. And subject anyway is important, but this chapter is very, very important. 20 marks. So, I think we have around 7 classes, if I'm not wrong. Today, class is till what time? As per my schedule, it's 6 o'clock. 6:30. I got 6 o'clock. Anyway, we'll see how it works. No problem. Doesn't matter. But what I'm saying is, we have around 7 classes, which, since it's a fast track batch, we can easily finish Contract Act. It's going to be revision. So, do not assume that everything like full in-depth will be taught. It's revision. So, I'm telling you now only, it's going to be a revision session. So, at least something you know about Contract Act, right? You know the basics, etc. But of course, we'll revise everything. Quick revision it's going to be. It's a fast track batch. Same BCR also we did quick revision. This also we'll do quick revision, okay? Right. So, my material, coming to my material, you need to understand, as I already told you in BCR also, what is very important is how will you study one day before the exam. So in this 149 pages are there. If you want to take any printout also, you can only take printout up to, I'll tell you where also. First, 40 pages, these are all not needed. Q&A vault, okay, all that not needed. Till 43 pages you take printout, that's it, 43. Out of 149 pages, 43 pages you take printout. Why? Because, and then after that it is Q&A vault, that is question and answers, that you can use through normal, you can scroll through your phone only. Or anything. If you want to take, you take. I'm not stopping you. But I'll just tell you how my notes is. First is the running notes. This is the crash course material. One day before the exam, this will really help you. Even for regular batch, I use the same material actually, but I'll explain more. But in fast track, we'll go very fast and we'll finish off all these things. This is going to be the perfect revision material for one day before the exam. Then next question is, sir, one day before the exam is okay, but how will I study 2-3 hours before the exam? So you only have realized already since you have written, you have understood all the concepts, but where have you faltered? Presentation. Second one, you will not know what to study one day before the exam. That is why this material is for one day before the exam. First is your accounts material. It's very simple. You will use, what do you say? You will, what is the first example? First exam is accounts. And can you tell me 1 week before accounts paper, will you touch any other subject or only accounts? Only accounts. Before that accounts, I'm sure you will study quant or something, maths or stats rather than law. Law and BCR, you will say you will see later. That you will see later, we will see later, will become like you will never touch that. So basically roughly 10 days before the exam, you will never touch law or BCR. You also know, I also know, it's the truth. On the day of the exam, like today accounts exam got over, now tomorrow you have to study law and BCR. So will you open the institute material? It is stupidity. Why? What will you study in institute material? So much is there. That's why this material is good enough. This is, once you go 2 to 5 examination over, go home, take rest. After that, after a couple of hours, you can start this material, 43 pages. Next day will be your off, leave. That time also you study from this material. Now, on the day of the exam, you have to study, 2 to 5 is the exam. Morning you need to revise something. If you have a choice to revise, will you revise other chapters or you just have, let's say, 1 hour time? What will you revise? Contract Act, because it comes for sure, it comes for 20 marks. I'm just saying, if you have the full day, 8 a.m. to 12:31, you can still revise everything one shot. But again, my material, 43 pages material will be too much to revise. That's why what have I done for you guys for Contract Act? I have done charts. Everything is in the form of charts. So this chart will help you, correct? So this is actually a copyright material which I have prepared, and the copyright is with the publisher. I hope you know that when the copyright is done, even the author will not have the right to share. But then I'm trusting you guys and shared with you the PDF. So don't share it with other people, keep it to yourself, correct? That's why, because I'm not supposed to do this. I'm actually committing a breach of contract, honestly, correct? But because I'm not supposed to, the rights are not with me. I have prepared the charts, rights are not with me, it's with the publisher. So it's actually loss of revenue for the publisher. But it's okay. I can transfer to my family and I deem that you guys are all like my family members. Yes or no? Yes. So no problem. We can do, but on the trust that you will not share with some 1,000 people. You keep it to yourself and you study. Right? And all these things are there. This material, I'm talking only about the charts material. After the charts are over, then it's the Q&A vault. I told you, you have 2-3 months for the exam. You have to write question and answers. That is given here, full Q&A. Previous year's question papers from 2018 to almost, I think, 2021, it's covered here. The last 2-3 attempts, you can check your ICI website. That's okay. After all that is over, I have given you additional reading. This is all Q&A material only. So much Q&A is there. After Q&A, what is there? You have the additional material. Additional material is not this one, additional reading material from 84 onwards. This is nothing but Institute Study Material, ISM. Redesigned form of the ISM. Same ISM, only little redesign. That anyway you have. That's why I'm saying don't take printout from 85 onwards. Sir, I want Q&A material. Okay, till 83 you take printout if you want Q&A. Sir, I don't want Q&A also. I just want 1 day before the exam material and on the day of the exam material. If you have that, then you can only take printout till page number, which one? 43. So till page number 43, this one. So overall 43 pages printout it will be. Correct? Very simple. So we will start off with the crash course material here, which has everything together in one shot. So the Contract Act, this extends to what? Tell me. Whole of India or only Chennai? What about except Jammu and Kashmir? No, it is removed. So it extends to what? Whole of India. Extends to whole of India. It came into force on what? 1st September 1872. That's just for your knowledge. When you know how a law is passed. So generally it will be like a bill, and bill will be drafted by the drafting committee, go to the Lok Sabha, then it will go to the Rajya Sabha, and then President will sign, and then it will be, published in the official gazette. When it is published in the official gazette, what happens? it becomes a act. So when did that happen? They are trying to tell 1st September 1872. This was during the British Raj, right? Yes. It is Act number dash of 1872. Means in 1872, this was which law? Yeah, this was the 9th law to be passed. This was the 9th law to be passed in what? 1872. This was the 9th law to be passed in 1872. Right? In 1972. 1 second, I'll just ask them to bring some water. Good. Right. So now seeing all the definitions. Now definitions, guys. One thing we need to understand that everything we do in life is a contract. Yes or no? Everything we do in life is a contract. The fact that you and I are sitting here, the fact that you and I are sitting here is also what? Contract. You have a contract with KSA and you have paid money saying that yes, I will attend the classes. That's it. So everything that we do is a contract. So if I want to break down the Indian Contract Act, what is the definition of contract? If you see, this is the chart. What is the definition of contract? Contract is what? An agreement enforceable by law. An agreement enforceable by law. Tell me, what do you mean by an agreement? So today afternoon also, when you went, let's say you went and had some lunch, or now in the break you will go and have coffee. Is that a contract? Yes. Why? Because you will go and ask him to give you something. So I'll explain with these examples. What? Okay, one by one. I'll explain just the basic structure, then with examples. What is a contract? Agreement enforceable by law. What's an agreement? Basically reciprocal promises forming the consideration for each other. Reciprocal promises forming the consideration for each other. What is consideration, guys? Simple, in simple words, something in return. Something in return. It's also called quid pro quo. Quid pro quo is also what? Something in return. Reciprocal promise. Reciprocal promise. What is promise? Offer plus acceptance is called as a promise. Offer plus acceptance is called as a promise. So again, very simple. Contract is what? Agreement enforceable by law. And what is an agreement? Reciprocal promises forming the consideration for each other. Reciprocal promises forming the consideration for each other is that. And then what is promise? Offer plus acceptance. Offer plus acceptance is a promise. And what do you mean by an offer then? Offer. Also one more word for offer. Yes, well, boys and all are telling experience. February 14, no? Proposal, they're telling. Correct. Proposal, you are right, 100%. Boys only will tell all this. Yes, what is this? Proposal. Correct, it is proposal. So one more word for offer is called proposal. It is do what? It is two things. Willingness to do something. Willingness not to do something. Willingness to do something. Willingness not to do something. Why I'll be willing to do? With the object of the other person saying yes. The reason why I am trying to do something or not to do something, object is for the other person. That is the promisee or the acceptor to say yes or to accept. To say yes or to accept. So it is a proposal either to do something or a proposal not to do something. With the promisee or the acceptor to say yes. They'll either accept or they will reject, whatever the case may be. This is the entire scheme of things. Very simple. Now, what do you mean by proposal not to do something? Another word. Abstain from doing. Yes, abstain from doing. Abstain from doing. So very simple, guys. As I told you, let's take some examples. If I go now to the, afternoon, evening break when I give, if you go and say coffee, you'll first order, you say coffee, 1 cup coffee. Is it an offer or what? Yes. You have made a proposal to do something. What to do? You will pay money. Proposal to pay 15 rupees for 1 cup of coffee. He has accepted and he starts making coffee. So when he starts preparing coffee for you, has he accepted your offer? Yes. So offer plus acceptance becomes what? Promise. Promise. Now there are reciprocal promises. What is reciprocal promises? Forming the consideration for each other. Very simple. You have made a promise to pay 15 rupees. He has agreed to give you coffee. He has made a promise to give you coffee. In return, you are paying 15 rupees. This is called reciprocal promise. That reciprocal promises with consideration for each other will become what? Agreement. Will become agreement. Now, when this agreement, what happens to this agreement? When this agreement is enforceable by law. What do you mean by enforceable by law? Basically, if that other person does not do this, you can go to the court of law and lodge a suit. You can go to the court of law and lodge a suit. That is the meaning of enforceable by law. Now, coffee drinking, is it legal or illegal? Legal. So if you do not pay for the coffee, technically speaking, can he sue you guys? What do you think? If you do not bring coffee, get the coffee, if you do not pay water, etc., can you sue or not sue? What do you think? Can you do that or not? What do you think? Yes, you can. Definitely, yes, you can do that. Why? Because it is enforceable by law. On the other hand, now you tell your friend, hey, when this fellow is going down, you push him from the stairs. When I am going down, push that fellow from the stairs. If you push, 100 rupees I will give. Now, the other fellow will accept the challenge. So when I am going down, he will push me from the stairs. Stairs and all will break down. That's another thing. But anyway, let push. So then what happens? 100 rupees. You will come back and say, see, I have done it. See the video also, I have done it. Give me 100 rupees. Other fellow will say, who are you? I don't know. Which amount? What amount? I don't know. Now, you have pushed in the hope of getting 100 rupees. Can you go to the court and sue me? Or sue your friend? No. Why? It can never be enforceable by law. It is never be enforceable by law. Outside one Pani Puri fellow is there. You have seen? Outside AGR one Pani Puri fellow will be there. You wait for some 5:30, 6:30, one mama will come, police mama. Police mama will come on the bike and he will every day he will take money, observe. Every day he will take money, some 100 rupees or 50 rupees every day he will take. Now, why is mama taking money? Why? Mamul, correct, it's called mamul. Why is he taking that money? Why is he taking? Why does he need bribe? Can you on a public property, can you put your personal business like that without taking any license? No. So all these Pani Puri fellows, when they are selling on the road, it is illegal. Because you have not taken something called Shop and Establishment Act license. When you open any shop, even if it's a normal shop, one normal small garage, you need to take something called as Shop and Establishment Act license. You have not taken what? Shop and Establishment Act license. So the mama is trying to tell, you give me 50 rupees, mamul, then what will happen? I will not throw you out. I'll let you continue. Like that you will come and take every day. Now one day mamul he came and took in the bike. Mama came and took 50 rupees and he went away. Within half an hour, Big Mama came in Jeep. In white color Jeep, Big Mama came. Big Mama said, hey, you leave, the ministry is coming here, you get out. You don't have to, today you just get out today. You cannot park all your vehicles here, park all your, this thing there, this Pani Puri shop. Now, can this fellow said, I have already paid 50 rupees for today, I'll sue you. No. Why? This can never be enforceable by law. So, the most important thing in agreement is what? The most important thing in agreement is what? Enforceability by law. Enforceability by law. Agreement has to be enforceable by law. That is the most important thing. Correct? Contract is what? Agreement enforceable by law. So, what is so if the enforceability concept only is not there, then it is not a contract. So, can I say all contracts are agreements? Yes or no? Yes. But all agreements are not contract. My agreement with mama to pay 50 rupees and then keep my Pani Puri stall here definitely is agreement. But is it a contract? No. It can never be a contract, but because it is never enforceable. So your agreement with your friend to push me down the stairs is an agreement, but can it be a contract? No. So all contracts have to be agreements, definitely, and it has some enforceability concept with that. But all agreements, are they contracts? No. Why? Because there are some which are not working. So such agreements are called, which can never become contracts, are called void agreements. We'll see that later. Now, reciprocal promise forming the consideration for each other means what? So basically, if it is between me and you, or between you and KSA in this fast track batch, each person would have made a promise, and for each person there would be a consideration. What is your promise? Before attending and all, what is the main promise? Fees. Correct? Fees. First part is fees only, no? Of course, you will, in that, along with other rules will be there. You have to attend class, all that is secondary. Main is fees. What is KSA's consideration? What is KSA getting? What is KSA's consideration? What is KSA getting? Fees. KSA is getting fees, correct? So your promise, do you agree? Your promise is KSA's consideration, yes or no? Everybody guys, your promise is KSA's consideration, yes or no? Yes. What is KSA's promise? To torture you. They'll send people like me in the torture chamber, like this will be there. So we will come to torture. I am the torturer, you are the torturee. Yes. So KSA's promise is what? Torture. What is your consideration? Getting tortured, correct? Yes. Torture. So if you see, one person's promise is the other person's consideration, and KSA's promise is the other person's consideration. Two different promises are there, and which will be reverse consideration. One person's promise is other person's consideration. Second person's promise is the first person's consideration. This only is called as reciprocal promise forming the consideration for each other. Right? Reciprocal promise forming the consideration for each other. Reciprocal promise forming the consideration for each other. This is what it is called. So, thank you, man. Thanks. So, this is called reciprocal promise forming the consideration for each other. So, what will happen here? Reciprocal promise forming consideration for each other is called as an agreement. And if the agreement is enforceable by law, it becomes a contract. And promise is what? Offer plus acceptance. Promise is offer plus acceptance. And what is consideration? Something in return. Consideration will be something in return, quid pro quo, as you know. And offer plus acceptance, if you see, in that offer is called what? Proposal. It is willingness to do something or willingness not to do something. That's all. Very, very simple. This is the entire definition of contract. Now they'll ask you, what are the various types of contract there? So if you see this only, all contracts are agreements, but all agreements are not contracts. We know that. Now you read this part you read, you'll understand quickly. 1 minute. They read. You can use your mobiles to read the notes, not to text your girlfriend, only to read your notes, which I have sent you. So this, along with me only, you finish off. One round of full contract act will be over, then it's only revision for you. No need to read ISM because you've already studied, correct? So just read this material, more than enough. There is no time to sit and study everything now. Just stick to this material. It is more than sufficient for the exam to score really well. Yes, read. Then we'll explain other types of contracts. Done. Yes. So now guys, there has to be, when I say enforceability of law here, enforceability by law, it means what? It should be a legal obligation. Today this time you clear foundation, 100% you will clear, and then you will say, sir, come, let's go, I'll organize dinner for you. So you will book one nice, table where in Taj, correct, ITC Chola, you will book one table and you will tell, sir, please come, this is all arranged, everything. Especially for me, you will book one table. I will not come that day, correct? Then you will, next day, you will send a legal notice to me. Because of you, I spent 3,000 rupees. Stupid fellow, at least you could have come. Free food, correct? You didn't come. So 3,000 rupees you pay. Can you sue me? Why? Because it was just a social obligation. It was just a social obligation. So all social obligations are not contracts. So for example, there was one husband, let's say one husband. Husband is always sad or happy? Sad. So husband is there, sad. When you get married, no, this husband has suffering from three types. Basically, you have to, have three types of rings after marriage. During marriage. One is what? One is engagement ring. 3 rings he has to wear. One is engagement ring. Second one is what? Wedding ring. Third ring is what? Suffering. Correct. So, he was wearing the third ring also, suffering. So, he is always crying. Correct? Always crying. So, wife was there. Wife was so very, very happy. Wife, this is wife. Correct? Wife was more like Nagavalli. So, her teeth and all was there. Yes. So, Nagavalli wife was there. Yes. Oh, Papa, hair only is not there. Let's draw. Correct. So, this is husband. Full, some 4 are left. That's all. Everything is gone. Correct? And this is the, wife little long we will put. Yeah. This is the wife. There is extra added. GST is added. Yes. So, this is what? One is husband, one is wife. Now, both of them are fighting. Both of them are fighting. Husband says, I really want some peace of mind. I really want some peace of mind. As of now, I only have pieces of mind. Alright? So, this I don't want. I only want peace of mind. So, he says, you just shut your mouth. I will give you 20,000 rupees per month just for shutting your mouth. Nothing else. You please don't talk. I will also not talk. Let's be happy. 20k per month. So, deal done. Correct? Deal done. So, 1 month he'll pay, 2 months he'll pay, 3 months he'll pay. After that, he'll stop paying. So, wife will go to the court saying that husband had told that he will pay 20,000, then he did not pay. What do you think? So, is this social obligation or legal obligation? Social obligation. So, if you see, there are 4 strands of hair for the husband, 4 strands of hair for the wife, and hair in Hindi is called Balfour versus Balfour. Easy to remember. Yes. Correct? Balfour versus Balfour is what? Which case? Yeah, social obligation. Balfour versus Balfour is the name of the case. I hope you know that. It is what? Balfour versus Balfour. That is the name of the case. Balfour versus Balfour. What is the case? Balfour versus Balfour talks about social obligation and not legal obligation. So basically you should all, whatever you do, that social obligation must be there. Undoubtedly it must be there. So that is one part of the story. Here on the other hand, peace of mind, pieces of mind, different things. So that is what they are trying to tell. Next, what else? That is one part of the story. Next, classification of contracts. As you can see here, this is the important classification. It is there in the, anyway, in the institute material also anyway. So what is this, guys? On the basis of creation, one is called express contract. One more is called implied contract. What is express contract? Basically, let's see. Express means what? Express by words spoken or words written. Means oral agreement or written agreement, both are called as express. Basically, we should express. Implied means something which is understood. Implied means something which is understood. Express means spoken or written. On the other hand, we will discuss that more. On the other hand, on the basis of execution, it is executed. One more is executory. Executed and executory. Once the crash course is over, what happens to that contract? Executed. You have also fulfilled the promise, and KSA also has fulfilled the promise. That contract is called as executed contract. Executed contract. What is executory? Executory is either one person has to fulfill or both the people have to fulfill. Either one person has to fulfill or both the people have to fulfill. Executory is of 2 types. Executory is of two types, unilateral, bilateral. Unilateral or bilateral. As of today, the contract between you and KSA, unilateral or bilateral? Why unilateral? You have fulfilled the contract already by paying the fee. KSA yet to fulfill promise or fulfilled? Yet to fulfill. So it is called unilateral executory. Executory is of two types. Unilateral executory. One side promise over, one side yet to be done. Unilateral executory. What is bilateral then? Both the sides are pending. Both the sides are pending. If you, let's say, book a movie from Book My Show, unilateral or bilateral? Unilateral, because you have paid for the ticket already. You have to just, they have to perform, they have to give the, they show the movie to you, right? So that is what? Unilateral executory. What is bilateral then? Bilateral is when you just, for example, reserve a table. You are going to some nice restaurant, you will just reserve the table and you will pay some, in some restaurants they'll ask you to pay some basic amount. So some 200 rupees you will pay and reserve the table, right? Now, have they fulfilled their promise? In the sense, have they served you food? No. Have you paid for the food yet? No. This is what? Bilateral. Both sides have to fulfill their promise yet, bilateral. Similarly, in KSA, also if you had some, what do you say? If you had installment scheme in KSA, and let's say for the fast track you have paid, let's say there are two installments, one to be paid before and one more to be paid, let's say, next month. So if you have paid already 50% of the fee, and KSA is also taking their class, now tell me, is it unilateral or bilateral? Bilateral. Why? It is pending from your side also, it is pending from my side also. So it is called bilateral. That's all easy. Express means spoken or written. Anything that is spoken or written is a contract. When you go down and ask for coffee, that is an oral contract. Everything that we do in life is a oral contract. And in India, contracts initially are based on trust. When you go and ask for coffee, you are expecting freshly brewed coffee. When you go and ask for idli, you are expecting freshly, prepared idli. You cannot give day before yesterday's idli, heated up, and today morning, yesterday night's chutney. No. It should be freshly brewed coffee, freshly made idli, freshly made food. That's the basic that you can expect from anybody. Now, on the other hand, that is spoken or written. So written can be anything that is written. Like even when you get a receipt from the hotel, that is still a written contract actually, because you have something in writing. That you can use that, and let's say you take one coupon today. Can you go in the evening and give that coupon? Yes. Coffee coupon, you will take it today morning. You can give it in the evening also, no problem. Not that you have to give it then and there. Yeah. That is express. What do you mean by implied then? Implied means something which is understood, which we'll say in a while we'll see. But most important thing is these things. What? On the basis of enforceability. There are three types of contract. Valid, void and voidable. Valid, void and voidable. Three types of contract. Anyway, in the exam, all these other questions they will ask in the exam. The person who's making the, not in the question, these words will be there. Person who is making the offer is called? Other person. Person who is making the proposal. Other proposee and all is not there. Who is the other person? Acceptor. Person who is making the promise. Other person, promisee. Like that I was asking, person who lodges a suit, somebody said suer. Suer and all is not there. Suer, sui, correct? Suer in Hindi is pig, correct? Don't tell all that. Person who sues, suer. Other person, sui, no. Correct? It is what? So it is promiser, promisee. Person who actually lodges a suit is not called suer. Who is he? Plaintiff. Person who lodges a suit, puts a case in the court of law, is called as plaintiff. Other person, plaintee. No, it's called defendant. Other person is called defendant. Plaintiffee, plaintee, toffee. No, it is what? Plaintiff and defendant. Plaintiff and defendant. One more name for plaintiff is called petitioner. One more name for plaintiff is called petitioner. Other person, petitionee and all is not there. That is called what? What is the other word? Pepsodent. What? Respondent. Correct. Respondent is the other word. Respondent. Very simple. These are the terms which they can ask in the exam. These are the terms which they can ask in the exam. Offerer, proposer, promiser, plaintiff, petitioner. Can ask in the exam. These are the terms that we should be aware of. Got it? Very simple. Moving on. So as I told you guys, right, there are various, types of contract, as I told you. Let's quickly, 1 second. As far as contract are concerned, there are various types. And based on enforceability, one is called valid contract. Second is called void. In void, there are two types. Void agreement, void contract. One is valid contract, one more is void contract. Third one, voidable contract. So one is valid contract, one is void contract, and the other one is voidable contract. And under void, there is void agreement and void contract. Now, before that, valid contract means what? All the essential elements must be there. All the essential elements of contract must be there. Only then it is called as a valid contract. What are the essential elements? If you see page number 4, these are the essential elements. In a valid contract, what do you mean by a contract which is valid? It means all these items must be there. All these items must be there. There has to be offer and acceptance, intention to create, legal relationship, means it cannot be a social obligation. Consent must be free. What is free consent? We'll discuss. Then there should be something called consensus ad idem. Consensus ad idem. Then capacity to contract. We'll discuss everything, don't worry. Lawful consideration, lawful object. It should not be expressly declared void. Means law should not tell it is void. All the legal formalities have to be fulfilled, and it should be possible to perform that particular promise. It should be possible to perform that particular promise, and terms and conditions must be certain. Terms and conditions must be certain. Certainty of terms. Everything I'll explain, don't worry. Now, here, agreement we have seen, legal relationship we have seen. This case, case number 2, which case is this? Read these three, please. Read these three. Create legal, in that case number 3, you have to remember the name. Which name? You already know. Yes. Balfour versus Balfour. So, husband promised to pay his wife household allowance of so and so. Yes, this case is Balfour versus Balfour. Balfour versus Balfour is the case here. Very simple. To constitute a valid contract, there must be meeting of minds. There must be meeting of minds. So basically, I have two phones. Let's say I have two phones, and I am just showing you my, let's say this is a phone. Assume this is a phone. This is a phone. So I have two phones. And I am just telling that I will be selling. I just tell you that I want to sell a phone. I just say that I want to sell a phone. I want to sell this phone. I want to sell this phone. But you think that I am selling this phone. I will not tell which phone. You know that I have two phones. I am just telling I want to sell my phone for 10,000. In my mind, I want to sell this phone. In your mind, you want to buy this phone. Now, when you come and pay me 10,000 and I'm giving you this phone, you're saying, boss, I never paid for this. I paid for this. I'll tell boss, I never was selling this. I was actually selling this. Tell me, is this contract valid or void? Void. Why? One most important thing is missing. What? Both of us are not agreeing on the same thing in the same sense. I am thinking something, you're thinking something. That concept is called this one. Consensus ad idem. So, the constitute a valid contract, there must be meeting of minds. That is consensus ad idem. So, you should agree on the same thing in the same sense. So, if you see that, parties do not agree to the same thing in the same sense at the same time. They should all agree to what? Same thing in the same sense. same thing in the same sense. Both should agree to the same. Now, what do you mean by, free consent? Okay, what is consent? Consent is you're agreeing on the same thing in the same sense. Same thing in the same sense, that is consent. What is free consent? What is free consent? Basically, you should agree on the same thing in the same sense. But what do you mean by free consent? Yes, basically free consent means there should be freedom of thought. There should be freedom of expression. I should be voluntarily doing it. I should voluntarily, with my own heart, I should tell, no, correct, you're right. I agree. Law says there is no free consent if 5 items are there. What are those items? Coercion. Then undue influence. Yes. Fraud. Third is fraud. Fourth, misrepresentation. Mistake. What is mistake? Taking up CA. No. Mistake. Correct? Mistake. Coercion, undue influence, fraud, misrepresentation, mistake. Correct? Coercion, undue influence, fraud, misrepresentation and mistake. So, consent means agreeing on the same thing in the same sense. How you agreed also matters. Did I force you to agree or you voluntarily agreed? So, in these 5 circumstances, law says whatever you agreed was not by choice but by force. What are those 5 items? Coercion, undue influence, fraud, misrepresentation, mistake. All these items we will discuss later separately, right? So if you see guys, free consent. Consent of the parties of the contract must be free and genuine. Hence, consent should not be obtained by 5 items. What are those 5 items? Revision, coercion, undue influence, fraud, mistake, misrepresentation. Very simple. So if the contract has free consent, what happens to the contract? Valid. If the contract has free consent, what happens to the contract? It becomes valid. Competence to enter into a contract. Parties should be competent to enter into an agreement and make it legally enforceable. They should be competent to enter into a contract. How will the competence come? 3 keywords. First one, person is competent if he is a major. If he is a major. Major means what? Army major? What is major? 18 plus. 18 plus. He should be in the army. Army major. No. What is 18 plus? 18 plus is unsound mind. What is 18 plus? Major. So it's what? 1 day. Is it 18 years means exactly 18 years or 18 years 1 day? 18 years 1 day is called as a major. 18 years 1 day. Of dash. Sound mind. Means you should not be doing CA. CAs are all mental fellows. So it should be what? Of sound mind. One is what? Major. Second one, sound mind. Third one, should not be disqualified by any law. Should not be disqualified by law. Should not be disqualified by law. What do you mean by not disqualified by law? Come down here in the same sheet. Reasons for incapacity, it's there. Reasons for incapacity. First one is status. Second one is mental deficiency. Third one is unsound mind. Mental deficiency means minor. He is still mentally not mature enough. Mental deficiency means minor. Status means disqualification, disqualified by law. Disqualified by law. In this, some spelling mistake is there. You remove this corporation. That insolvent should go there basically. By mistake it has come down. Insolvent should come here. This is not needed. This is just foreign sovereign. Foreign sovereign. Foreign sovereign, alien enemy, convicted criminal, insolvent. 4 people. Now, who is, okay, alien enemy, one by one. First of all, when can't you enter into a contract? First, if you are unsound mind. When can't you enter into a contract? If you have some mental deficiency. When can't you enter into a contract? If you are disqualified by law. What are the cases of disqualification by law? These 4 items. Foreign sovereign, alien enemy, convicted criminal, insolvent. Insolvent. Yes, one by one. Alien enemy means what? I have entered into a contract with a Pakistani, absolutely no problem, I can do so. Tomorrow, government declares war against Pakistan and India calls Pakistan enemy country. Then, what happens to the contract already entered into? Gone. Or, as of today, can Ukrainians enter into any contract with Russians? No. Assuming they were in India, I'm just saying, same laws apply there also, assuming, then yes. And no other country will allow, actually no law in the world will allow you to trade with your enemy, obviously, right? So, any law will never permit the country to trade with their enemy. That is not possible at all. In Companies Act is over, na? You remember one case law, Daimler, Continental Tire, yeah, Daimler, same case. German company was there, no? Same thing, right? So, you cannot trade with your enemy. That was part of Indian Contract Act only, actually. Next. Who is a convicted criminal? Convicted criminal is a person who has been proven guilty in the court of law. Proven guilty in the court of law. Is a person who has been proven guilty in the court of law. So, can you enter into any contract with the convicted criminal, especially if he is undergoing his sentence? Undergoing sentence. Undergoing sentence means what? Sentence means imprisonment. So, if you have been proven guilty by the court of law, correct? Sanjay Dutt was proven guilty for having ammunition and arms which were not to be carried by any civilian. AK-56 rifles he was keeping. So, tell me, is he a convicted criminal? Yes. So, under the Terrorism and Disruptive Activities Act, TADA, he was convicted and sent to jail for 7 years. Rigorous imprisonment. Correct? Rigorous imprisonment, 7 years. Now, can you enter into any contract with Sanjay Dutt when he was jailed? No. Can you enter into a contract with him today? Yes. What about Salman Khan? Salman Khan was where? On a jeep. Correct? Salman Khan was on a jeep. What did he do? Killed. You know that story, right? So Salman Khan was, driving a jeep. I mean, he was not driving, Papa. Correct? Driver and all was driving. He was not driving. Assume this is a jeep. So Salman Khan was actually not driving, guys. He was standing. That's what he told everyone. Yeah. See, this is Salman Khan. Yes. Correct, Salman Khan. Correct, standing, 6-pack and all will draw. 8 packs will draw. GST will add and draw. Yes. So, this is Salman Khan is there going. Then in Mumbai there was a slum. 7 people were sleeping. 7 people were, sir, it is person or plant, or lollipop. Yeah. Whatever. So, this 7 people are sleeping. This fellow went and killed 7 people. Correct? 7 people got killed. Then he told the court, sir, I was not driving. My driver was driving. Then he got convicted in the lower court. When he went to higher court, he said driver was driving. And all these people who saw him, other people who saw him said, no, we didn't see him. How? Suddenly? Money. Correct? That's all. Money they would have paid and closed the case. So then they said, no, he was also not driving. Driver also was not driving. Correct? So 7 people got killed. Similarly, during the same time, one more case was going on. He went and killed a deer, chinkara or black buck. He killed a deer called chinkara or black buck. So the thing is, there also he was convicted, proven guilty. Then there also that case said, no, he was not there, all that was happening. So basically there also case closed, here also case closed. But that deer died and here 7 people died. Correct? So, but now, is he convicted criminal as such? No. Is he undergoing his sentence? No. Can you enter into a contract with him? Yes. He is just an accused, not a convicted criminal. Actually, Papa, I was telling the truth only. The deer was driving, guys. Deer, this is the deer. No, deer was driving. Okay. Deer was driving. Then it drove. It did not know, poor thing. It killed 7 people. After killing 7 people, it became full sad. So it committed suicide. Gone. Both the cases closed. This is what actually happened. Poor guy. Simply we blame Salman Khan. Correct? He is busy building his body and all. Yes. So basically, Salman Khan didn't kill anybody. Correct. This case both closed. Correct. Deer only was driving. Correct. Yes. So that's the end of the story. Now, what I am trying to tell is, can I enter into a contract with Salman Khan? Yes, I can. 100% yes, no problem. So if you see, foreign sovereign is one, then alien enemy, convicted criminal, foreign sovereign will come to it. Insolvent. What is insolvent? Your liability is far in excess of your assets. Your liability is far in excess of your assets. When the liability is far in excess of your assets, you are called what? Insolvent. And when you are insolvent, you will not tell, you will not obviously declare to others. Who will declare? Court. You will go to the court. Court will say, yes, you are 100% chaprasi fellow. And the court will say, take, from today you are called as insolvent. Next 2 years, you cannot enter, just example I am saying, next 2 years you cannot enter into any contract with anybody. You are official beggar is what they say. Correct? Basically, you cannot, obviously enter into any contract with anyone. This is called insolvency. Convicted criminal, insolvency, alien. What is foreign sovereign? You see this US embassy, US consulate you have seen near this Gemini Bridge. No, what is that bridge called? Gemini Bridge only. Mount Road. There is a US embassy. Correct? There. US embassy, that land which is there, does it belong to USA or India? As per the agreements between all countries, whenever another country's embassy is there in our country, that land, even though it is in our country, it is deemed to be in their country. So, Indian embassy in various places of the world, that land on paper is belonging to that country only. But as per the arrangement, where does it fall under? Here. So basically, if any USA citizen has some problem, he can go and seek help from the US embassy. And once that person walks into US embassy, will Indian laws apply? No. Can that person be arrested? No. So that's why if you see, many people go and seek shelter and help in the embassy. Once you reach the embassy, nobody can touch you. You have something called as diplomatic immunity. Diplomatic immunity. Foreign ambassadors and any person who is working there, they all have diplomatic immunity. So in this US embassy in Chennai, people are working. USA fellows are also there. Can you enter into any contract with them? No. They are barred from entering into any contract. Even, for example, can they hire a servant? No. Unless permission is taken from whom? USA and India. I should sign saying that this fellow will get this many people. Exactly this guy he will take and all that. Yeah. So that's what. So undergoing sentence, all that, it is not possible. And here also foreign sovereign, not possible. Correct? Yes. So this is regarding what, guys? Coming back to competence to contract. Then this part we will see later. Consideration must always be lawful. Whatever you are doing, money that you are getting should not be this should not be illegal money. I cannot say, I will do this for you, you give me black money. Black money is illegal or legal? Illegal. So actually black money is not illegal. Black money is money which has not been accounted for technically. Okay, let's say you get some money which obviously is not accounted and it has actually been derived by killing somebody. Correct? So that is actually called what? Illegal money. Now can you touch that illegal money? No. So the consideration should always be lawful. What about the object? Object means, what do you mean by object? The main objective of the law. So can I enter into a contract with you to a paper leak scam? I want to leak the 12th standard science papers, all papers. I'll tell you, pay me so much amount, I will give you the leaked paper. Is that a valid agreement? No. It is obviously object itself is unlawful. Then some things are not declared void. That's this one. Certainty of terms. The meaning of the agreement must be dash or dash. The meaning of the agreement must be certain or one more. We'll see. Solve these examples now, then you'll understand. Page number 6. Come on, solve. What is certain? What is uncertain? Check. Solve. 1 minute. That's it. Page number 6. You do it on your own. No problem. 1 minute I'll give you. Read and do it on your own. Check it out. You can write the answer. You no need to write the question. You can write the answer in your book, or you can just do it in your mind only. No problem. Read. 1 or 2, 3 will be easy. Later slightly you will get confused. On A agrees to sell B 100 tons of oil. Certain, uncertain? Uncertain. Why? Why? Which kind of oil? Don't know. Good. A agrees to sell to B 100 tons of kerosene oil at 15 rupees per liter. Certain. Because I am telling which kind of oil, how much rate, everything I am telling. Mr. A, who is a dealer in coconut oil only, agrees to sell 100 tons of oil at 300 per liter. Certain, because he is only selling one type of oil. So these three are easy. What about the fourth one? A agrees to sell to B all the grain in his granary at Lakshmi Nagar at the rate of 15 rupees per kg. So if I go to, let's say I want some 500 sweets, I'll go to a place, I'll see 100, guarantee 500 is not there, I know for sure. I'll just tell him, sir, whatever is there, you give me, sir. Whatever sweets are there, you give me. How much per piece? 10 rupees. Give me everything, sir. Is it certain or uncertain? Think about it. How is it certain? He will count. No, he will count and say, sir, 233 are there. Okay, sir, give me. You wanted 500. You know that 500 is not there. You will go and say, whatever is there, you give me. So I will count. So it may not be certain at the time of asking, but can he count it? Yes. So if you see here, coming back, there are one very nice dialogue. The meaning of the agreement must be certain, or one more dialogue, capable of being made certain. Capable of being made certain. The meaning of the agreement must be, point number A, certain, or capable of being made certain. Capable of being made certain. You had class in the morning also? First class only is this. Okay. So only 4 hours a day? Generally from beginning? Recorded was? Sorry, the online was? 1.5 hours. Okay. So the meaning, I'm just asking, just want to know how many hours per day, just generally asking. The meaning of agreement must be certain or capable of being made certain. Capable of being made certain. In this example, so wants to sell to B all the grain in his granary. All the grain in his granary. I am just telling, granary means a place where grain is stored. Warehouse. I'll go to the warehouse and say, bro, whatever is there, you give me. Whatever, how many, whichever items are there, you give me here. Whatever number of kgs. At the point when I'm asking, it may not be certain, but he can weigh it, no. He will weigh and say, sir, 1000 kgs are there, or 989 kgs are there. Okay, 989 into 15, I'll pay. So this is definitely certain because it is capable of being made certain. Capable of being made certain. Similarly, when you go to a shop and say, give me whatever sweets you have, yes, capable of being made certain. On the other hand, if I say, I want to sell my horse for 500 rupees or 1000 rupees, I don't know, then this is uncertain. Definitely uncertain. What is the previous one? A agrees to sell to B 1000 kgs of rice at a price to be fixed by some other person. C will be a valuer, that's what I am trying to tell. He will be a valuer. So I will say, let's agree, let's go to that person, whatever he gives the rate, let's go to him. Yes, it is what? Capable of being made certain. Capable of being made certain. When I am talking about it, it's not certain, obviously. When I am talking about it, it's not certain. But I will give it to C and C will fix it. Both of us are agreeing that C's rate is fine, final. Whatever C tells, we will agree. That is called capable of being made certain. Capable of being made certain. Got it? So that's all, guys. Chiller. All easy. So all this section 29, certainty of terms. So keywords, remember, in the exam are what? Meaning of the agreement must be certain or capable of being made certain. Are you guys understanding? Yes or no? Yes, superb. So if you see this lawful consideration, lawful object, not declared void, means the law should not declare it void. Possibility of performance. If I say, you give me 1 lakh rupees, I'll make you CA in 3 months. Will you agree? So is it possible? No chance. Nobody can do it. Nobody. It is impossible. If I say, give me 10,000 rupees, I'll leak the CA paper. Impossible. From 1949 till 2022, ours is the only institute where one paper also has not leaked. Not joking. Not even once. That is the best part of our institute. No other institute can boast of this. 1949, Chartered Accountants Act came. From there to now, how many years? Some 74, 75 years, 73 years, not even once paper leak. Think of that's how strict our institute is. So if at all you pass, it is purely because of your hard work. No copying also, the moment you copy, they'll catch you. There is no scene of copying. And if you get caught, 5 years, cannot write. And your paper, your photo, color photo will come on the book. So all that is there. So it's a very the course only for the deserved. No reservation also. Stupid reservations not there. Everybody has to score what? Minimum 40, overall 50. I don't care whether you are SC, ST, OBC, GM, nothing. They say I don't see all those things. I will see only your brilliance. You can be whatever caste, creed, I don't care. Do you have the brains or do you have the hard-working ability? Come. Otherwise, get out. That's it. So there's no reservation, nothing, which is excellent. Anyway, so these are all the essentials of valid contract as we have seen. So now, coming to this. So we were still discussing this. What are the types? What is all the essential elements? If it is there, it is called valid. That's what we saw. Then what is void agreement then? Void agreement, void contract, what's the difference? Void agreement can never be enforceable. Void agreement can never be enforceable. Means what? Agreement with minor. Can you make it valid and then make it invalid? No. The word void means what? Invalid. The word void means invalid. So my question is, can you make agreement with minor valid first and then make invalid, or from the beginning only invalid? Begin only invalid. Your agreement with your friend to push me down the stairs, can it be enforceable by law? Never. You giving 500 rupees to mama to just allow you to continue there, can it ever be enforced in the court of law? Never. All these agreements which can never become contracts, at the time of agreement only it is void and forever it will be void, are called void agreements. They are void from the beginning. Hence it is also called void ab initio. Void ab initio. This will include illegal agreements also. All illegal agreements are 100% void agreements, but all void agreements need not be illegal. All void agreements need not be illegal. Then what is a void contract? As the name suggests, first it is valid because it's a contract, and later it becomes void because of some reason. Initially it starts off as a valid contract. I entered into a contract with Raha Fateh Ali Khan of Pakistan. He's a very famous singer, very, very beautiful singer. Raha Fateh Ali Khan of Pakistan. I'll tell him 10 lakh rupees I'll give you. You have to come and sing in Legend movie. Example, correct? So you have to come and sing in the movie. Now, the moment this happens, in 2 days, India declares war against Pakistan. What happens to this contract? Initially it was valid when everything was fine. Now it becomes void. Now it becomes void. Very, very simple. Like for example, COVID. You had purchased one ticket to go abroad. Everything. Was it a valid contract? Yes. Suddenly COVID happened. All borders closed. Now what? What happens to the contract? Void. Initially valid, later void. Will you get your money back? 100% yes. Because contract only is void. Whatever money you paid, you will get back. That's why contract is void. So if you see, the reasons of void contract are given here only, page number 4. These are the examples of contract which was valid, later becoming void. Contracts which were valid, later becoming void. Circumstances under which a contract which is valid at the formation becomes void later. Circumstances under which contract which is valid at the formation becomes void. One by one. Destruction of the subject matter. Destruction of the subject matter. Death of the parties. Contract becoming unlawful. One or more parties becoming unsound. Alien enemy. One by one. Destruction of the subject matter. I have hired AGR building 3rd floor for my class. Assume I have hired it. I have paid some 10,000 rupees to the organizers. Now I have called you for the class and all those things. One day before, is the contract valid or void? Valid. I have paid advance 10,000. One day before the class, there is a short circuit here and 3rd floor is destroyed due to fire. What happens to the contract? Void. Destruction of the subject matter. Valid contract becomes void. Death of the parties. Death of the parties. I have hired somebody to draw my portrait. Correct? I am sitting like this. That fellow is drawing my portrait. Correct? Let's see. This is my portrait. He is drawing. Correct? He is drawing. When he reached my nose only, this fellow seeing my nose and my other things, they are full like this and all I am putting. That is my pose. I am sitting in front of him. By seeing everything, by drawing only, heart attack happened for the artist. And he died. While drawing my portrait only, he died. Now tell me, can I sue him for not completing? No. Can his son come and complete it? No. Because I have entered into a contract only with him. Can his son come and complete it? No. What happens to the contract? Void. So this second one, death of the parties. On the other hand, if you book the movie ticket and you die, can your friend go watch the movie? Yes. Movie ticket, will it have your name? Yes. But no. Will yes or no? Booking name will be there. Anybody can watch. No. It's not something of personal nature. Correct? So two of you are going, that you will die. He'll say, okay, anyway you died. He'll take the ticket and he'll go. He'll call his girlfriend. Right? Simple. So it says what? It is obviously no problem. Movie and all you can watch, but this is like personal contract. I have hired that artist to draw my portrait. Correct? That's it. Next. Contract becoming unlawful. That's what initially it was valid. Let's say I have obtained a liquor license from Chennai, Tamil Nadu government. I have obtained a liquor license. And tomorrow, 2-3 days later, Stalin says, Tamil Nadu, full Tamil Nadu, liquor ban. Tamil Nadu, liquor is banned. If he tells, no chance, I know. If he tells, then what happens? Then contract, now that liquor license, it becomes unlawful. It becomes, that no scene it will happen in Karnataka, Tamil Nadu, impossible. Okay, no, India it happens. In Gujarat and all it's banned. At least on the face of it, it's banned. But it has become a business. In Gujarat, the police officers mint money because of liquor smuggling. They only mint money, they allow. So, in Gujarat it is. Basically, Mahatma Gandhi ji had told, nobody should drink. So that's why in his own hometown, Gujarat is his home state, they had banned. That was the reason. Now everybody openly drinks there. And only in 1 or 2 places liquor license is allowed. For that you need signature and all those things. Otherwise it is banned. But then openly people do it in Gujarat and all that. Here also, I mean in Tamil Nadu, Karnataka, Kerala and all, if they ban, impossible. No chance. Pondicherry and all, if they ban, that's it, impossible. People go there only to imagine banning liquor in Goa. Yes, so not possible. Anyway, so contract becoming unlawful. Next, 1 or more parties become unsound. So 2 people have entered into a contract, correct? 1 fellow joins CA, so he becomes unsound. So what happens? So obviously, can you continue the contract with him? No. These are some funny examples I'm giving. Don't go and write this in the exam. 1 fellow becomes CA. No. Yes. So 1 or more parties becoming of unsound mind. So you already know what is unsound mind? Yes. You're experiencing it. Alien enemy means what? Already discussed. So tomorrow, obviously, that Ra Fateh Ali Khan example, alien enemy. All these things. So these are the areas where initially contract is valid. Later it becomes void due to some reasons, any reasons for that matter, then it is called as void contract. So if you see, coming back to the discussion, we have void agreement, then we have void contract. Last part, what do you mean by voidable contract? In one simple word, one simple sentence, absence of free consent. Absence of free consent. Absence of free consent is called voidable. Now, in free consent, 5 items we saw: fraud, undue influence, mistake, misrepresentation, fraud, coercion. So we saw 5 items. Here, in voidable contract, absence of free consent with respect to 4 items are covered. What? Fraud, coercion, undue influence, misrepresentation. Mistake is not there. So mistake is not voidable. Mistake is either valid or it's void. That's why mistake will not come. So if the contract is affected by misrepresentation or fraud or coercion or undue influence, then it is called voidable contract. It is called voidable contract. Absence of free consent. Absence of free consent. So if some Sheila auntie is walking on the road, yes, sir, you have drawing spiral binding, or what is this? This is yes, Sheila auntie. Okay, sorry, yes, eyebrow and all deemed, assumed, correct? So Sheila auntie is walking on the road. Sheila auntie likes what? Jewelry. So if you see everywhere full, her entire, what, all jewelry, here also full jewelry, and here also full jewelry. So she is walking on the road with full on jewelry. When one KD fellow will come, correct? KD fellow, correct? He looks like Teenage Mutant Ninja Turtles, yeah, correct? KD fellow will come, and KD fellow will show what? KD fellow will have a knife. Yes, he will show knife. And he will tell, either you give your life or you give up your gold. Correct? So Sheila auntie will say, okay, take the gold, no problem. Done. Now, the thing is there consent? Did they agree on the same thing in the same sense? Yes. Very simple. He made a proposal, either gold or your life. The proposal was accepted, choice was made. Please take the gold. Very simple. So consent was done. consent was taken. But was the consent free? No, the consent was not free. It was using force. Force is coercion. So now it is up to Sheila auntie to do two things. What? Either she can let it go and she can make the contract valid. She like, leave it, no problem. Because I told you, free consent is needed to make the contract valid. So she can say, let it be, it's okay. I'll assume it to be free consent. She can say, anyway, that fellow thought it was all real gold, it was artificial gold. Some 10,000 rupees, let him take, it's okay. Either it can be made valid or you can make it void. Either she can make it valid or she can make void. How can she make it void? Go to the police station and say, this thing I've lost and all that. So basically you can either make it valid or make it void. Either make it valid or make it void. Now what is this? Called as voidable contract. Voidable contract. In voidable contract, there is what? Absence of free consent. Absence of free consent. That's all. So these are the various types of, contracts which are there. Very, very simple. The other parts are all fine. For fast track, that is not needed. This much is enough to understand, right? So quick revision. What is this? What are the types of contracts? Express or implied. Implied is still there. We'll have to do it. We'll do it now. Express or implied. Then you have executed, executory. In executory, you have unilateral, bilateral. And then we have valid, which all essential elements must be there. Voidable and void. In void, you have void agreement, void contract. Void agreement is also called void ab initio. Then void contract. Then voidable. In voidable, what? Either you can make it valid or you can make it void. You can make it valid or you can make it void. Very simple. Then solve these two questions and tell me whether it is social obligation or legal obligation. Page number 6. And then we'll do implied contract. Check it out. Page number 6. Read. Page number 6. Read in your mobile and whatever. And then tell me whether it is social obligation or legal obligation. Okay, 1 second. Where? Here only, no. Take. This is how it is. No? It's fine. You know I need one more, da. Send them. Okay, guys, tell me. What is it? First one. Social obligation. Social obligation. Where is the legal obligation? Just I invited somebody and he didn't come, I can't help it. So it's a social obligation. It is a social obligation is what they say. Okay. So social obligation. Then what is the second one? What about the second one? So if your father says he will give you one car after you clear CA foundation, social or legal? Then you clear and you go and ask your dad, then he gets, no inter, he'll give you a car, he'll give you that other car. If you pull like this and it will go in front, no, that car he'll give. He never said which car, he said car. Toy he'll give and say take it. So now what do you think? But still it's a social obligation. But what will your answer be in this case if it was same? In this case, if it was written and registered document. Thank you. Written and registered agreement. We'll have to see that later. If there is a written and registered agreement between you and your father, that the father will give you so and so if you clear the examination, would be Valid or void is something that we'll have to see later. We'll see that later. What do you think? Valid or void? We'll see that later. There's a separate concept. But now it is a social obligation. So there can be still one scenario where you can sue your dad. Don't go and tell him all this. Yes. So it is social obligation, then return and registered agreement. Yes. Last part of the first subchapter would be, and in this material would be what? The, other type, the implied contract as such. So let's see implied contract. Yeah. Implied contract. So guys, implied contract is of two types. Implied contract is of two types. One is what? Implied by law. Implied by law. Second is what? Implied by action. One is implied by law. Other one is what? Implied by action. Now tell me, what do you mean by implied? Means which is understood. Implied means understood. What is implied by action? If you go to a ATM machine, will you talk to the ATM machine? No. It's purely based on action. You will key in your PIN, insert your card, key in your PIN, whatever money you want, let's say 5,000. What if 2,000 rupees comes out and suddenly the screen goes blank? Can you sue the bank? Yes. Can you recover the money from the bank? Yes. Did you speak to the ATM machine? No. Did you expressly say this is the offer? No. Was it by words spoken or words written? No. It was purely through action. So this contract between you and the ATM machine is called implied by action. Implied by action. Called what? And also one more. During auction sale. Auction sale. What will you do? When will you say it is sold? Yes. Fall of the hammer. Fall of the hammer, you will say it is sold. So when you do that, when you strike the hammer, you are saying it is sold. Now the sale is made at the fall of the hammer, or when will it be made? Yes, obviously there is no need to open your mouth and tell sold. The moment you strike the hammer, it is understood that it is sold. So now the question is, this contract is made expressly or through actions? Action. So it is not, it's not an express contract at all. It is implied by action. So these examples, ATM machine and what the other one, the auction sale. This is called implied by action. And such contracts are called tacit contracts. Tacit, T-A-C-I-T, not take it, tack it, and all that. Tacit, tacit contract. Tacit contract means what? Silent, where it is nobody speaks anything, but actions speak louder than words. Where the actions speak. When I strike the hammer, the action is speaking for itself. That is called tacit contract. Once for 4 marks they ask this question. I'll show you a video. For 4 marks they ask this question. I'm not joking. You need to tell me the answer. 4 marks, not even 1 or 2 marks. 1 or 2 marks means I can understand. 4 marks they ask this question. I'll show you that video. So basically, see, 1 or 2 marks if they ask, no, we can somehow manage. But some 4 or 5 marks and all, if they ask, it will be a huge problem. So let's see. This was asked in the exam.
Miljoona siellä herra. Nimessä. Miljoona siellä herra. Tuleeko muita tarjouksia? Ei tule. Miljoona ensimmäinen, miljoona toinen, miljoona kolmas.
They asked in the exam, who is liable? Seller, buyer, auctioneer. 4 marks question. CA Inter. I'm not joking. Based on this only they asked. Check it out again.
Miljoona siellä herra. Tuleeko muita tarjouksia? Ei tule. Miljoona ensimmäinen, miljoona toinen, miljoona kolmas.
Correct. So, what is it? Who is responsible? Buyer. Who is responsible? Buyer. Buyer, seller, don't know. Later we'll see. Buyer is responsible, seller. So here we should read what? Both Contract Act and Sale of Goods Act. Why Sale of Goods Act? Why? Sale by auction. Sale by auction. So we'll have to see both Sale of Goods Act and this, both. So action, tacit. So now tell me, what is the other one? Quasi contract. We'll see. So first you see this examples. Please do one thing. Read this tacit and express. Page number 3. You leave quasi. Read 1A and C along with example A and C. Thank you, thank you. All throwing everything. It's like showing, hey, leave enough, da, get out. It fell down, it falls like that only. Then it will fall on me tomorrow until it fell down. Yes. Read, okay, read, come on. Right. Now, what is the next part, guys? Quasi contract. Quasi means what? So, if you see here, one is implied by action is anyway here. This is implied by law. Implied by law. So, few examples I will give you here. Implied by law. So, with few examples. Now, there was, check it out. There was one tenant. He was farming in a land owned by Zamindar. Zamindar was owning a land and this fellow tenant was doing farming. One day, income tax mama came, correct? Income tax mama. And he came and said, boss, this you have not paid so much tax. You have not paid so much tax since so many years. I am going to take over the farmland. I am going to take over the farmland. Either pay or I will take over the farmland. Zamindar said, okay, you take, who cares? I don't care. Anyway, I have so much land, this is nothing for me, take it. But unfortunately, in that farm, almost 40-50 lakh worth of crops who had grown, tenant. Tenant says, don't worry, Zamindar, I will pay tax on your behalf. Later we'll adjust. I will pay tax on your behalf. So who paid tax? Tenant paid tax on behalf of the Zamindar. Income tax mama went away, over. Now, tenant, can he recover the money from Zamindar? Zamindar says, boss, it is not, I don't care, why did you pay for me? You wanted to retain your land because your items, your crops were there worth 60-70 lakhs, that's why you paid. Think of it as a business expense. Why are you saying that I have to pay? This went to court. Who will win? That is one question. We'll ask all questions and then I'll come to the question number 1. Question number 2. You are a CA student traveling in a train. Assume this is train. Don't ask other questions. This is train. How and all, don't ask. Yes. So from train, one fellow is getting down. That is you. Right? Once you got down and one coolie, without asking or without even telling you anything, I will put all the books one after the other, one top of the other like this. Books, CA books, correct? Right, CA final, everything. Correct? This is the thing. Now, you do not tell him anything. He also doesn't tell anything. And when he's actually putting the books on, you are not even stopping him. Then you walk, he also walks behind you. And when you reach the taxi, he will say, pay 300 rupees. You will say, who are you? I never asked you to do it. Correct? I never asked you to do it. Show me, was there an express contract? No. Is it implied by any action? There is no action here. You only did whatever you wanted on your own and you just came here. It was not that an ATM machine where I had to insert the card and do some actions, or auction where I said like this, nothing. There was no action involved here. I did not tell anything, you did not tell anything. So who should he pay or not? Should pay, okay. Then the thing is, okay, that is you only, minor. Generally one minor, KD fellow, correct? It looks very innocent but is an KD minor. So this KD fellow, 16 years of age, he entered KSA, he took KSA's food, shelter, PG state, nicely ate also, and then took the education from KSA. He came for foundation fast track. He told that I will pay 10,000 in 1 month, there is some problem in the house, they agreed, no problem. 10,000 he had to pay. Now, he took all the services and he was about to run away. So KSA says, boss, you have to pay 10,000. He said, agreement with minor is void ab initio. Super. Agreement with minor is what? Void ab initio. That's it. I am a minor. Agreement with me is void ab initio. So what? Pay or not? Okay. Like when you're walking on the road you find a kidney. Means what? iPhone, kidney phone. Right? You're walking on the road, you find somebody's kidney. You'll pick up their kidney. Nice it is to look, silver color, all that. But it is little damaged. You switch on the phone, then you'll figure out who's the owner and all. And then now owner will come and say, give it to me. You will say, why? Where is the contract between me and you? Show me, where is the contract? There is no contract. You are different, I am different. Should he return or not? He should return. He should return. Correct? Then, let's say there was one more. Let's, your, what's your name? Sham. Okay. There was Sham stays in an apartment. Okay. So he one day ordered mango milkshake from Swiggy. So Sham stays in an apartment number 420. Example. So Sham stays in apartment 420. What is the spelling, man? SHYAM. Okay. Sham, he stays there in apartment number 420. So he has got the, what do you say? A mango milkshake from Swiggy. Now the Swiggy fellow, when he is delivering, he goes to 402 by mistake. Correct? So 402. And then there also one more fellow is there. His name is Sham Sundar. Correct? Sham Sundar is there. This fellow's name is Sham, that fellow's name is Sham Sundar. So this guy, when he opens the door, Swiggy guy says, hi, is it Mr. Sham? He obviously says, okay, because Sham Sundar short form is Sham anyway. So he will say, sir, delivery for you. Correct? Then Sham Sundar will pick up, hey, mango milkshake, I never ordered. Oh, maybe my girlfriend would have ordered. Then he thinks, hey, I don't have girlfriend only, how will she order? Correct? So basically, then anyway, who cares? Somebody has ordered, maybe some well-wisher would have ordered. Then he will open the thing and then he will start, one sip he has. And then he sees number 420. Then he realizes, oh, it is actually belongs to Sham. By mistake, they have delivered to me. But the milkshake was superbly tasty. Once you have already tasted, you don't want to leave. So he will say, anyway, Sham will not realize how much is there. I will drink half and add water, no problem. Then he will not know only. So that Sham Sundar drinks half of that milkshake. By this time, this fellow comes to know something is wrong. He is trying to call the Swiggy guy. Swiggy guy is telling it's already delivered. So then he finds out, where did you deliver? Then he said, sir, this was there in that. Then he realized, okay, I think he has gone to 402. Immediately he goes to Sham Sundar's house and he opens. Sham Sundar is putting water. Right? Now he tells very simple, boss, I don't care, you have to pay me. This guy says, Sham Sundar says, why should I pay you? Where is the contract between me and you? Show me. I will have to pay something when I have a contract. There is no contract between me and you. So what do you think? What happens? What do you think? So should he pay or not? So all these things are not inserted in the Contract Act at all, unfortunately. Nowhere it says all these things. So people were doing whatever they wanted to do. That's why they made an amendment and they added chapter number 5. They said these contracts are not contracts as such, but they resemble something like contract. They are not actual contracts, they are false contracts. If you tell something false contract, it sounds so weird, correct? If you call something false contract, it sounds very weird. So they gave a term for that. What is the term? Quasi contract. Yes, they gave a term called quasi contract. Quasi means false, something that is resembling a contract. Something that is resembling a contract. Quasi contract, false contract. Correct? Something that is resembling a contract. Correct? That is quasi contract. One is this and the other one is quasi contract. Then implied by action is the other one, that is called tacit contract. Implied by action, that is this tacit contract. Quasi contract is from section number 68, 69, 70, 71, 72. 68, 69, 70, 71, 72. 68 says if you are a minor or if you are a person incompetent to enter into a contract, what will happen? If you are a minor or incompetent to enter into a contract, what will happen? The contract, and then if you take something for necessaries, if you have taken food, shelter like that, you have to pay. Personally you have to pay or through your estate? Estate. Through your estate you need to pay. Similarly, your 69 is that Zamindar example. Correct? Then 70, 71 all is finder of lost goods. Finder of lost goods means if you find some phone etc., it is your duty as per law to actually return it back. Yesterday they were telling where is it written? I don't know where it's written. Now I am telling it is written in law. Then 72 is that Shyam Sundar example where anything returned by, anything given by mistake to somebody else has to be returned. So law inserted these provisions so that there is absolutely no confusion. So this is nobody can enrich themselves unjustly. This is the process of unjust enrichment. Nobody can enrich themselves unjustly at the expense of others. Unjust enrichment it's called. Unjust enrichment. Nobody can enrich themselves unjustly at the expense of others. That's why quasi contract. So with the examples I have given, I'll tell you the page number. This is a separate chapter called quasi contract. After all this is over, please read. I'll give you 2-3 minutes. Please read it. It is in, so along with me only, if you read and finish, it will be easy. Read page number 30, 30. 30 and 31, please read. 30 and 31 with examples, please read. 30 and 31, half from half, that is quasi contract. This one, please read guys, come on. 30 and 31, read. Take 1 minute, read. Yes. Chat, huh? Yeah. No, not at all. It can be sent by somebody else. Yeah, that is something else. That we'll see later. What you are saying is something else. That the desire should come from the promisor, not the price. Different. Read guys, come on. With the examples here, 1 and then here, B, C, D, E. Please read. Read the examples, no problem. Even that coolie example, whatever he was he doing for free or not for free? That's why it's called as non-gratuitous act. Non-gratuitous means what? Did not want to do it for free. Got it, guys? Responsibility of the finder of lost goods, liability of the person to whom money paid delivered under mistake or coercion. Mistake, in that it was delivered to him by mistake, right? That's it. Responsibility of finder of lost goods, non-gratuitous act. Then reimbursement to a person paying money due by another, that is a zamindar example. Correct? So you can write law in your own words, only some key words like this non-gratuitous act and all you should see. Then what is this? If you see here, responsibility is same that of a bailee. Bailee-bailer relationship. It's like when I give my two-wheeler for servicing, am I transferring ownership or possession? Possession. So I am the bailer and the service fellow is the bailee. If I am giving my clothes for dry cleaning, I am the bailer, they are the bailee. They have to work on it and give it to me properly and they will get money for it. Similarly, if you are a finder of lost goods, if I found it, though I do not know the owner, it is deemed, what is deemed? It is understood that I am the finder is a bailee. As per law, this section says the moment you touch somebody else's phone, it is as if that fellow only has given you the phone for you to keep it safely. Imagine, superb. Law is telling the moment you find somebody's phone, it is as if the owner himself has given you the phone to keep it safely, which means you have to keep it safely and return it back safely. That is why it says as that of the bailee, as that of the bailee. Right? So this is all the other parts. So next quickly we'll see the other two areas. Offer. Offer is very easy, guys. It's all these chapters and all will go very fast. 10 minutes will finish and take a break. Offer. What do you mean by offer? Signifying to one more person willingness to do or abstain from doing anything. Signifying to another person either willingness to do something or abstain from doing anything. Abstain from doing anything, with a view to obtaining the assent of that other person to such act or abstinence. So basically, if I tell that I'll do something or not do something, it's called as a proposal. Modes of making an offer, either by doing an act or words, oral or written, or through conduct of the parties that I showed you, the conduct, the way they act, that itself, or by abstaining from doing the act. Some important rules are what? It should always create a legal relationship. Terms of the contract must either be certain or capable of being made certain. It should not be vague. What is the other word for vague? Ambiguous. If you remember, ambiguous. Ambi is to, guity is mind. What is not vague? What is absolutely clear? Unambiguous. Ambiguous means confusion. No confusion, unambiguous. So, terms must be absolutely unambiguous. Terms must be absolutely unambiguous. Can I say this? I want to sell my car for 10 lakh rupees to you. If you do not reply within 2 days, I will assume you have said yes. Can I have this dangerous term like that? No. If you don't reply, it is rejected. That I agree. But I cannot say, I cannot force a reply from you. I cannot say, I am offering to sell my, what do you say, car for 10 lakh rupees to you. If you don't reply within 2 days, I am trying to tell you that you have already accepted. No. So it's a very, very important rule. Imagine if that was there, guys. Boys and all, 14th February. I love you. If you don't reply within 1 day, I am coming to marry you. Correct? Dangerous. That's why the lawmaker, he thought about all those things, experience. He said, no, I cannot have these deadly, provisions in the contract law. By saying that, yeah, if you don't reply, it's accepted. No. If you don't reply, what is the general rule? If it is not, if you don't reply, it's rejected actually. If you don't reply, it's rejected. Today somebody will make an offer to you. You will not even bother replying on the phone. You have so many offers you will get. No. Does it mean your silence is acceptance? No. Right? You should think about all that. So it says what? Certain, definite and not vague. See this dialogue. It should not contain a term, the non-compliance of which would amount to acceptance. That's what I'm saying. Non-compliance means what? If you don't reply, all those dialogues you should not say. You should not say that if you do not reply within 2 days, it would amount to acceptance. It should not contain a term, the non-compliance of which would amount to acceptance. It should not contain a term, the non-compliance of which would amount to acceptance. Cannot be there. This is an important line. If agreement, okay, that you leave. Next, offer can be express or implied, specific or general. Express offer, implied offer, we have seen. What is specific offer, general offer, and what is 4, 5, 6? What do you mean by these things? Specific offer, general offer, invitation to offer means what? Invitation to offer means what? If I go and see a menu card, Gobi Manchuri is written there. I have ordered Gobi Manchurian. He will come and tell me, sorry sir, it's not there. Can I sue the hotel? Can I sue the hotel saying, you gave your menu card, that's an offer. I accepted the offer by ordering. Now you are saying it's not there. Can I sue you? Why? Menu card is merely an invitation to offer. You are inviting to order food. I am inviting you to order food. Prospectus. You would have seen prospectus of college and all that, whichever you want to join. State of the art. Full lies they would have written. State of the art is the infrastructure. Then they will say what? AC, everywhere AC. Then what will they say? World famous faculty from T Nagar within bracket. World famous faculty from Nungambakam. Then what else will they tell? Placement and all we will give. Then 360-degree CCTV. CCTV will be there. It will be dangling. Will going round like this with wire. That's why 360-degree. Correct? 360-degree CCTV. It will be broken fully. So all that they will lie. Is that invitation to offer or offer? Invitation to offer. It is just an invitation to offer. Once you accept, once you say, okay, I want this particular, I want to buy this share, or I want to join this college. When you make an application to the college, that is your offer. Then they will release your name, first list, second list, third list. That is the acceptance of the offer. That's it. So it is merely invitation. In that case, what is a general offer? General offer is made to the public at large. It is made to everybody. So all your malls, etc., they have 50% off, star, conditions apply. Can offer have conditions? Of course, offer should have conditions. Offer can be conditional. Offer can be unconditional also. Means what? They'll say flat 50% off. Recently in Lulu Mall, you know Lulu Mall? Lulu Mall in Kerala, what they did was they said, you please come, every item you touch 50% off. So you should have seen the crowd. You just search on YouTube. The crowd was crazy. Crazy crowd in Lulu Mall. That was why? Because of a unconditional general offer. No conditions attached. Please come and buy whatever you want 50% off. Unconditional general offer. So offer is what? Specific offer means what? Only to one person or to a group of people. If I make an offer to you, only to you, that I will leave the class at 6 o'clock. Specific offer or general offer? It is a one person or to a group of people. I will leave the class at, yes or no? I will leave the class at 6 o'clock, yes or no? Yes, sir. Okay. Today 6 o'clock I'll leave you. No problem. So invitation to offer. Invitation to offer is what? It is public at large. That's a general offer. Invitation to offer is initial invitation only, expression of initial intention. What is specific offer? It is made to one person or to a group of people. So you see that these are the examples of invitation to offer. It is there in page number 8. Check it out. Page number 8. Examples of invitation to offer. Price list for goods for sale. Quotations of lowest prices available in anything. An advertisement inviting tenders. An advertisement inviting for you to, pitch in. Tender means your government, tender that they'll put auction, government auction. So if I make an advertisement inviting you to put a tender here, no Tinder and all don't write, tender, correct? So then it will happen. Then railway timetable. Railway timetable is what? Railway timetable, your bus schedule, all these things are merely invitation to offer. Prospectus issued by company, that also is an invitation to offer. Display of goods with price tags attached. So when you go to a mall or when you go to your food bazaar and all that, you will see all these items displayed. All these are merely invitation to offer. With that knowledge, solve this question. Pharmaceutical Society of Great Britain versus Boots Cash Chemist. No need to remember the name. No need to remember the name. Solve. Write down the answer, or think about the answer. Later in 1 minute we'll discuss. Answer. It was held that display of goods was invitation to offer. Selection of goods by customer amounted to? Yes, offer. He is going and picking up the whatever goods and giving to the cashier. Shop owner had the discretion, means his choice, whether to accept the offer or reject the offer, whether to sell the goods or not. Refusal by shop owner amounted to? Rejection of the offer, and therefore no contract concluded. Therefore the customer can sue, cannot sue? Cannot sue. Perfect. Cannot sue the shop owner. Cannot sue the shop owner. This is what it was. So that is the thing. So if you see here, that is Pharmaceutical Society of Great Britain versus Boots Cash Chemists Limited. Okay, so we'll stop here, take a break. After that 4:30 to 6 o'clock only. Bye. See you. All right, guys, can we begin? Yes. So, we saw the Pharmaceutical Society of Great Britain versus Boots Cash Chemicals. That's one thing. Now, one of the most important cases in offer, which one? Which one? Carlyle versus Carbolic Smoke Ball. Carlyle versus Carbolic Smoke Ball Company Limited case law. This was the actual advertisement. In 1803 or something, they released this advertisement, right? So, what was this? There was a company called Carbolic Smoke Ball Company, and they told that if anybody after having our medicine, that is smoke ball, it is like this, if you inhale that medicine, you will not get any cough, cold, asthma, bronchitis, nothing will come. If at all anybody gets it, they will be paid how much? 200 pounds as reward. Was it a general offer or specific offer? General offer. In a general offer, communication of offer is a must. Okay, it is done. In a specific offer also, communication of offer is a must. That is also done. What about communication of acceptance? What about communication of acceptance? That is to be done or not done? Communication of acceptance also, in every offer it is a must. So if I make an offer to you, I need to communicate. Like for example, I will give you a job offer to join my company, let's say. Then will you have to accept the offer? Yes. Otherwise, how will I know? When I say you will accept, should you communicate your acceptance to me? 100% yes. So it is very important for me to communicate the offer also, then communicate the acceptance also. In this case, a lady called Carlyle followed all the conditions which the Carbolic Smoke Ball Company had given. Yet, even after following all the conditions, what happened to her? She got some cold. She went and sued 200 pounds. So, you know what they said? What did they say? They said, you have not communicated the acceptance. You have not communicated the acceptance. Since you have not communicated the acceptance, what is it? It is void. Since you have not communicated the acceptance, contract is void. Who will win the case? Who won the case? Carlyle. Why? In general offer, no need to communicate the acceptance. If you follow the conditions, it is deemed to be accepted. Very good. So if you see there, Carlyle versus Carbolic Smoke Ball, important case. Page number 7. Page number 7. See, company advertised that it would give a reward of 100 rupees, 100 pounds, whatever you leave it, to anyone who contracted influenza after using its smoke ball for a certain period according to printed directions. Mrs. Carlyle purchased it and contracted influenza even after using it as per the printed instructions. She claimed the reward of 100 pounds. The company resisted the claim on the ground that offer was not made to her, and in any case she had not communicated her acceptance. What was held? What was held? In a general offer. In a general offer, following the conditions. Following the conditions of offer is deemed. In a general offer, following the conditions of offer is deemed to be what? Communication of acceptance. Is deemed to be communication of acceptance. In a general offer, following the conditions of offer. In a general offer, following the conditions of offer is deemed to be communication of acceptance. In a general offer, following the conditions of offer is deemed to be communication of acceptance. Following the conditions of offer is deemed to be communication of acceptance is what they said. You have to remember this name, Carlyle versus Carbolic Smoke Ball. You have to remember other name, which one? Balfour versus Balfour. Then Harris versus Nickerson is one more case where there was a auction. When an auction is there, was it an offer or invitation to offer? Invitation to offer. This fellow, what happened? There was an auction happening, let's say in Chennai. That guy came all the way from, let's say, Jammu and Kashmir to Chennai, spent 20,000 rupees and came here for the auction, but the auction got cancelled. So he immediately sued the auction company. And he said, I had accepted your offer and I came all the way. So the auction company said, sir, you didn't accept any offer. There's no offer only. What is it? Invitation. When you come here and do the bidding, then only it is called as an offer. So it went to court, Harris versus Nickerson. Court also said the same thing. What did they say? What did the court say? What did the court say? It is merely an invitation to offer. It is not an offer, merely an invitation to offer, and hence there is no concluded contract. Harris versus Nickerson. Harris versus Nickerson. So in one of the classes I was asking who is a very famous or good caterer here, catering services. Who is a good catering here? So somebody told me that as far as catering, some, what is that name they told me? 1 second, let me see if it's there, otherwise leave it, I'll tell you the example. Sheila Aunty Caterers, correct. In Tamil Nadu, Sheila Aunty Caterers will come. Right. So, yes, so let us see, okay, this is not there here, it was written somewhere else. Cool. So, the catering here is done by, let's say, some random, Sheila Aunty, yes. So, catering is done, if you see, 1 second, yeah. Catering. Now, the thing is now, there was one case where, let's say, you go to a caterer, yes, Sheila Aunty Caterers. You want Sheila Aunty catering only. Nobody can come and cook, correct? You go to them and say, I want 500 people are coming home. I want 500, what do you say, meals. So, you will place the order and all those things. You will place the order, all that thing will happen, correct? So, she was not there that day, but you have placed the order with their people, all that is okay. Now, that day, 2 days later, Sheila Aunty has sold her entire catering business to Onion, okay. They have sold the entire catering business to Onion, what? Onion Caterers. See, like noodles will come here, Onion Caterers. Correct? That is Onion Caterers. Correct? Catering, that's the logo, by the way, yes. So, it is what? Onion Caterers. So, he will be sold, so they will sell it to this fellow. Onion Caterers on the designated day, 10 days later, Onion Caterers come to you and say, sir, take, I have given 500, thing. This fellow says, no, I want Sheila Aunty only. Yes, alright, Onion Caterers and all won't happen. Alright, I want only what? One auntie, that is Sheila Aunty. Correct? How the hell, when I have made an offer to Sheila Aunty, how the hell can you come and say that you have accepted the offer? Offerer was what? You. And who is the offeree? Yeah. Who has accepted the offer? Onion. So, is this valid or void? Void. So, the rule of specific offer is what? Offer must be accepted by the offeree only, not any other person. Offer must be accepted by offeree. And who is the offeree here? Sheila Aunty. So, Onion cannot do anything. So, he has to go back. No choice. This fellow said that you are breaching the contract. There was no contract only. I never offered it to you. It was offered to somebody else. This is the landmark judgment which you have to remember the name. Which one? Bolton versus Jones. Check it out. Page number 8. Bolton versus Jones. Bolton versus Jones. Bolton versus Jones. Here J is equal to U. Z is Sheila auntie. Read it like that, you'll understand. J is you, Z is Sheila auntie, and B is onion. B is onion. Read. Read and tell me the answer. Read and fill up the blanks. Read. In this case, it was leather. It was held. What was held? Offer was made to onion or not made to B? Not made to onion. Offer was not made to onion. B. So B, that is onion, had right to accept, no right. No right to accept the offer made by J. Therefore, there was dash, contract, no contract. No contract. There was no contract between J and B. There was no contract between J and B. Simple. No contract between J and B. Very simple. Correct? So, very simple. All these cases, Harvey versus Facey and all not needed. Leave it. Not needed. Yes, this much is enough. All that is there. Now, moving on. Invitation to offer, all that done. Now, what is a cross offer? Cross offer is most illogical. Earlier, there used to be telegram system. Now it is irrelevant. When A makes an offer to B, saying that I will buy your, car for 1 lakh rupees. At the same time, B also makes an offer to A. Without knowing of A's offer, he'll also send a telegram saying, I will sell my car for 1 lakh. Early in the olden days, 1800s, all offers etc. used to happen via letters and telegrams. So that time it was valid. I made an offer to you, you also made an offer to me. I didn't know about your offer, you didn't know about my offer. Identical offers is called as cross offer. Identical offer is called cross offer. So that is anyway not there now. But what is definitely there is this one, counter offer. Counter offer. Counter offer, the best possible person is your mother in counter offer. So when vegetable vendor will be sitting, correct, tomato will be selling. So 1 kg tomato he'll tell 60 rupees. Your mom no scene. First only 30 rupees. Correct? First only 30. Correct? So basically your vegetable vendor will first say 60. Your mom says no 30. Then that fellow will say, no, madam, please, this prices have increased, all those things. So vegetable vendor will be sitting here, obviously. He'll be with a sad face sitting and, selling this vegetables here. Then he'll be telling, no, madam, please, I had to go from so long, it was so much. So your mom also will tell, I also have struggled a lot in life, correct? I have one stupid child who's doing CA, right? So that is so much suffering every day, correct? Yes. So please, you also help out. 30 rupees, less than that, not possible. Then this fellow will tell one full sob story that how his life was and all that. He'll say, make it 50. Sure, mother will say, sure, make it 28 then, correct? Simple, yes, that is what your mother will tell, 58. Then suddenly again he'll tell, no, see my children, instead of going to school, they're sitting and selling tomatoes. The moment she tell about children, 2 children will pop out from behind like this. Correct? So from behind they will pop out. And they'll say, yes, see, because of that it is very difficult for me. Please, 50, at least, okay, last price will make it 48 rupees. Your mother says, okay, 100%, 27 rupees. They'll fix on that. Then your mom, what do you say? This fellow will tell about his love story. Yeah, then how, it is, you watched Kadal movie. Old movie one, Kadal. Like that he'll tell one story. Correct? He'll tell one story that what happened to me. My girlfriend left me and she married off some rich guy. So I was become like this, I became a vegetable vendor. All that he'll tell. So your mom now will feel little emotional because she has your dad. So no tension. She has become little emotional. When she thinks of you, she'll feel like reducing the price. But when she thinks of your obviously dad, she'll feel nice. So he says, madam, last price 45. So your mom says, okay, fine, let's not make 25 and all, let's make it 35 and close. Now, this is exactly counter offer. First offer was made by this guy. Your mother accepted the offer with conditions or what? Is there any word called conditional? Is there any phrase called conditional acceptance? Nothing. There is no concept called conditional acceptance. Offer can be conditional. Acceptance can never be conditional. If acceptance becomes conditional, it will become a counter offer. It will become a counter offer. So if I say 30, I am making a counter offer to 60. What happens to the original offer? Gone. Then when this fellow is making 50, he is making a counter offer to 30. 30 is gone. Then there are 28 will be a counter offer against 50. 48 will be a counter offer against 28. 27 will be a counter offer against 48. 45 will be a counter offer towards 27. And 35 is a counter offer against 45. And this, when the shopkeeper agrees, it is the shopkeeper is agreeing to your mother's new offer of 35, which eventually actually is a counter offer. Counter offer is basically changing the conditions of the original offer. There is nothing called conditional acceptance. Now, when your mother makes a counter offer, what happens to original offer? Lapse. What's happened to this original offer? Lapse. All the offers will lapse and the final counter offer will stand. Lapse means what? It will no longer exist. Lapse means no longer exist. So in cross offer also, offer will lapse. In counter offer also, offer will lapse. Then offer, the next part is lapse of the offer. As I told you, cross offer and counter offer will lapse. If I say offer is valid for 6 months, 8 months later, can you go and ask for the offer? No. Why? Acceptance should be made within stipulated time. The offer says that you will get 50% off only if you purchase 5,000 rupees worth of goods. You will purchase 500 rupees worth of goods. Can you claim the offer? No. Acceptance, that is what? Non-fulfillment of conditions by the acceptor. You made an offer to somebody and then before even that contract could go ahead, that person died or insanity happened. Before even that person could accept, what happens to the offer? Lapse. Then you had told that person you need to accept only via email. Other than email, I will not even accept it. Acceptance should be sent via email. You send the acceptance, then we'll see. That fellow did not send via email, he did not send only. What will happen? Offer will lapse. Some law also changes. As of today, everything was fine, but tomorrow there is a change in law. For example, you had made an offer to purchase 1,000 bags of plastic flex. Tomorrow, government banned flex. And the flex banner only they banned. Now what happens? Offer will be lapsed. Then what is the difference between rejection and revocation? What is the difference between revocation and rejection? Cancellation. Completely not accepting. Then half accepting is there if completely not accepting. What do you think? What is revocation? What is rejection? Offerer. Revocation is offerer. Okay. So on February 14th, Onion will go to propose. Correct? This is Onion. Correct? Correct. Sorry, Ambi. Everyone same only, Ambi, Onion, everything. Yeah. So Ambi will go what? With one book he will take, not even letter. Correct? One book with full letter he has written everything and he will take one rose. Correct? Assume this is rose, guys. Don't ask question. This is rose. One rose he will take to what? Yes. To propose. To whom? Yeah, Nandi. Yeah, I'll go propose to, and now on spiral binding we should write spiral binding. Yes. Yeah. So they will go and she's very happy to see. So she's seeing what is fellow doing and all that. Yes. So is going to propose. The next time next moment that he realizes that actually the what Nandini, what does she do? He just hears a sound and then he sees his cheek has become red and it is paining, which means what? Oh, he got slapped. So next moment he realizes that he is running, and when he sees beside him there's one chappal also flying. Alright, so chappal also is flying, 2 chappals. So what has happened now? It is rejection. It is rejection. Correct? Then suddenly Ambi will become what? Remo. Remo. Ambi will become Remo. Color hair. Correct? Yes. Color hair. Ambi will become Remo. Correct? Right. And he will go and say, you Nandi. Yeah. Yes. Like I love about to tell, but from behind suddenly he will see, from that Sarpata Parambarai, hero will come. Alright, yes. So he will be standing. See, this is full, like Lokesh Cinematic Universe. This is PJU. Correct. Yes. Correct. From here behind he'll be there. Correct. He'll be Superman. Okay, this little bit. Yeah. Okay, fine. So he'll have what? He'll have all 6-pack, 10 packs. Here side also he'll have extra. Okay. So yes. So he will be there. He will be. What's his name? Kabilan. Kabila will be there. Kabilan will be there. So, yes. So, this, he will be there waiting. Correct? This fellow is Nandini's brother. See, full connection. This fellow is what? Nandini's brother. So, this Remo will see, and the moment he sees, coolly will do right about turn. Correct? Right about turn, and he will throw this flower in the air and all. Now, what is this? Revocation. Now you tell me the difference. What is rejection? What is revocation? Rejection is done by offerer or offeree? Offeree does the rejection. Offeree, will she assent or dissent? Spelling? D-I-S-S-E-N-T. Dissent. What is this dissent? D-E-S-C-E-N-T. Going down. And what is this? Descent. No, descent. And all these three in English, when it sounds the same, what is it called? Homophone. Okay, little bit mana maryada you have saved of mine. Thank you. Yes. Homophone. Yes. You have descent, descent and descent. Yes. So if you see what? That is rejection. This is called rejection of offer. What is that? Offeree. Offeree is cancelling the offer. That is called rejection. What is revocation then? Yes, the offerer himself, if he withdraws the offer, offerer himself withdraws the offer, that is called revocation. Offerer himself withdraws the offer, it is called revocation. Yes, that is called revocation of offer. That's also easy. Revocation of offer and rejection of offer, both will result in lapse of the offer. Both will result in lapse of the offer. Offer will be cancelled. That's it. So that is revocation and rejection. So these are all the various concepts in offer. Moving on to acceptance, this is very, very easy again. Moving on to acceptance is very easy. Now, when you basically, acceptance means consent. That other fellow should say yes to whatever you are telling. The same dialogue here also. It should say yes to whatever you are saying. Now, after this class, you will go and you want to have something. You will go to one, hotel where they'll have some stuff. What do you want to eat? Tell me. You will want to have charts. Okay, you want to have charts. So you will tell him, give me one pani puri, one masal puri and bhel puri. So each one, let's say 30 rupees. So 90 rupees you will say. You will take the coupons and now you are going towards the person who is making it and you are eating. When you are eating, this cashier, first he will smile normally, then he will smile big, then one big smile he will give you. You'll be like, what is wrong with you? Why are you smiling? You will go and tell, what's the problem, sir? What's the issue? What is the issue that you are facing? Yeah. So why are you smiling like that? He will say, look behind. Behind him there will be one board, one black board where they would have written today's offer, bhel puri plus pani puri plus masal puri at just 50 rupees, all put together. You have paid 90 rupees and come and you are eating. Now you will say, sir, come on, it's right there, give me 40 rupees back. I have ordered the same thing, give me 40 rupees back. Can you sue him? No. Why? Why? He did not know about the offer. When you did not know about the offer, how can you sue? It's like telling you ordered something from Swiggy and later you paid 500 rupees on Swiggy and later you realize there was a 50% coupon code which you forgot to add because you saw it later. Can you call up Swiggy and ask for 50% refund? No way. You have to add the coupon code. Coupon code, if you didn't know about the coupon code, how can you say, sorry, I forgot? No. So this fellow will smile and tell, boss, if you do not even know about the offer, how can you say that you accepted the offer? Acceptance should come from the offer. Acceptance should arise from the offer. And instead of arise, what's a better word? That is party word. Party. Party is which party? That lady who died. Queen Elizabeth party. She died. No, we should use language from her country. What is the better way of telling arise? Emanate. Emanate is a better way of telling. Acceptance emanates from an offer. Emanate means arise. Acceptance emanates from offer. Don't do overthinking and tell the sun emanates from the east. All that don't tell. It is arise, not rise. Correct? So acceptance, offer. So acceptance should emanate from an offer. I am reading page number 8. Acceptance should emanate from an offer. Which is the landmark case law? Lalman Shukla versus Gauri Dutt. In Lalman Shukla versus Gauri Dutt, what happened? Yeah, the nephew got lost. He asked him to go fetch the nephew. In the meantime, he gave a reward also. Whoever gets the nephew, 10,000. Servant did not see the offer. He brought back the nephew. Later, when he was going home, he saw the reward. He came back and claimed. Will he get? Nothing he will get. So, read the case law here. It is there in page number 9. Lalman Shukla versus Gauri Dutt, important case. Case number 1 that you have to remember. Balfour, the decision also you have to remember. What is the decision? Social obligation. So in another page it is better if you could, at home, write down the important case laws along with the decision. There will be around 15 to 20 in your law that you have to remember. Case law with the decision. First one is Balfour versus Balfour, social obligation, legal law. Second one, Carlyle versus Carbolic smoke ball. Gist of the decision is what? In a general offer, there is no need to communicate the acceptance. Following the conditions is deemed to be communication of acceptance. Next, Bolton versus Jones. In a specific offer, only the offeree has to accept the offer and nobody else. Next, Harris versus Nickerson. Fine, if you know that, no need. Next, Lalman Shukla versus Gauri Dutt. Acceptance will emanate from an offer. Like that, if you write down, it becomes very easy for you for one day before the exam revision. So that is regarding this. Then what else is there? It can be made only by the offeree. What? Acceptance should be made only by the offeree. We know Bolton versus Jones. Should be made before the lapse of the offer, obviously. If you perform all the conditions of the offer, it will amount to acceptance. In which case? In case of general offer. So here I can write down in case of general offer. Acceptance should be for the exact terms of the offer, obviously. Acceptance must be unconditional. Any variation becomes counter offer. Any variation becomes counter offer. The moment you vary any terms and conditions, it becomes counter offer. Acceptance should be communicated, especially in which one? A specific offer, it has to be communicated. In a general offer, no need to communicate. Follow the conditions deemed to be communicated. Silence in any case will never equal to acceptance. But there are exceptions which we'll see later. Silence will not equal to acceptance. So I cannot say I am making an offer to you. If you don't reply within 2 days, I will deem it to be accepted. No. Offer cannot contain a term, the non-compliance of which will amount to acceptance. It must be as per the prescribed mode. All that is fine. So this is irrelevant for our this thing. No problem. Leave it. All this is fine. For our crash course, not needed. Whatever is very, very important, everything I will cover. Some stupid cases not needed, but this is important. Powell versus Lee. Powell versus Lee is important. Now I am let's say I applied to your school. You are running a school. You are one of the trustees in the school. I applied to your school to be appointed as a headmaster. So I'll apply it and then I'll call you and tell, bro, what happened? You'll say, no, we have a committee, we are deciding, don't worry. But you are one of the top candidates, no problem. So I am very worried. I'm again calling you, what happened? Then suddenly you will call me and say, boss, the committee just met. Congratulations. Anyway, you'll get one confirmation tomorrow. But yes, the committee just met. You are the principal. I am full happy. I gave full party that day. Next day, I wear suit and all and go to that particular school. Open the principal chamber. Somebody else is sitting. Can I sue the school? Why? Because offer was communicated to the school. Who had to accept it? School. Means the official committee had to send me the official acceptance. Some one person in the committee will not make the entire committee. So this was an important case, Powell versus Lee. You have to remember the name. Read the cases, please. Read the case. I'll give you 1 minute. Please read it. Powell versus Lee. Read it. Important. Self-explanatory, but read it, please. Yes, got it. Therefore, A has no cause of action against the school, is what they say. Cause of action against the school. What about contracts over phone? Can I make a contract over phone? Yes, but later the law says, in the sense generally, you should make it in writing. So from today, if any person makes any contract over the phone, do not accept. What you will say? Sir, whatever we have discussed, I'll send a quick mail, just acknowledge it. Correct? Proof. Because tomorrow he will say, I never told you. And you cannot do any voice recording without their consent. Without their consent, you cannot make any voice recording. All voice recordings without consent will not be admissible in court. So it's useless anyway. Correct? Nothing will be admissible in court. You have to take consent. That's why, your CCTV camera also, can it be admitted in court? Yes. That's why they will put everywhere, no, this area is under CCTV surveillance. That is showing that they are taking consent. Here they may not have put, is there a CCTV here? No, not there only. Anyway, so if it's there, anywhere, one place in the office, they would have written, the entire area is under CCTV surveillance, is what they say. That is like communicating to you that, boss, it is under CCTV. So do not act funny, it is under CCTV, is what they say. All these things you are done. Now this part we'll do later, it's slightly relevant. Later we'll do it for sure, no problem. As far as other things are concerned, here this case law not very important for the exam, not needed. This third one, B sent a draft agreement. I'm reading page number 10, last part. B sent a draft agreement relating to supply of coal and coke. Coke here means not Coca-Cola or not Narcos Coke, not drugs. This coke is what? It's a like coal and charcoal and this other coke, which is a mineral, to manager of a railway company for his acceptance. The manager wrote approved on the same and put the draft in his table drawer, intending to send it to the company's solicitors for a formal contract. He forgot about it. Can you approve the acceptance and not communicate? No. It has to be communicated. Not communicated, not a valid acceptance. It can never be a valid acceptance. So general rule, offer must be valid only when it is communicated. Acceptance also will be valid only if it is communicated, especially if it's a specific offer. In general offer, no need of communication. What will you do? Only follow the conditions of the offer, that's all. Follow the conditions of the offer, then it is done. So let us say I have a stable where I will rear horses. Horses are there. Horse, you know. So I have a stable and I sell horses, assume. You come to me, you are my uncle. You come to me and say, boss, I want this, this particular horse I want. Please keep it aside. You just send me a WhatsApp text that I want this particular horse, please keep it aside, I want it when I come next. I will not reply to my uncle. I will see the message but not reply. He made an offer. What offer? Please keep the horse, that one horse I want, 20, whatever amount, 20 lakh rupees is what you are quoting, I will pay that, I don't want discount also, I want that horse. Please keep it aside. Now I have read the message, not replied to my uncle, but I tell my worker, hey, that my uncle is come, I forgot to reply actually, but I tell my servant, boss, that fellow is coming, my uncle is coming, just keep that horse aside, he will buy it later. My servant by mistake has sold off that horse to somebody. Money I only have, but he sold off the horse, horse is gone. My uncle comes. My uncle comes and says, where is the horse? Now my uncle sues me. Am I liable? My servant is liable or uncle only is liable? What do you think? He will also tell that if I do not, basically he will send a message, in a message only would have told, if you don't reply within 2 days, then I will deem that you are sold the horse to me. Is that valid? No. It cannot contain a term, the non-compliance of which would amount to acceptance. Assume he had not told that also. Now who is liable? Uncle. Why? Because I have never communicated the acceptance. I may have told my servant to keep it aside, but I should have communicated, no. Without communication of acceptance, not possible. Feldhaus versus Bindley. No need to remember the name, but please see the case law, this one. Feldhaus versus Bindley, please read. F is the uncle, nephew is there. His name is Bindley, please read. F. Feldhaus is the uncle. Right. So, what does it say? I shall consider the horse is mine. Nephew did not reply, but he told an auctioneer who was selling his horse not to sell that particular horse, as he had sold it to his uncle. By mistake, the auctioneer sold it. F sued the auctioneer for conversion. Conversion means now I want that horse back. That's what he told. Held, the uncle could not succeed as his nephew had not communicated the acceptance, and hence there was no contract. Hence there was no contract as such. Now this chapter is very, I have to do this still. This is pending. I will do it, don't worry. This part I will do, not to worry. That is pending still. Now consideration. Consideration means what, guys? Quid pro quo. In simple words, consideration means what? Something in return. Definition is like this: when at the desire of the promiser, promisee or any other person has done or abstained from doing or does or abstains or promises to do, promises to abstain. Such act, abstinence, promise is called consideration. Now, because it says has done or does, promises to do, this is past, present, future. It can be past, present and future. Undoubtedly, it can be past, present and future. Such act slash abstinence slash promise is equal to consideration. And general rule is what? No consideration, no contract. No consideration, no contract. Consideration must move at the desire of the promisor. So, for example, there was a district commissioner. There was a district commissioner once. He told, DC of Chennai, let's say, he told his supervisor, he said, go to this, what is this market called? Coimbatore. Go to this Coimbatore market and fully clean it, boss. It's not nice, just clean everything, make the shops, renovate the shops and come. Make it absolutely spick and span. So DC ordered his supervisor to go and completely renovate Coimbatore market. Now one of the shopkeepers who was there, Mr. H, shopkeeper, he became very happy that his shop was getting renovated. He made a promise to the supervisor saying that he will pay 2% of that year's profits to him because he is actually renovating the entire shop. 1 year, and the consideration according to him was you are giving the renovation. Now, after this renovation was done, supervisor came to the shopkeeper and said, boss, give me my 2% profits. Shopkeeper said, who are you? I don't know. What are you saying? Which amount? What amount? In that full Josh initially he told. Later now he is recanting his story. Now this fellow went and sued in the court of law. Who will win the case? Shopkeeper or supervisor? Shopkeeper. Why? Answer is correct. Logic. Answer is correct. Logic. Consideration. Consideration must move at the desire of the promisor. Who is the promisor here? Who is the promisor? Shopkeeper. Shopkeeper has promised to pay 2% of the profits. The consideration of renovation, did it move at the desire of the shopkeeper? Did shopkeeper tell renovate the market? No. It was told by a district commissioner. Whether you are getting 2% profits or not, renovation anyway would have been done. Renovation anyway would have been done. So tell me, is this actually consideration? No. The court said that this remuneration is not at all consideration. Remuneration is not at all considered because it did not move at the desire of the promisor. So that is the important case. Durga Prasad versus Baldeo. Durga Prasad versus Baldeo. So read and tell me what would you write. Think about it, then tell me. Read. Read the case, please. What do you think? Deconstructed market. What was held? D sued the shopkeeper. Held. What do you think? How will you write it? D sued the shopkeeper, held. What do you think? Shopkeeper, what? Is he bound to pay? Need not pay. Held, or rather the renovation. Renovation is not consideration. Why? Held renovation. Renovation is not consideration. Renovation is not consideration as it did not, as it what? Did not move at the desire of promiser. That is who? Shopkeeper. As it did not move at the desire of the shopkeeper, but it moved at the desire of somebody else. But it moved at the desire of somebody else. Moved at the desire of somebody else. Somebody else can fix the consideration. Your doubt. Your doubt. Correct? Somebody else can fix the consideration. That's okay. I can ask somebody else to fix the consideration. That's okay. But here, did I ask you to renovate? No. When I didn't ask you to renovate, so you cannot say that that is consideration. I should have asked you to renovate. In this case, I have not asked you to renovate at all. Hence, that is not called consideration. Renovation is not consideration as it did not move at the desire of the promiser. That is shopkeeper. But it moved at the desire of somebody else. Somebody else. It can be done by the promisee himself or any other person. That's fine. You come back here. Yes, it must move at the desire of the promisee. That is point number one. Second one, it can be done by the promisee himself or by any other person. It can move from a stranger, benefit a stranger. I'll explain this. What do you mean by it can move from a stranger, benefit a stranger? Very, very simple. There was one, old lady. There was one old lady. Yes, one old lady was there. She's almost dead. All wrinkles everywhere. Correct. So almost dead she was. Sir, what? Sir, chicken pox you're drawing? No, wrinkles. Okay. She was dead almost, right? So now she wanted to give the, let's say her name was Mariamma. Yes, Mariamma, what? Gave the, daughter was there. Daughter was one devil. Daughter was a real devil. She was a vamp. Correct? She was a vamp. So like this she was always, in that she had 3 teeth and all, right? She was a vamp. 2 horns also she had, right? So she was what? Yes, this is the daughter. Right. What's the name? Sheila, you want? Right, Sheila, no problem. Yes. So, Mariamma, correct? Mariamma's daughter is Sheila, correct? Sheila, what did she say? Sheila said, I want your property. You give your property. Only then I will see what can be done. Now, Mariamma had a younger sister. This Mariamma was, let's say, 77. Younger sister was 75. What's their name? Sheena, Mariamma's sister. What's her name? Suryamma. Okay, we'll name that only. Mariamma, Suryamma. Right? She is also almost dead. Wrinkle extra she has here. Yes. So now this Mariamma this Sheila wants what? Property of Mariamma. Mariamma says, I will definitely give you the property. Don't draw all this in the exam, guys. It's just for making you understand, I'm telling. Don't draw all this. Mariamma, Sheila, Suryamma. Yes. So, property she wanted. Property she wanted. So, Mariamma says, do one thing. I will give you the property, 100%. Only if you enter into a contract with your auntie. Where, Suryamma, where you will tell, I will pay you a monthly, what do you say? Amount like this pension. I will pay you pension, some 10,000 rupees per month I will pay. So the contract was only between Sheila and Suryamma. Contract was between Sheila and Suryamma. Fine. So, Miss, what do you say? What? That, okay, fine. So, property was given to Sheila based on this condition. Who were the parties to the contract? Only Sheila and Suryamma were the parties to the contract. Fair enough. Every month Sheila was giving 10,000 rupees. Fair enough. One day Mariamma became late Mariamma. Right? Yes. She died. Correct? Late Mariamma she became. After she became late Mariamma, what happened? Sheila stopped paying this 10,000. Correct? So Suryamma went to the court saying that, see, there was already a contract where she had to pay me 10,000 till I die. Correct? So Sheila says, very simple, for everything there has to be something in return. I made a promise 10,000 rupees. What am I getting in return from you? Nothing. Correct? That property was Mariamma. She was not even party to the contract. Contract is between me and you. So if Mariamma also was included in the contract, then she couldn't have told anything. But Sheila very careful, very, very smartly excluded Mariamma from the contract. It was only between Sheila and Suryamma. So she went to the court and said, I am promising you 10,000. You have to give me something in return. You are not giving me anything. How can you say there is a contract? Whatever I have paid you all these years also return. Counter suit. Correct? Not only now. You are telling you have to pay. I will not pay 1 rupee also. Whatever I have paid you before, please pay me back. Everything you pay me back. Now, who will win the case? Why? Consideration, if you see the definition, it says consideration, if you see, when at the desire of the promiser, the promisee or any other person has done, So in this case, Sheila has promised to pay 10,000, that's okay. Promisee is Suryamma. Has Suryamma given something? No. But any other person has given. Any other person means a person who is not party to the contract. So, this case law, Chinnaya versus Ramaya. Chinnaya versus Ramaya case law clearly said that there can be a stranger to a consideration. Consideration can flow from a third party. Consideration can flow from a third party. That was the case. Check it out. These two. Case number B and C together. It can be done by the promisee himself or some other person. It can be done by promisee himself or any other person. And next what? It may be from a stranger or benefit a stranger. It can be a stranger or benefit a stranger. Chinnaya versus Ramaya. Consideration may move from a stranger and also benefit a stranger. Correct? It can come from a stranger also, or it can benefit a stranger. For example, if you guys clear CA and then come back to KSA and say, sir, you'll tell Sara sir, I want to, pay for a student who doesn't have money. I want to pay for his education. Now, who is the contract being entered into? You and KS Academy, but the benefit of the torture is going to whom? Some other random person. So consideration can also go to a third party. Consideration can also go to a third party. Can consideration come from a third party like this Chinnaya Ramaya? Yes. Consideration can also go to a third party. This is the case. You have to remember which one. Durga Prasad versus Baldeyo. You have to remember which one. Chinnaya versus Ramaya. These are the other two cases you have to remember. Consideration may be past, present, future and all those things. No problem. It can be past, present and future. Then, consideration may be anything, that's okay. Also, consideration must be real and not illusory. Illusory means what? Cannot be imaginary at all. Consideration cannot be imaginary. It must be real. It is not at all valid if it is physically impossible to do so. Like I told you that, physically it's not possible only to say that I will ensure that you will clear CA in 2 months. Not possible. Legally not permissible. All, leaking of the examination paper or getting you drugs, all these things are what? Legally not permissible. So any money that you take would be void. Uncertain. Uncertain also, it shouldn't be uncertain. Payment of a pre-existing obligation. You are handling your client after you clear the CA, you are a practicing chartered accountant, your client has come to you, you are fighting his case in the High Court. He will tell you, boss, your fees is 10 lakhs, I will pay you 5 lakhs more if you win the case for me. I promise to pay you 5 lakhs more if you win the case for me. You now put extra efforts and somehow win the case in the hope that you will get 10 plus 5, 15 lakhs. That fellow will give you 10 lakh rupees. Remaining 5 lakh he will not give. What to do? Can you sue him? It will go to the court. Court will say, sir, 10 lakhs they are already paying you. Why are they paying you 10 lakhs? You will say, sir, for winning the case. Obviously, they are paying you 10 lakhs not to stand there, to win the case. You have to work and win the case. Then that extra 5 lakhs, isn't it a waste? Your fees was not revised. What did he say? He said he will give you extra 5 lakhs if you win the case. 10 lakhs also was to win the case only, no? So the court said that extra 5 lakhs is useless because you are anyway supposed to win the case with 10 lakhs only. Extra 5 lakhs is his choice. Is it legally enforceable? No. It is his choice. He may give, he may not give. It's purely his choice. His promise to pay you extra has got nothing to do with the contract because you are anyway getting paid 10 lakh rupees to win the case. Similarly, if your friend is stuck in some legal case and your friend is stuck in some divorce case and you are there to sort of help your friend out. Court case is going on, you have to go and now stand witness against his ex-wife. Correct? So they will call and they'll say, your friend will call and say, bro, I will send you flight tickets. I will ensure that you will come there. I will also give you 1 lakh rupees extra. Please come and tell the truth. Correct? Please come and tell the truth. You will say, okay, no problem. So he will definitely send you a car, give you flight tickets, book the accommodation there. You will go tell the truth also. You will get the divorce and then you will call up and say, where is my 1 lakh rupees? He will say, what 1 lakh rupees? Then you will go sue him. Is it possible? No. When the court has summoned you, you are supposed to go. No choice. No extra payment will be done for that. This is called pre-existing obligation. When you have a pre-existing obligation, how the hell can you expect more to the not possible? So if you see, where a witness who has received summons to appear at a trial, promise to pay him anything beyond his expenses is void for want of consideration. Means there is no consideration. Because the witness was bound to appear and he was bound to give evidence. Because the witness was bound to appear before the court and he was bound to give evidence. Collins versus Godfrey. Collins versus Godfrey. No need to remember the name, it's okay. These are all the case. And can I sell my house to you for 1 rupee? Is it valid? No. I am only telling, I want to sell my house for 1 rupee. Valid? Yes. Can you later say it was invalid? Or in consideration, is there any definition saying consideration must be adequate? No. Consideration must be adequate, it doesn't say. It says, nowhere it says, you see, when at the desire of the promisor, the promisor or any other person has done, blah, 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 such act, abstinence or promise, if adequate, is called consideration. Nowhere it says. Such act, abstinence, promise, if adequate, is consideration. Nobody says. Should consideration be adequate? No. So the important rule here, see, consideration need not be adequate. Consideration need not be adequate. Milkha Singh made a movie, rather based on his movie Bhag Milkha Bhag, that is based on Milkha Singh's life. He made a movie. This guy, what's his name? Farhan Akhtar was the hero, right? They made a movie, and obviously you can't just make a movie like that. You have to buy the rights of the film. You have to buy his rights of making the movie. Dhoni also sold his movie for 70 crores, and then he also took a share of profit. He was smart. Milkha Singh said, see, I don't want any of this money and all, but do one thing, I'm selling my rights of my movie for 1 rupee, just 1 rupee. And once the movie makes some profit, whatever you feel like, please donate it to my orphanage. He runs an orphanage, so he told, if you feel like, no force, if you feel like, donate some money to my orphanage. But for this movie, I'm just gonna charge you 1 rupee. So Milkha Singh just charged 1 rupee for his movie Bhag Milkha Bhag. Now, is the consideration adequate? No. But is it a valid contract? Yes, 100% valid contract. Will courts interfere if the consideration is not adequate? No. But if Milkha Singh had gone to the court and told consideration is not adequate, then would the courts interfere? Courts will ask, you only told, no, you only agreed. Then the Milkha Singh will say, consent was there, but it was not free consent. They forced me to sell it for 1 rupee. So, courts will not interfere. When will courts interfere? Courts will interfere only when there is absence of free consent. When there is absence of free consent. In a voidable contract, it is exercisable at the option of the victim or option of the aggressor. Victim always. Like Sheila auntie can go, in that first case, can go to the police station and lodge a complaint. Can the thief go and lodge a complaint? Sir, fake jewelry I stolen, sir. I thought it was real. It's actually fake jewelry. No. Correct? So it has to be by the victim and not the aggressor. So in this case, who is the victim? Milkha Singh. Milkha Singh can go to the court and say, or police station and say, or court basically, through the police station, and go to the court and say, see, this is invalid. The contract is voidable. Why? Free consent was not there. Contract is voidable because free consent was not there. This was the scene. Okay, that's all. So if you see, all these things are the rules of consideration. Then if you see here, if you see, this is also very, very, very important. So again, quick revision, guys. If you come to the charts material, just let's revise only this part from the charts. There you go, consideration. And then we'll come to the exceptions, this part. Page number 35, actually in 35th page number it will come. Page number is not written, but if you scroll down to 35, you will get this. So consideration means what? Something in return. No consideration, no contract. That's the general rule. No consideration, no contract. Then you see here, consideration must move at the desire of the promisor. It can be done by the promisee himself or by any other person. Consideration may move from a stranger and also benefit a stranger. May move from a stranger and also benefit a stranger. Consideration may be past, present or future. English law does not recognize any past consideration. Indian law recognizes everything. Consideration must be real and not illusory. It is not valid if it is physically impossible, legally not permissible, and it must be legal. Consideration need not be adequate. Consideration need not be adequate is what they say. General rule, exceptions now. General rule is what? No consideration, no contract. The normal rule, no consideration, no contract. But these are the exceptions. Important 4-mark question. What are the exceptions to no consideration, no contract? What are the exceptions to no consideration, no contract? WB2P3C. WB2P3C. W. Written and registered agreement arising out of love and affection. B. bailment. P, past voluntary services. One more P, promise to pay time barred debt. 3C, one is completed gift, contract of agency, then charity. Completed gift, contract of agency, then you have charity. These are all the various exceptions, one by one. I told you an example, right? I told you an example of this Balfour versus Balfour. Balfour versus Balfour. General rule what? No consideration, no contract. So, husband and wife in Balfour versus Balfour. Husband now entered into a contract to pay 10,000 rupees. In Balfour versus Balfour, he just told. That's all. He didn't do anything, he just told. It was an oral agreement. If this contract was written and registered, and then the husband did not pay the wife, if the wife has sued the husband, who will win the case? Why will wife win? Because it was written and registered. For husband there is no consideration, but still it is valid. Why? Because it was written and registered. 100% wrong answer. Superbly, 100% wrong. What is the exception? See, written and registered agreement arising out of. Where is love and affection here between husband and wife in this example? No love and affection. There was friction. Correct? Love and affection not there. Hence, even if Balfour versus Balfour, even if it was written and registered agreement, valid or void? Still void. Who will win the case? Husband. Correct? Husband will win the case. Very, very interesting, because love and affection are not there. Love and affection is missing. Related to that case only, there is already a case. Which case? Come to the case law sheet. Sorry, here. There you go. Raj Lakshmi versus Bhutnath. Husband thought, Raj Luki, sorry, this is a spelling mistake. Raj Luki, Lukhy. Raj Luki versus Bhutnath. Raj Luki versus Bhutnath. Husband thought he can be like a king, but he ended up becoming a ghost. Correct? Yes. Raj Lakshmi versus Bhutnath. Read. A Hindu husband, by a registered document, after referring to quarrels and disagreements between himself and his wife, promised to pay his wife a sum for her maintenance and separate residence. Held what? Contract is void because there is no legal obligation. Even though it was written and registered, it was not out of natural love and affection. Even though it was written and registered, it was not out of natural love and affection. That's the reason. Now, slightly change. I told you, your father promised to pay you 1 lakh rupees or gift you an actual car after you clear CA foundation. If that agreement was written and registered, then valid. So you can sue your dad. Why? Because that was written, registered, arising purely out of love and affection. General rule, no consideration, no contract. What is the exception? It should be written, registered. Arising out of natural love and affection, only then it will be valid. If it is simply written and registered, not be valid. It should be arise out of natural love and affection. So first one is what? Written and registered agreements arising out of love and affection between parties standing in near relation. Second, past voluntary service. So I was burning in one fire here. So, what's your name? Kumar. So Kumar became Superman and he saved me. Correct? Yes. So this is Kumar here. So he became what? Superman. So Superman will draw. Correct? Kumar. He is carrying me. Correct? How he carried, God only knows. I am here full dead. Full dead. So he is carrying me. So Kumar is Superman. No. So let's see. Kumar. This is Kumar. S. What is it? Superman will have S or K. What will he have? S. But our Superman has K. Correct? This is Kumar. Now this is Superman. No, we should draw like this. Yes. Yes. Superman. You are. Yeah. So you are what? Correct? K. Correct? Yes. Superman. Correct? So the thing is, he has saved me. 4 years later, because I was saved in that fire by Kumar, did he do it for free or for money? Free. So voluntary service it was. It was voluntary service. Now, because I was saved in the fire, correct, I became full rich. Suddenly, like lady luck shone on me and I became extremely rich. 4 years later, I come to Kumar and say, boss, thank you for saving me that day. I now promise to pay you 10 lakh rupees. And I write one agreement and give it to him. In the next 1 month, I'll pay you. 1 month later, he comes. I don't pay. Can he sue me? Answer is, then he will, basically then the court will say, what is your consideration for me? He said, past consideration. He saved my life. But then now I am not paying him actually. In the court when I go, who will win the case? He will win the case. Because the court will say, boss, you only wrote and told you will give. There was no need for you to give, first of all. You only said you will give. And now you are telling you will not give. It was a past service. Was it a voluntary service? Yes. If Kumar was a employee of the fire department, then no. Because was it voluntary service? No. He did it as part of his job. Paid service it is. Not voluntary at all. But he himself, what? So like superpowers came and, saved me. In that case, what is the scene? Past voluntary service, though for me there is no consideration now, still it is valid consideration because past consideration is there and it is a voluntary service. So first one is what? Written and registered agreement. The next is past voluntary service. Third, promise to pay a time barred debt. Between a debtor and a creditor, if the relationship, in the sense you do not send any notice for repayment, you do not ask your money back, that money will stay for how long? Or rather that notice or that entire contract will stay for how long? 3 years. Because there is a law called LOL. What is LOL? Law of limitation. Law of limitation. 3 years later, if the creditor asks, where is my money? You can reply saying LOL. Why? Law of limitation. Correct? Law of limitation. So what is law of limitation? Debtor and creditor, 3 years. If you do not seek your money, I am not saying within 3 years you have to pay. I am just saying within 3 years you have to send a notice that I need to pay. Within 3 years, creditor has given me 1 lakh rupees and he has forgotten about it completely. 5 years later he is coming and telling, I want the money. Is it? Can he sue? No. On the other hand, I only go to him and say, sir, 5 years ago, you have paid me 1 lakh rupees, which I am 100% sure you have forgotten. Next week, I am writing a document. Next week, I will pay that money back to you. You have made a promise to pay a time barred debt. Is there any consideration for you as of today? No. Because that 3 years ago, that contract is already gone. But still you are promising to pay. If I don't pay after promising, can I be sued? Even though it is time barred? Yes. Why? Because I made a promise to pay. I made a promise to pay a time barred debt. I made a promise to pay a time barred debt. First one, written and registered agreement arising out of natural love and affection. Second one, past voluntary service. Third one, promise to pay a time barred debt. Fourth one, completed gift. Completed gift. So if I, out of my own free will, want to gift you something, if I want to gift you something, I will have to go through a gift deed. There is something called as gift deed. In the gift deed, I will say, I will completely give my whatever asset I want to buy. Let's say I want to gift a house to you. That house will be gifted to you. Who is the person doing the gift called? Gifter, giftee and all, don't tell. Yes, donor and Dhoni, not Dhoni, Dhoni. Person giving the gift is called donor. Other person is called Dhoni. Gifter, giftee, no. Alright, yes, donor and Dhoni. So, I am the donor through a gift deed. I am telling that I am going to gift this house to you. You have the gift deed in your hand. As the registration should happen 2 months later. 2 months later, if I back out now, no, I don't want to give the gift, can you sue me? Yes, once the gift deed is already done, you cannot take it back. That's why you should be very careful while signing the gift deed. So that other fellow, cannot go and say, sir, there is no consideration for me. Said, no, even though there is no consideration, it's a valid contract as per, Contract Act. Completed gifts. So, anything that you promise to pay a gift, it is called as completed gift. When the gift deed is done, it's called as a completed gift. Cannot be taken back. Is there any consideration for the donor? No. Sir, satisfaction, that is not consideration. Correct? Donor has zero consideration, but is it still a valid contract? 100% yes. Next, bailment. What do you mean by bailment? Already discussed. Transfer of possession. Transfer of possession. Let's say you become a CA and you buy brand new Hayabusa bike. Correct? Hayabusa. 20-25 lakh bike it is. Minimum. Hayabusa. Very, very nice bike. Correct? Yes. So, the thing is, you will, come in front of KSA in Hayabusa bike. I'll be standing there. I'm like, wow, man, very nice. Congratulations. Thank you, sir. Then, you will say, sir, do you want a ride? I'll say, yes, sure. You will hand over the key to me. I said, I want a ride. I never said, I want to ride. But you have given me the key. Now, everybody is watching. All students are watching. My mana maryada is at stake. I have told that, okay, I will ride and all I have told. Now, I will sit on the bike and accelerate. It will fly from AGR building to the other building. And there is one electric pole there in front. It will go and hit there. So, Hayabusa will become Haya one side, Busa one side. Alright? Tire will go that side, this tire, one tire will go. Now, my question is, you will come and say, sir, what have you done? I said, what did I do? Nothing, it has happened. Hayabusa is there, no, see, Hayabusa, that's there. So, it says, sir, I don't know, you pay me. You pay me, you sell me your car, you sell me your shorts, you will sell me your everything and say, anyway, Karthi, this fellow is there. He will give me shorts, no problem. So, you sell everything. Superman is there now, waiting. So, he said, sell everything and give me now. 40 lakh rupees, this bike. No, you cannot even repair it, replacement. You sell it, you give me now. Now, I will say, boss, I am not the owner. You are the owner. As per Motor Vehicles Act, you have to die, not me. Correct? You committed the accident, not me at all. Second part of the story is, when you gave me the key, what was your consideration? Nothing. It was called as gratuitous bailment. Gratuitous means what? Bailment given for free. Gratuitous bailment. It's like I give you my laptop and say, I'll just go down and come, man, just keep this laptop with you. That is bailment. Is it gratuitous or non-gratuitous? Gratuitous, for free. Gratuitous bailment. So, I will tell whatever the key that you gave was gratuitous bailment. Why did you give me? I didn't even give you any money. So, not possible. Not a contract. That's why Indian Contract Act says bailment is a contract. Even though there is no consideration, there is a contract. So, gratuitous bailment is a contract. Next, contract of agency. When an agent is entering into a contract with you, an agent is entering into a contract with an outsider, is there any consideration for him from the outsider? No. His consideration is only with the principal. But still, he can enter into a valid contract with his, on behalf of his principal. So, always principal, agent and outsider. Agent and outsider will enter into a contract with each other, but on behalf of the principal. This also is, though there is no consideration for the agent for that particular contract, he is getting a salary or amount from the principal, hence it's valid contract. Though there is no consideration in this particular thing, because the consideration is going to principal, still it's a valid contract. Still it's a valid contract. Lastly, charity. You become a chartered accountant and you will tell that I will now donate my first month's salary to charity. So you'll go to a charitable organization, you will tell, madam, you tell me what all you want. You'll say, I want some orphanage. Orphanage will say, I want some beds, I want some cots, I want some chairs. You'll say, my salary is 2 lakh rupees, I'm going to donate 1.5 lakh rupees. The salary is coming in 3-4 days, you please order it today only. So that lady becomes very happy and she orders. Correct? In 2 days, you are giving party to one girlfriend, second girlfriend, third girlfriend. By the time that 2 days happens, 1,50,000 will become 10,000 rupees. Then now that charity lady is calling. Now you have reached a situation where you only have to go with a begging plate everywhere. You only need donation. Correct? Now the charity lady is calling, where money, etc. You are nowhere to be seen. Can she sue you? 100% yes. Because of the faith of that promise, she has gone and bought the goods. You promised to pay 1,50,000. She has spent 1,20,000. How much can she sue for? 1,50,000 or 1,20,000? 1,20,000 only. How much she has spent? You had promised to pay 1,50,000. She has spent 2,10,000. 1,50,000 only. So the donation or actual amount spent, whichever is less. Promised donation or actual amount spent, whichever is less only. Whichever is less only should be done. That is what it is. These are all the exceptions to what? No consideration, no contract. So first this is consideration portion. Then we have no consideration, no contract. Then we have something called as what? Doctrine of privity of contract. Doctrine of privity of contract. This part we will do tomorrow. Doctrine of privity of contract. Just before leaving now, let's see capacity to contract. Very small part, small part. This part tomorrow morning, whenever, if tomorrow is there class tomorrow? I don't know. I have no idea. They didn't give me the schedule. Today also it was not there. Yesterday they told me. Is it there or not? Don't know. Even I don't know. If at all it is there tomorrow, then we will start with doctrine of privity of contract. Okay? Actually, it's okay. Anyway, 5 minutes is there. Bye. See you. Leave. Bye, bye. Take care. Because the other part again takes time. Leave it. Bye. Bye. Yes. All right, guys. Can we begin? Just little bit volume. Recording is started. All right. Okay, where did we stop, guys, yesterday? Where did we stop? Contract act we are doing. And we had stopped at consideration, right? Let's go ahead with that. That's okay. It'll go. Okay, guys. So, thank you. Thank you. Okay. So, let me just. Okay. So you had an extended break, right? Break means what? From 9:30 break only, no? No, why? First session from 7:30 to 9:30. Then 10:30 to 12:30 only was the first session, no? Oh, before you class started only break happened. Super. Yes. All right. So I was in a meeting. I was seeing my screen and suddenly mobile was in silent and I saw 32 missed calls. Huh? Like what happened? Who died? Yeah. And that's what I thought. Then I saw, then all these are people only were there, so many calls. Then I said, okay, fine. Yeah. Miscommunication happens. Communication is not there, the miscommunication. Okay. So, one thing that I really hate is making students wait. As you know, I've always, when the class time is 7:30, we will be there at 7:30. If it's at, you've seen, right? So I hate, that's my policy from beginning. So genuinely, it's okay, it happens, guys, mistakes happen. So it was not informed to me, it's okay, don't worry. But I'm sorry, genuinely, I'm sorry. That was never the intention to make you wait. I really did not know, genuinely. Is unilateral mistake or bilateral mistake? We'll discuss all that. Everything you can convert to contract act, don't worry. Yes, so if you see, right, acceptance and all is done. This part I still have to do. We will do that this part later, no problem. Yes, so if you see, consideration we're doing, correct? Consideration, let's continue with it. Consideration, meaning and definition we have seen. Consideration means what? Something in return. So when you get something in return, that's what it is. You have your schedule, any other class after this? No, okay. Because I have 2 other classes. Then if I have to take this also, that also, I was thinking how to do. Right hand I'll teach this, left hand like Rajnikant, other class I'll take. Yeah, right. What is that called? Left hand, right hand, BCR. Ambidextrous, very good. Yes. So, right. So, consideration may move from a stranger. Okay, quick revision. What all case laws that you have to remember? First one, Balfour versus Balfour. Then, Carlyle versus, okay, what was the decision in Balfour versus Balfour? Social obligation. Okay, next was Carlyle versus Carbolic Smoke Ball. What was the decision in that? Yes, so in a general offer, no need of acceptance. Communication of acceptance not needed. What you should do? Follow the instruction. That's all. Next one. Bolton versus Jones. In that case, what happened? For specific offer, you should communicate. Sorry, the acceptance should be communicated by the offeree. Acceptance should be communicated by the offeree. Good. Next. Harris versus Nickerson. In that, what happened? Auction sale. In auction sale, it's an invitation to offer. So, following the conditions of the offer. What do you say? In that case, what happened? In Harris versus Nickerson, the coming to the auction and then saying that, okay, I've spent expenses, reimburse the amount. No. If the auction gets cancelled, will he get any reimbursement? Nothing. Because it is merely an invitation to offer and not exactly an offer. Very good. Next. Which one? Lalman Shukla versus Gauri Dutt. What is that? What does it say? Yes, in that case, offer should emanate from an, acceptance should emanate from an offer. It should arise from an offer is what we said. All that we saw. Very good. Now, and here one more case we saw. Which one? Chinnaya versus Ramaya. In Chinnaya versus Ramaya, we saw that it should come from, it will come from where? The consideration can come from a stranger. Consideration can come from a stranger. It can also benefit a stranger. Consideration can come from a stranger and it can also benefit a stranger. That is what it said. It can come from a stranger and also benefit a stranger. All that we saw. So moving on. We saw exceptions to no consideration, no contract. WB, 2P, 3C. W, written and registered agreement arising out of love and affection between the parties. Then B, bailment. Then 2P, one is promise to pay time barred debt. One more is past voluntary services. Then 3C, one is contract of agency. Then charity. And then completed gifts. Completed gifts. So, in written and registered agreement, that case law is Rajluki versus Bhutnath. I mean, it's okay if you can't remember, it's okay. But if you can remember, great. Rajluki versus Bhutnath. Rajluki versus Bhutnath is Balfour versus Balfour only, no? Actually, it is Balfour versus Balfour plus written and registered agreement. Balfour versus Balfour plus written and registered agreement will be Rajluki versus Bhutnath. But what was missing here? Love and affection. Love is missing, correct? Yeah. So, love is missing. Love and affection is missing. So, then what will happen? Gone. All that we have seen. Now, coming to the next concept of doctrine of privity of contract. Doctrine means what, guys? BCR, doctrine. Rule, very good. Mana Maryade, that is little saved for me. Yes, rule, correct. Doctrine means rule, very good. And privity means what? Yes, privacy, or privacy, whatever, UK English, US English. Doctrine of privity of contract. Doctrine of privity of contract. What does it say in that? Doctrine of privity of contract means what? Basically, yes, a stranger cannot sue. We have seen one dialogue which says there can be a stranger to a consideration, Chinnaya versus Ramaya. But can there be a stranger to a contract? No, there can be no stranger to a contract. Stranger to a contract cannot be there. So the case law here was Dunlop Pneumatic Tire Company versus Selfridge. No need to remember the name, it's okay. And what happened here, guys? I mean, gist of the story: if there is a wholesaler, or rather manufacturer sells something to the, let's say, wholesaler, and he will tell, you cannot sell my product less than 1000 rupees. Just an example. Manufacturer sells to the wholesaler and says, boss, you cannot sell it further for less than 1000. Minimum should be 1000. So he will sell it to various people, retailers. To some people, he'll sell it at 1010 rupees, 1100, 1500, 2500. Fair enough. But when the retailers are selling, no, they will sell at whatever rate they want, 800, 900, 1200. Now, there are two contracts here. One is between manufacturer and the wholesaler. Second contract, a series of contract between wholesaler and retailer. The moment the manufacturer comes to know that it is being resold like that crazily, he will immediately sue the wholesaler. Wholesaler will say, boss, I did not sell. I sold it at minimum 1000 only. If the other fellow sells, what can I do? This went to court. In the agreement, it was only between whom? Manufacturer and the wholesaler. Retailer was not at all concerned about this. Now the question is, if the terms of the contract said you cannot sell or resell beyond 1000, then I understand manufacturer has every right. I repeat, in the terms of the contract, if it is mentioned, you cannot sell or resell. You cannot sell or resell beyond 1000 rupees. Then I understand. No problem. But if the contract just said you cannot sell beyond 1000, did the wholesaler breach this contract? No. He has sold to everybody minimum 1000. If the retailer has done it, does manufacturer have any control over the retailer in this agreement? No. The contract is between manufacturer and wholesaler. So outside fellows are not covered. This is basically a manufacturer cannot go and sue the retailer. Why? Doctrine of privity of contract. The contract is between manufacturer and wholesaler. Retailer is nowhere to be covered here. Retailer is nowhere to be covered. Good. Did you get this? Manufacturer and wholesaler, that's the deal. Retailer is nowhere to be covered in this entire scenario. In this entire scenario, retailer is not to be seen. It is only between whom? Manufacturer and wholesaler. Got it? So this is the doctrine of privity of contract. But are there scenarios where even a non-party to the contract can sue? Yes, there are exceptions to the rule of doctrine of privity of contract. That can be a separate question. That can be a separate question. What are the exceptions to the rule of doctrine of privity of contract? What are those exceptions? Let us see. It's in the notes only. Check it out. This one. Yes, these are all the examples of what? Stranger also can sue. Stranger also can sue. Quick examples we will take to understand. So basically you would have heard in Companies Act and even in your CA Foundation accounts something called as debentures. Who will issue debentures, guys? Yes, company will issue something called as debentures. Is debenture like a loan? Yes. So like debenture holders will be there. They will give money to the company. Correct? And then in acknowledgement, one acknowledgement I have to give. What will I give there? Debentures. Debentures will carry some interest, 8%, 9%, whatever. That will be like acknowledgement of your liability, and that is my interest portion. 8%, 9%, 10% is the loan interest portion. Now, this is not as simple as I have written it here in the Companies Act. So basically, debenture holder will not directly buy, because thousands, lakhs and lakhs of debenture holders will be there. Like all of us can be debenture holders. I will not know you, you will not know me. But then all of us must be protected. Tomorrow, if the company does not pay, what to do? Right? So basically what happens is, ideally speaking in law what happens is, company will definitely issue debentures, no doubt, but it will all be governed by a trust. Trust means a group of people creating something. Now the thing is, this will be called as debenture trust, and all the debenture holders will have access to something called debenture trust deed. Now debenture trust deed will be governed by a guy called debenture trustee. Debenture holders will be part of this debenture trust deed, and the trustee will directly, is like a representative, he will directly coordinate with the company. Right now, as per this debenture trust deed, the trustee will have control over the company's assets. If the company does not repay the debentures, what should the trustee do? Take away the assets and sell the assets. That's the role of a trustee. Now tell me, the contract is between who and who in this example? The contract is between company and the debenture trustee. Holders are not there only. The contract is between company and the debenture trustee. But it is for the benefit of who? Debenture holders. It's for the benefit of debenture holders. Now tell me, are debenture holders part of the contract? No. Are they part of the contract? Definitely not. Parties to the contract are who? Company and debenture trustee. Company and debenture trustee are parties to the contract. Parties to the contract. What do I do now? Tomorrow, if the company does not pay the debentures, I want to take over my assets. I will take over my assets. But let's say the company has paid some bribe to the trustee, and the trustee is simply delaying it. Trustee is delaying it. He has got his money. Why will he care? Debenture holders come to know about it. Question is, can debenture holders sue? 100% they can sue. Why? Yes, because this is an exception. General rule what? Doctrine of privity of contract. Can debenture holders sue? No. But this is an exception. First one. Trust or charge. What trust have they created? Debenture trust. What does this charge mean? This charge is nothing but right over the asset. Right over the asset. Which asset? The fixed assets of the company. So basically in law, when you have a right over the asset, you will say that you will have a charge. When you have a right over the asset, you will say that you will have a charge. When you have a right over the asset, you will say that you will have a charge. You will have a charge. Correct? That is called charge. Right over the asset is called trust or charge. That is a legal term, by the way. Legal term. Trust or charge. Next. Second one. Marriage settlement, partition and other family arrangements. Marriage settlement and other family arrangements. So basically all these things. Let's see. In a family arrangement, a family partition, for example, Hindu undivided family is there. Are female members, can female be members? Yes. Can female be karta? Earlier it was not possible, but now after one Supreme Court case law, correct, a few years ago, what did they say? Even a female member can be a karta. Now HUF system only is useless. HUF system has become a method of what? Evading taxes. It is a method of evading taxes. Correct? How and all, you will now, for foundation not needed, leave it. They want to abolish the system of HUF. But anyway, HUF is still there now. In a Hindu undivided family, are female members generally allowed? No. That was an exception where female members were also allowed, but generally are female members allowed to participate in the day-to-day operations of the HUF business? No. It is an old, stupid law now. It is no longer relevant. But anyway, as per that law, are female members allowed to participate? No. Now the question is, during a partition of the HUF, however, are female members entitled to their share? Yes. If the male members do not give them the share as promised, can female members sue even though they are not party to the contract? Yes, they can sue. Are they parties to the contract? No. Because in HF, the agreement will be between the male members of the Hindu undivided family. But can the female members also sue? Yes. They can definitely sue because it is a family partition. Hindu undivided family partition. So, right. So, if you see here, one more example. There was a father-in-law and the father. They entered into a contract. So in Islamic Sharia law, when a girl is entering into a family, the boy's side should pay money to the girl's side. Correct? It's not like dowry, it's reverse dowry. Correct? When the girl is entering into the groom's place, the groom's side should pay money to the girl's side. Why? Because this lady is coming into the house, and it is more like a contract whereby one person is coming into, not sold. Sold is a very weird word. It's not sold. Basically, one person from my family is going into your family. For that, I need consideration. So that way they are giving. That's like a contract in the Islamic Sharia law. Don't tell girl is sold and all. Don't write all that in the exam. Correct? So this is the rule. Okay. So father-in-law and father entered into a contract on behalf of this fellow's son and of course the daughter-in-law, whereby money is to be given by whom? I told you, father-in-law was supposed to give money to the father, but that father was very smart. He said Chinnaya versus Ramaya, consideration can move to a stranger also. Who is a stranger to the contract? Daughter. So he said, as per Chinnaya versus Ramaya, you don't pay it to me, you give it to my daughter. So father-in-law was supposed to pay money to whom? To the daughter-in-law. Father-in-law paid for some time. After that, he stopped paying. So the daughter-in-law sued the father-in-law. Father-in-law said, there can be a stranger to a consideration, but there can never be a stranger to a contract. This went to court. Who won? Phil won or Dil won? Dil is what? Daughter-in-law. Phil is father-in-law. Phil won or Dil won? Dil. Why? Because it's an exception. Because this is a marriage settlement. As you can see, marriage settlement. Important case you have to remember. Which one? Khwaja Muhammad versus Hussaini Begum. Khwaja Muhammad versus Hussaini Begum. There you can ignore the fact that they were minors. It's an old case law. Now minors cannot get married. But on that old law you could have married. You don't get ideas now. Finish CA first. Yes. So Khwaja Muhammad versus Hussaini Begum. Read that case. Please read. Read. And tell me what would be the decision. Read. You have your mobile or you have your printed material, or it's a screen also is there. You can please see. Read. Page number 12. Yes, page number 12. Kindly read. Done. So what did it say? Held. Both H and D were minors at the time of marriage. Held. That minors you leave, that's fine. Here, H can sue her father-in-law. Why? Because it is an exception to the rule of doctrine of privity of contract. Under which one? Under the exception marriage settlement. Marriage settlement. So it is 100% possible. It is possible. Next. I'll do acknowledgement of liability slightly later. Assignment of a contract. What do you mean by assignment, guys? What does the word assign mean? assign means transfer of a right. Transfer of a right is called assign. Transfer of a right is called as assign. So what do you mean by assigning here? Assigning a contract. So A, for example, will assign, basically he will have to pay B some amount, or he would have sold goods to B, and B will give something called as bills payable. Have you heard? Like for example, I have sold goods worth 1 lakh rupees. Now B has given to A a note saying that after 1 month I will pay 1 lakh rupees. That will be called bills payable. In A's hands it will be called as bills receivable. You know that. Now A has a right to pay or right to receive? Right to receive. He in fact has to pay some amount to some random guy C. Can he endorse that bills receivable? Yes. He will tell C, bro, I have to pay you 1 lakh. I have to receive 1 lakh anyway. B has to give me 1 lakh. I have to give you 1 lakh. Instead of all this drama, B only will pay you 1 lakh. Take it. This is what he will anyway give. Take it. Endorse. Now C has to pay some other guy. That's a link. D. D has to pay some more guy. F, G, like that it keeps going. So basically what started off with A and B, that 1 lakh has been endorsed to so many people. And in the end, it has come to whom? H. It has come to H. Now my question is simple. What was the original contract between A and B? H will come to B and say, bro, pay me the 1 lakh rupees. B will not pay. B will not pay. Can H sue each and every person in that string? 100% yes. He can sue. That's the beauty of this assignment of a contract. What is assignment? Right to receive. Right to receive has been transferred to each person. A has a right to receive how much? 1 lakh. Transferred to whom? C. C has a right to receive what? Transferred to D. D transferred to E. E to F. F to G. G to H. So it has gone to whom eventually? H. And can H come back and what do you say? Give them a thing to B? Yes, he can give. And if B does not pay, can I sue all the previous parties? Yes. Can the other say, sir, we never entered into a contract with you? Yeah, you may not have entered, but this is an exception in Indian Contract Act. What is it? Assignment of a contract. Got it? That's called assignment of a contract. In assignment of a contract, even though you are not party to the contract, in assignment of a contract, even though you are not party to the contract, you can still sue. Even though you are not party to the contract, you can still sue. Why can you sue? How can you sue? Why? Because it is an exception to the rule of doctrine of privity of contract. Very, very simple. Contracts entered into through an agent. Same. I enter into a contract with an outsider. I am just an agent. I am entering into a contract on behalf of, let's say, KS Academy. I am just an agent. I am entering into a contract on behalf of KSA. Ultimately, if anything happens, the contract is between me and the outsider. Contract is between me and the outsider. I am signing on behalf of KSA. Is KSA a party to the contract? No. It is between me and the outsider. Tomorrow, if anything happens, can KSA sue the outsider? Yes. Why? Because I am just an agent. Who is the principal? KSA. On the other hand, can that other party, if I cheat the other party, can the other party directly sue KSA? Yes. Even though KSA is not party to the contract, that outside party can sue KSA because the contract now is entered into on behalf of KSA. That's what contracts entered into through an agent. Contracts entered into through an agent. Contracts entered into through an agent. That is one part. Now, You've seen some Christian colleges. Do you have some Christian colleges in Bangalore, in Chennai? Yes, Loyola and all that. One thing, if you go to those Christian colleges, one thing you will see, their grounds are huge. Have you ever wondered? Everywhere the grounds are huge grounds. Correct? If you have not studied in a Christian college, your entire full school building will be less than their ground size. Huge grounds. Have you ever wondered why? Because before, at the time of independence, 1947, there were a lot of Britishers still remaining in our country, and they brought in the various other types of education from UK. One is Montessori type of education. Instead of nursery, the Montessori school, where they don't teach everything using books, but more of, other things they teach, which is very different kind of education called Montessori. Similarly, your entire these Christian missionaries who had come to India, they said we will bring in good convent education. So many convents were established across the country to provide us very good education, including in English. But they said we need some benefits. We need some benefits. So what did the government do? They sold the land to those people at dirt cheap rates. If the land value, let's say, is 1 lakh, they sold it to them at 10,000 rupees. That is why, if you see, that's a fact of life. If you see all the Christian colleges across India, see their grounds. How is it possible that in the middle of the city they are able to get huge grounds? It's because of, purchasing it at dirt cheap rates. And did they have money to buy? 100%. Why? Because money came from outside. Money came from outside, correct? The foreigners paid the money, so they bought the land. It was registered in India only. Foreigners didn't buy the land. It was registered in India, but dirt cheap rates. But government put a condition. What condition? You should use it only for education. Only education or little bit of your spiritual, religious purposes, yes, but only that, nothing else. That's why in most of your colleges, this Christian college, you will find a church also. 100%. There will be a church inside. That is again because of that restriction. You cannot use it for any other purpose. One church you can make, that only one. You can't make 10 churches. One church and college or school should be there. That's it. And huge grounds you can have. You can do whatever you want, but education. Now, they say, as long as the land is there, you should always use it for what purpose? Education purpose, nothing else. So basically, that thing is called as a covenant. That is called as a covenant. A covenant is a benefit as well as a restriction. A covenant is a benefit as well as a restriction. A covenant is a benefit as well as a restriction. What is the benefit here? No, what is the benefit of the land getting at dirt cheap rates? What is the restriction? Use it only for education. Use it only for education. So, the government sells this land to some person. What's your name, da? Spelling? Vignesh, okay, Vignesh. So, he will send it to Vignesh. Vignesh will open one college. Vignesh School of Vignesh School of Commerce, Vignesh Institute, not school, Vignesh Institute of Commerce and Knowledge Sciences, Wix. See, Wix. I made Wix, correct? So, he will open one institute called Wix, right? Vignesh Institute of Commerce and other, everything, all knowledge enhancing studies. So, he will keep this, and they'll tell very simple that you should only use it for educational purposes. No problem. He will use it for some 5-10 years. So, the state government actually sold it, right? Who is the party to the contract? That is state government and Vignesh now. Vignesh uses it for many years and he will transfer to somebody else. What's your name? You only. Varsha. So Vignesh will transfer it to Varsha. Varsha will, open Varsha Spiritual Center. Varsha Spiritual Center. They said you can only use it for education and spiritual purposes, maybe sports also. That's it. Sports, educational services, and spiritual centers. So she opens Varsha Spiritual Center. She'll also run it for some 5-10 years, no problem. Then she will sell it to, what's your name, da? Next week's Jagan. Ah, is Jagan. So he will institute what? Jakkamma Yoga Center. Yes, correct. So he will open what? Jakkamma Yoga Center. Correct? Right, he will open that. That he will open. He will also, is this a correct thing? Yes. He can use it for some time. So he will use it for what? 5 to 10 years. Yoga center will happen. Yoga center will happen. Okay. Control. Yeah. So Jakkamma Yoga Center, 5-10 years he will do it. After that, Jakkamma Yoga Center, it will go to, what is your name, da? This fellow? Gopal. So he will, Gopal will open Gopal Wine Store. Yes. And bar and restaurant. Alright? Yes, he will say Gopal Bar and Restaurant. Spiritual activity, he will tell. Spiritual activity. Correct? Spirit. Yeah. So that spiritual activity. Now the thing is, the government will come to know about this. Government will come to know about this. Can the government directly sue Gopal Bar and Restaurant? But the government is not party to the contract. Exception, that is covenant, last point. Covenant running with the land. Covenant here. Covenants running with the land. So as long as the land is there, that restriction will continue. As long as the land is there, that restriction will continue. That is called what? Covenant running with the land. Covenant running with the land. Boyfriend will be texting, hey, where the lunch break? 15 minutes, I'll be out. Please come. She'll be texting. That boyfriend will be texting. But I only came late, so they asked me to take class till 1 o'clock. 1 o'clock. Yes. Covenant running with the land. Class is till 1. Till 11, for 11:30 you are sitting, no? I can't help it. It is not my mistake. So otherwise I would have left at 12:30. Now the class is still 1. After that you again can leave. Any other class? No, you can leave. So covenants what? Running with the land. I have at 1:30. Covenants running with the land. Covenants running with the land. Means what? As long as land is there. As long as land is there, your restriction or benefit will go on. A restriction or benefit will go on. She will now text 12:30, not possible. The stupid fellow came late. Yes. So, darling, please come at 1 o'clock. Yeah. Alright. Yes. Covenants running with the land. Covenants running with the land is what it's. That's it. So, these are all the various points. Other cases and all not needed. This much is enough. What is the case law? Khwaja Muhammad versus Hussaini Begum. Khwaja Muhammad versus Hussaini Begum is what you need to check. So this is what exceptions to the rule of doctrine of privity of contract. Strangers also can sue. In this case, strangers also can sue undoubtedly. Now, as far as capacity to contract are concerned, very, very simple, guys. 3 things. First of all, you should be a major. Next, sound mind. Next, person who is not disqualified by law. Person who is not disqualified by law. Agreement with such a person is. Agreement with minor is void or void ab initio. Void ab initio. Once you become a major, can I approve those contracts or cannot approve? How can you approve something which was invalid from the beginning? Cannot be approved. So if you enter into an agreement with minor, later you cannot say, sorry, I'll approve it again. There's no concept of approval. Agreement with minor is void ab initio. If you become a major, I cannot approve old contracts because that old one was not at all a contract. What will you do? Does it mean that you can't enter into a contract once you become a major? No, you can. That will be a fresh contract. It will not be approval of the old contract because old contract only doesn't exist. It is void when it is an agreement stage only. So tell me, can the acts done by the minor once he becomes a major, can it be approved? No. Other hi-fi language of approval is called ratify. So can acts be ratified? Cannot be ratified. Very good. Cannot be ratified. Cannot be ratified. Acts cannot be ratified. Ratified means approved. If a if a minor misrepresents his age to be a major, you are 16, you will make all fake documents and show you are 20 years of age. You will assume that I am a major, you will sell your property to me. I will not pay you anything, I will run away. I will just pay some down payment, remaining payment I will not pay. I will run away. Do you have any right under the Indian Contract Act? Unfortunately, no. Why? Agreement with minor is void ab initio. So, is he liable in case of fraudulent representation, or minor is still not liable? Unfortunately, under Contract Act, not liable. Not liable. Like this, many minors started cheating the public. So these fellows went and told, what stupid law is this Contract Act? Correct? This was from 1857 to almost 1960s, so 100 years. People, the children, actually kids, started cheating. All 15, 14-year-old kids started calling themselves at 18, 19, 20. In Pakistan cricket team, though they do. Correct? Have you seen? They are some 25, they show that they are 18. Shahid Afridi, one player, was there. Correct? Shahid Afridi, I think some 60 years he is. Still is showing 30. Correct? So that's how they do. Pakistan famous in doing this. Changing their age. They will be 25, they will tell 18. They will change the records only, imagine. That is reverse. But here I am talking about reverse. What? You are 16 but you are showing 25. In cricket it should be reverse only, no? The younger you are, the better. Right? So if you see experts, Pakistan, Afghanistan, all experts there. So agreement is what? Void ab initio. Then if you see in case of fraudulent representation of age, liable, not liable? Not liable. Why? Because of course. But the thing is, as I told you, they went to the court and said, sir, do something about it. I am simply here sitting and dying here. Every time, I will say that, this is a problem, and you will not do anything. You will still say that not liable. You will still say not liable. What to do? So they went to the courts, and the lawmaker said, okay, fine, we'll do something. They created one more law that was called as Specific Relief Act. They created one more law in 1963 called Specific Relief Act. Under Specific Relief Act, they said, if a minor has cheated a major and he has looted the money and he has gone, if the money is still traceable, if you can still figure out where that money is, the court can, it is not compulsory, the court may ask the minor to refund that amount. Is it under Indian Contract Act? No, it is under Specific Relief Act. So if they ask you a question in the exam, what will you write? Can be returned, cannot be returned? Cannot be returned. But will you write a note also under Specific Relief Act? Yes. This note will add weightage to your answer. This note will add weightage to your answer. And if you assume that questions like that will never come, you are mistaken. I'll just show you. They would have seen. Not on Specific Relief Act specifically. What I'm saying is, questions will come based on things. 1 second. Let me see. Indian Contract Act only I'm saying. See, for example, guys, here 7 marks question. This was November 19. Direct question. Define consideration. What are the legal rules relating consideration under the Indian Contract Act? Yesterday only we fully discussed. You have to define consideration. Then the rules relating to consideration you have to explain. What are the rules? Consideration must move at the desire of the promisor. Durga Prasad versus Baldio, explain. Consideration must be legal and should not be illegal or something of a pre-existing obligation. Collins versus Godfrey, that case you have to explain. Then consideration can move from a stranger, benefit a stranger. You have to explain Chinnaya versus Ramaya. 7 marks question, guys, not 1 or 2. Then of course consideration need not be adequate. Consideration should not be illusory, like that. 7 marks. Correct? So like that direct questions will come, or I mean you will also get to give you case study based questions. Case study based questions also. Let me just check 1 second. Now see here, examine the validity of the following contracts as per the Indian Contract Act, giving reasons. Question number 1. I am reading December 21 question paper. See that question number 1. Read. X age 16 years borrowed a loan of 50,000 for his personal purposes. Few months later, he had become major. How few months later he became major, God only knows. They meant 2 years later. And could not pay back the amount borrowed on due date. The lender wants to file a suit against X. Answer. Agreement with minor is void ab initio. There is no ratification once he becomes a major. And the landmark judgment in minority cases. Yes, kiski bibi? Mohiri bibi. Correct? Yes. So if you see, come back here. Mohiri bibi versus Dharmadas Ghosh. Here. You have to remember the name. Important. Mohiri Bibi versus Dharmadas Ghosh. Mohiri Bibi versus Dharmadas Ghosh. Landmark judgment in the Indian Contract Act. Agreement with minor is void ab initio. Agreement with minor is void ab initio. You should write that answer. If it's like a 4-5 mark question, 4 mark question, apart from this answer, you should also say, once the minor falsely represents his age, nothing can be done. However, under specific relief act, if the court feels that the property is still with the minor, the court may ask for refund. Only the court may. That is as a note only, not your main answer. As a note you should write. So that I have given it here. Please read. Kangul versus Laka Singh. Please check. Especially from here. Section 30. This one you should write in the exam. Examination as a note, not as the main answer. In the exam as a note, not as a main answer. Please read. Page number 14. Read. Section 30 and 33 of which law? Specific Relief Act. Read it, guys. Section 30 and 33 of Specific Relief Act provides that in case of fraudulent misrepresentation of his age by a minor, inducing the other party to enter into a contract, the court may award compensation to the other party, and you can say this also, if the money could be traced. Check it out here, this one. If the money could be traced, the court on equitable grounds asks the minor for restitution. Restitution means refund. Equitable grounds means based on justice. Equitable ground means based on justice. This is what we should write. This is as a note only. This is as a note only. So let us see 1 second. See your 6 marks question, May 22. Your attempt, hey, your written. See, same thing they had asked. Srishti, a minor, falsely representing her age, enters into an agreement with authorized laptop dealer, owner of SP laptops, a purchase of laptop on credit amount 60,000. She promised to pay back outstanding amount on 16 July, whatever it is. She told that in case she won't be able to pay, her father will pay back on her behalf. After 1 year, when she was asked to pay, she refused to pay and told the owner that minor and how he can't recover a single penny. What do you think? She will be adult on 1st January 24 after the agreement can be ratified. See, all nonsense. What is the answer? Yes, agreement with the minor is void ab initio. Second point, no ratification possible after attaining majority. Third one, if she is only not responsible, will her parents be liable? No, parents also will not be liable. Exception is Motor Vehicles Act. In Motor Vehicles Act, you take your dad's scooter. You are a minor. You take your dad's car and go and bang and kill somebody. You are mini Salman Khan. Correct? Then tell I was not driving because I am a minor. Correct? I am not driving at all. Correct? What do you think? In the Motor Vehicles Act, whoever is driving, especially minor if it's driving, parents will be liable. In Indian Contract Act, parents will not be liable. In Motor Vehicles Act, parents will be liable. In Indian Contract Act, parents will not be liable. So if you see here, so same answer for that. 6 marks question, they had asked the same thing. This you should write, guys. Section 630 and 33. This is fraudulent. As a note, you can write this point. That's all. Motor Vehicles Act is different from our Contract Act. So if you see, cannot be a partner except for benefits. So if can minor be a partner, answer is no. Minor cannot be a partner. Minor can only be a partner for what? Benefits of the firm. You cannot say minor can be a partner. Then it's not partners, parents. Parents or guardian, liable or not liable? Not liable. Based on that only they asked a question. See, parents or guardian not liable. So if you read my material properly and go understand the concepts in class, all questions you can answer 100%. Everything is covered here. Next, cannot ask for specific performance of the contract. Specific performance means what? I don't want your money back, please perform the contract. Like for example, if you have attending crash course, I'll say I will not teach today. I will not teach only. Bye. And KSA only will tell that no subjects will be taught. Thank you for your money. Bye. Can you sue them? Yes. Can you ask for your money back? Yes. But you will say, sir, I don't want money back, sir. It's okay. Please complete the portions. I want to finish the exam. I want to clear the exam this time. Kindly finish the portions. This is called specific performance. Specific performance is you will do when money doesn't matter. Getting money back is of no use to you actually, but completing the classes is of lot of use to you. So when monetary remedy is not an adequate remedy, you will go for specific performance. Let's say a minor has cheated you. You will be like, okay, you've taken extra money, I don't care, but at least complete this, give me the contract. Can you tell like that to him? No. Cannot ask for specific performance. Minor cannot be judged as an insolvent because he is incompetent to enter into a contract. Minor is not liable also in any part of the contract, but minor's dash is liable for dash. Minor's estate, if he has any property, is liable for necessaries, not necessities. You have to write whatever is given in the Bare Act. Sir, what is the difference? Both are same only, but still you should write necessaries. It is better. Minor's estate is liable for necessaries. Sir, if I write necessities, will I lose marks? No, but I am just trying. Always remember, keyword should be written as per the Act itself. Even if you don't write, it's okay. I am just saying. Better to always write necessaries, not necessities. Minor's estate is liable for necessaries. So in this Moiri Bibas Dharmadas Ghosh, remember the name and other things you can go through. Nothing great here. This one, Khan Gul versus Laka Singh, name not needed, only the content. Always remember, Khan Gul versus Laka Singh should be written only as a note, not in the main answer. You will lose marks if you write in the main answer. You will get extra marks if you write as a note, because the evaluator feels that not only do you know Contract Act, but also Specific Relief Act, and you're connecting both the provisions beautifully, is what they will think. Necessaries means what, guys? Minors dash shall be liable in dash. Necessaries. Yesterday I gave you an example. You are the KD fellow. You will go and take from food, shelter, clothing, everything from KSA. Can KSA sue you? They cannot sue you personally, but they can sue your estate. Necessaries in life. Necessaries. Anybody who's singing here? Singer. Okay. Harish Jairaj here. What's your name? Okay, I'll take example. Yes. What's your name? Last time I think I took your example. Your name. You only. Yes. Name. Can't hear. Tamil what? Bharati. What a nice name. Tamil Bharati. Yes. Okay. Now, different. So, Tamil Bharati now is a singer, and she's, what do you say? She is going to, I mean, she is now studying for CA, obviously. She may not, she wants to obviously become a singer in the future, but as of now, she's just doing her CA. Fair enough. So I have, let's say, heard her sing. I have a couple of video recordings of her, audio recordings of her singing. Like, wow, she's very good. Now, when I'm going back, let's say I'm flying back to Bangalore. I was just sitting here. I turn right side. Anirudh is sitting next to me. Yeah, I was like, not bad. Then I make conversation with him, and I am talking to him, and then he's like, I said, I'll be like, bro, why are you going to Bangalore? He'll say, no, I want one different voice. I'm searching for a different voice. I'm making Legend Part 2 movie, right? Yes. So I want for that heroine, I want different voice, because hero only is so different. So for heroine, we want different voice. I'm doing that. That's what I will do. Hero, when he dances, heroine will just fall off. So for that, one powerful voice should be there. So I am searching for that voice, is what she tells. I said, okay. What he tells? Anirudh tells. I said, okay. I like, see, I have, I teach at KS Academy. Then there is one very nice singer. See, you want Tamil song? Her name is also Tamil only, correct? So you listen to her sing. Then I will just play that, he is mesmerized there only. In the flight only, he is flying already. Correct? Then it said, this is the voice only I was looking for, bro. I could have come here only. I'm going to Bangalore and all those things. Now I have to swim and go in Bangalore. I don't know where to search. Flood, no, that's why. So then he said, okay, fine. I'll do one thing. This person, 100% sure. Yes, 100%. Now, the thing is, I will tell this to her. She is very happy. Absolutely no problem. She's extremely happy. Then she'll say, yes. So this Anirudh says, so you are so awesome that now I'm actually going to for a world tour. I'm going on a world tour. Actually, he's going. If you see, he's going on a world tour. And he'll say, I want you also to come and be one of the background singers. It will be awesome. So we'll have a nice performance. Now, the thing is, I know you are a minor. You are just 16. What I'll do is, I'll book everything for you. Don't worry. And I will also train you in how to sing, and I'll also train you for the big stage, how it should be once you become a major. If you want to take this up as a main thing, the Anirudh will ask, are you serious about pursuing this thing as a career? She said, yes, 100%. So, cool. It's set. So, Anirudh is going to train her, and also he is going to book everything, and he just tells, see, you don't pay me for my classes, etc. That I will not charge 1 rupee also, but you will have to pay for the accommodation and all these other things that I'm booking. I'm not doing it for free. But classes, I am going to teach you the music. That you don't have to pay, no problem. So she says, okay, no problem, all that. So they're supposed to leave November 15th, 16th or something. Then the Anirudh is calling. Where are you, da? Where? What happened? Come. This, the Tamil is now, no, sorry, I cannot come. Exam. Foundation exam is there. I cannot come. Anirudh is like, but I have planned everything, and like you, there are many very good singers also. All of you are going. It will be a good exposure for you. You only said you will come. Yeah, but now I will not come. Anirudh says, okay, I think it's your loss. So what you do is, do one thing. See, I have spent almost 3 lakh rupees on accommodation and all that. Now that cannot be cancelled. Now you are telling, please pay that 3 lakh rupees. So Tamil will be like Mohiri Bibi versus Dharmodas Ghosh. Correct, no? Agreement with minor is void ab initio. I will not pay 1 rupee also. Moiri Bibi versus Dharmadas Ghosh. Issue will go to court. Who will win? Issue will go to court. Who will win? Who will win? Yes. What? Who will win? Legend will win. Saravana. No. Yes. Who will win? Is the question. So the thing is, now the question was, agreement with minor is void ab initio. So agreement with Tamil definitely is void ab initio. But is it a necessary is the next question. Necessary is what? Yeah. Is it like just food, shelter, clothing? No. It is the wording say anything that is suitable to his condition in life. Anything suitable to his or her condition in life. The court will ask a question, what do you want to become in the future? She'll say 100%, I want to become a singer. Then why are you doing this CA and all that? Simply time pass, extra. I am doing that, that is just like a backup. So I'll become a CA and I'll become a singer. If I fail anywhere, I can come back to, that's a very smart plan. If I fail as a singer, because singer, you may be a good singer, you also need luck and opportunity, and one song can make you or you can break you. Correct? Like Legend movie, one film can break the audience. That's a different thing. Yes. Correct? Yes. So like that, one movie, like one song actually can make you so famous, or it can pull you down so badly, and from that next time onwards, you'll never get a job. So she said that's very volatile market, singing, but CA is not volatile. 100% I know my future is secure. So I am doing both, but my real future is singing. Then the judge will say, if your real future is singing, don't you think so? Training in singing and the related accommodation, etc., which relates to singing and for it is like education. Yes. So it will become like a necessary. Necessary doesn't mean food, shelter, clothing. Necessary means whatever is needed for your condition in life. If you are simply a CA student, training in singing for you necessary or luxury? Luxury. But if you are actually a singer who wants to also do CA, then training in singing will be necessary. If you are a CA student, KS Academy classes will be necessary. That's why if you are a minor and you don't pay fees to KS Academy, if you tell Moiri Bibi versus Dharmadas Ghosh, KS Academy will slap you and will tell Roberts versus Gray. That's the case law. Roberts versus Gray. Read. Roberts versus Gray. Roberts versus Gray. Check it out. Read, please. Page number 14. Check. Page number 14. Roberts versus Gray. Roberts versus Gray. Read on the phone or here also. Don't message your boyfriend, girlfriend. 20 minutes more. Sorry, darling. 20 minutes. This stupid fellow said 12:30. It is 12:40. Okay. New promissory note, if it's written, it's okay. But old loan will never be there. Old loan is gone. No, not possible. Because that agreement itself is void. It is no contract only. So when there is no contract, what will you accept? Nothing can be accepted. Yes? Education loan will always be done in the name of the guardian. It's not in your name. It will be in your parents' name. That's the thing. Parents' name it will be, and they will take a lot of security. See, estate is liable, no, for necessary. Isn't education loan necessary? Yes. So they'll ask you to keep some security. They'll not simply give like that. They'll ask you to give some security. I have given many education, and I have signed on documents. I have not given. I have signed on documents where they have gone to banks, and parents have to give their house and all as security. No choice. House, gold. Basically, the money that you will give, that will be more than the money that, like gold valued 3 lakhs, they will take and give a loan of 1.5 lakhs. So then, even if you don't pay, I will sell the gold. Just like that, they'll not give any loan for students. That's what. That also they will take. After you start earning, they will take a bond, written bond, a contract. And after you start earning, collateral is not in it, but that is only collateral, no? Once you get a job, which they'll know that you become a CA and you'll get a job. So that they will take already a security. that you from your salary you should pay, and that's an actual agreement that they will take, which will they'll again do it after you become a major again. Fresh agreement will be made. So all that protection is there, no tension. And for 2 to 3 lakhs and all, they'll not do so many things also. But yes, that is how it is. Anyway, read. What is the answer here? Held G was minor. Liable, not liable? You will write G was liable. No, G was not personally liable. G was not personally liable, but yeah, was not personally liable. But his estate was liable, and this as the education, as the what do you say, training in billiards. Training in billiards was what? A necessary. Was a necessary. Training in billiards was a necessary. Training in billiards for you will be a luxury for us because you are doing CA. But training in billiards for a person who wants to be a professional billiards player, obviously it will be a necessary. So if you want to become a singer, singing practice, singing training will be a necessary. But if you are a CA who's singing, bathroom singing, where everyone will run away, that is what? That is a luxury. Luxury for you, pain for others. Yes. So Roberts versus Gray. Roberts versus Gray. Next one, Nash versus Inman. Answer. Roberts versus Gray, you have to remember the name. Nash versus Inman, not needed. Read the case and tell me. Nash versus Inman. Answer. One word will tell you that it is not a necessary. Which word? One word will tell you that it is actually luxury, not a necessary. Which one? Fancy. Over there only. Anything that is fancy can never be your necessary. Right? So, minor was a student, bought 11 fancy coats from N. He was at that time adequately provided with clothes. Held not even a single coat was a necessity or necessary. His properties could be attached, could not be attached. Could not be attached. Could not be attached. For its payment. It is immaterial whether the other party knows this or not. It is immaterial whether the other party knows this or not. Nash versus Inman. Right, next. Sound and unsound mind. If you are generally unsound, occasionally sound, can you enter into a contract when you are unsound mind? No, you can enter into a contract only when you is of sound mind. But when you are generally sound, occasionally unsound, you cannot make a contract when he is of unsound mind. Will this happen suddenly or, there? Yes, it happens. Now, you would have some 11th and 12th and in BCom, you are attending BCom class or not? Attending classes or only, okay, 11th and 12th, I am sure you know in school, there will be one mental teacher. Generally, suddenly he'll be silent, he'll be talking, suddenly he'll rise, hey! Like that he'll tell. He'll be talking, dear students, this is how it is, A plus B, hey! Why are you talking? Correct? Then you will tell, mental fellow. Is he like that? Generally sound, occasionally unsound. Is it like that? No. This sound and unsound, you calling somebody mental fellow will not make him mental. Who should declare? Court. That is most important thing. You call mental fellow somebody will not make him mental. It should be what? There will be one teacher like that, 100%, yes or no? In your life you would have seen. Correct? In that PT teacher sometimes. PT teacher. One period will be there for us to play. That fellow will come. First he will make you sit for 5 minutes. Correct? Then he will be seeing everybody who will talk, who will not talk. And then only he will send you outside. And there outside he will not allow us to play any game. He will play some stupid march past he will make us do. Yes or no? Like that some fellow will be there. Some fellow sadistic pleasure he will get of torturing students. Yes, otherwise any one teacher 100% in your life you would have seen one teacher who is like on little crack. So nothing can be done. So if you see little generally unsound, occasionally sound is unsoundness of mind. Unsoundness of mind is a medical condition. You and I cannot decide. Just because one fellow is short tempered, all that doesn't matter. Now in CA I had one teacher, if you switch on the AC, he used to get mad. Sometimes he used to tell switch on the AC. When he wanted, he used to switch on. I'm like, what is wrong with this guy? He was a brilliant teacher, no doubt. But then suddenly used to get, anybody switches off the AC, gone. Full, he used to go to another level only. Crazy. So like that, some fellows will be there. Can't help. So medical condition, generally unsound. Then occasionally sound and all those things. Enter into a contract when he is of sound mind. Generally sound, occasionally unsound, we've seen. Now these three words, again in the exam, and if they ask you, you should know what it means. Lunatic means what? Half mental. Lunatic is half mental. Sometimes he'll be okay, sometimes he'll be not okay. Half mental is called lunatic. And you and I cannot declare. Court will declare him to be lunatic. Idiot is full mental. Correct? A person who has completely lost his mental balance. After Legend movie watching, yeah, we'll become lunatic, yes. Who has completely lost his mental balance. That is called idiot. Correct? Idiot and lunatic. Lunatic is what? Intermittent intervals of sanity and insanity. Who is a drunkard? Yes, who is a drunkard? Vimala, okay. Kishore, okay. Who is this drunkard? Drunken person is similar to lunatic. He will have, obviously, some phases when he is completely out. He'll have some phases of, rational mindset. He'll know what he is talking, otherwise not possible. So, in the exam, what will they say for a person who is completely like drunk? This you should remember. Some words they'll give you. One is inebriated condition. Or intoxicated. They will either give you inebriated or they'll give you intoxicated. Correct? In Kannada they say full tight. I don't know what you say in Tamil. Same. Full tight. Tight is an English word, but that's a Kannada slang. Full tight means what? Full sloshed. He has no idea where he is. Correct? What do you call your? Mattai. Mattai. Full mattai. That is only, yes. Inebriated condition or intoxicated condition. Inebriated or intoxicated. What if you are, for example, not like fully inebriated or intoxicated? Okay, what is the opposite of inebriated? What? Yes, sober. Experience and all are telling now. Sober. Right, correct. Sober. Sober means obviously you are not intoxicated. What is the other form of sober? They'll give you sobriety. So they'll say during periods of his sobriety, can he enter into a contract? Yes. But if he's in an inebriated condition, intoxicated condition, then he cannot enter into a contract. Cannot enter into any contract. Inebriated, intoxicated is the other thing. So these are all the things with respect to what? Capacity to contract. Moving down here, couple of points and then we'll stop for today. Free consent and factors vitiating. Vitiating means what? It is affecting. It is vitiate, not vitiate. Factors vitiating free consent, because English is a very stupid language. Obviously, why can't it be vitiate? Why is it vitiate? God only knows. So free consent and factors vitiating free consent. Factors vitiating free consent. First part of the story is what? Coercion. Coercion is what? Is it physical force, mental force, moral force? Coercion. Coercion, according to you, is physical force. Is it mental force or is it moral force? All three. Only physical. So if I just put one gun in front of you and not shoot you, will not touch you only. One gun I am holding. Is it coercion? I will not touch, I will not even touch you. I'll just hold an actual gun, put bullet in it, and I'll keep it in front of you. I'll say you have to sign this agreement. No physical force, no touching. What is this? So guys, coercion is both physical and mental pressure. Moral we'll see later. Coercion is both physical pressure and mental pressure. Definitely not moral pressure. Correct? So coercion is both physical pressure and mental pressure. Coercion in India is with respect to a property or a person? Yeah, person and property or only person? Both. So I will not touch you, but I will take away the watch given by your ex-girlfriend. Take it, sir. I don't care. Correct? Yes. I have ex-girlfriend, Y girlfriend, Z girlfriend. Take it. No problem. Yes. Sir, everything. So you take it. No problem. No. But the thing is, like, let's say you have some very, very special gift by special person has given, and they have taken it away. So then in that case, have I touched, the person as such? No. Morally, no. Mentally, no. Physically, no. But I have taken the property. 100% that also is coercion. That is also coercion. In Three Idiots movie, in before the interval scene, there is this person who's dead, that father. Correct? And that ashes he will take. Remember? Right? Ashes he will take, and they are about to put the ashes in the toilet. Now that, have I touched the person? No. I have touched the property of the person. And for him, most important thing are those ashes. Father's ashes. Correct? Now nothing can be done. Is that force? Yes. Is that coercion? Yes. He figured out where that person is only by forcing him. That is called coercion. That is called coercion. So it is what? Property. Property, person. So what is this? Is it threatening or actually committing the offense, or threatening to commit offense? Both. Even committing the offense also. If I slap somebody, that is also coercion. Threatening to slap also is coercion. So basically it is either committing the offense or what? Threatening to commit the offense. Either committing the offense or threatening to commit the offense. With respect to property, it is what? Property, I will not commit any what is that called? That word. I will take away the property from you. What is that? Detaining. Detain. Some words you should use like this. Detain. Either detaining the property or threatening to detain. Threatening to detain the property. All these things, most importantly, must be prohibited. All these things must be prohibited by the Indian Penal Code, IPC, by the Indian Penal Code. It does not matter if that particular place where this coercion is happening is in India or outside India, does not matter. What does the law say? It should be prohibited by IPC, Indian Penal Code. English law does not talk about property. English law only talks about person. So in England, me and you have gone to England on a trip. In England, I take away your father's ashes in that movie. In England, I'll take away the ashes. Can you come to India and still sue me? Answer is yes. Because it does not matter whether IPC is in force in England or not. The law says the action should be prohibited by IPC. So the action is what? Taking away the property, which is very much covered in the IPC. So do not see which place the offense is happening. If you are an Indian, where Indian laws will apply to you, and you have done it outside India, you have done it. If you are a UK citizen, then UK law will apply. But if you are an Indian citizen living in India, where Indian laws will apply to you, when you go abroad and you do something and you come back to India, that other person can still sue you, because the IPC says, Indian Penal Code, the action should be covered under Indian Penal Code, nothing else. Right? So this is prohibited by IPC. Prohibited by IPC. So that's it. Last part. Forcibly compelling a person to enter into a contract, committing an act forbidden by IPC. Both threat, not dare at, both threat to both person and the goods. In English law, it is called as duress, where it is only relating to a person, not property. Severe mental strain is called as duress in English law. In Indian law, it is called coercion. You should write coercion only. Threat to commit suicide is also coercion. Why? As per law, it is you cannot take away your own life. You can do courses like CA, but you cannot take away your own life as per law, right? Yes. So threat to commit suicide is what? Coercion. You cannot threaten anybody. If you threat also, it is what? Coercion. What is consequence? I told you that if free consent is not there in 4 items, it will be called as voidable. This, when I force somebody, is there consent? Yes. Is it free consent? No. So 4 items are what? Coercion, undue influence, misrepresentation, fraud. Mistake is not there. Mistake could be a mistake if you write. Only 4 items. If it happens, it will become voidable. So what are the consequences here? Voidable. Consequences of the coercive act is voidable. And the best part of the story is if I forced you at knife point and you go to the court and put a case against me, you have to prove that I showed the knife, or I have to prove that I didn't show the knife. Who is the person suing? You. You are the plaintiff or I am the plaintiff? You are the plaintiff. Plaintiff is going and telling me, defendant is showing the knife. So the court will say, okay, will they ask the plaintiff to say, you prove that the defendant was showing a knife at you? Or they will go to the defendant and tell, boss, you prove that you were not showing a knife. The burden of proof is on plaintiff or defendant? Defendant. Very good. Burden of proof lies on the person who wants to relieve himself from coercion. Means burden of proof is on the defendant. Burden of proof is on the defendant. There are 3 cases here. Case law names are not important, but you can read the cases at home. Very simple. You will easily understand. Case law names not important. Content is important. In the content you will read in all the 3 cases, it amounts to coercion. It amounts to coercion. On that note, we shall wind up for the day. Thank you for your patience, guys, and I apologize once again because I don't like it. Personally, I value time a lot. As you can see, time is utmost importance to me. Even in my clients also, time means time. Okay, sorry. Take care. Bye. See you, I don't know when. Tomorrow, if I have class, I'll ask them. Then again, I don't want to delay like this. I'll ask them. Make it. Yes, guys. Kalai, vanakkam. How are you doing? Doing fine. Are you alive? Okay, fine. So let's start the class. Right. There were some technical issues. Yeah. Nothing can be done. Sometimes happens. Let's do it. So where did we stop, guys? Coercion. So we were doing a subject called law, right? It's there in our syllabus. Yeah. So let's see. Coercion was over or to be done? Done. Coercion was done. So quick revision. What was coercion? It is physical force or mental force? Both. And what do you say? What happens to the it is threat to property or person? Again, both. And is it committing a crime or threatening to commit? Both. And with respect to property, is it detaining or threatening to detain? Both. But English law recognizes only threat to person, and in English law it is called as duress, whereas in Indian law it covers everything, both threat to a person and a property. So what about threat to commit suicide? Is it also coercion? Yes. Any threat to commit suicide is also called coercion. Why? Yes, it is not permitted by law to sort of, lose your life like that. It is definitely not permitted. It is not permitted by law to lose or just to take away your life. Nobody has the right to take away one's life. So that's why that is also done. Then we have seen this thing. What do you say? What is the consequence of coercion, guys? It becomes voidable. Voidable. At whose option? At the option of, yeah, the aggrieved person. So it basically the victim has to go to the court and say this has to be cancelled. So that was regarding coercion. We had seen all these things with examples and all that. Now undue influence. Undue influence is the next part. Let's see. Improper or unfair use of one's superior power in order to obtain the consent of a person who is in a weaker position. Now basically here one person will have a dominating will over the other person. So there are 2 points to remember. One is what? One person will have something called as a dominating will. What do you mean by dominating will? What is dominating will? Control over the other person. So here 2 things that we have to keep in mind. One is of course the dominating will. So 2 things to keep in mind. Is this acting funny now? Yes. 2 things to keep in mind. One, there is a what? Dominating will. Dominating will. To do what? Yeah. So dominating will means what, guys? Like between me and you. I mean, I will assume that I will have a dominating will. Sir, that and all you won't have. I know that. But I'm just saying, assuming that I have a dominating will over you. So can I use it? Having a dominating will is good or bad? No. Why? Having a dominating will is good. People can positively influence you. So having a dominating will is always good. So basically, for example, doctor and client will be there. Doctor and patient, that is. Is it good to have a dominating will? Yes. You will blindly listen to the doctor. Doctor has saved your life so many times. So dominating will is actually good. But what is the problem? When that person misuses that power. So if you go to a doctor and rather than giving something which will cure your disease very soon, what he does, he keeps on, yes, giving wrong diagnosis, giving wrong medicine, so that he will have some deal with some pharma company where they will say, sir, you please keep giving this medicine, this is a little wrong medicine, and not wrong medicine, just not so effective, so that the patient should keep taking a longer period to sort of take this medicine, and even I will give you money. Many times it happens. If you have seen recently Dolo was charged. Dolo 650 was charged by, everyone was telling that they have taken money and they are using it. All the doctors, Dolo has spent how many crores? 1000 crores. Dolo has spent 1000 crores to do what? This giving kickbacks to the what do you say, giving this extra money to whom? To the doctors. What do you mean by kickback? Kickback means bribe. They have given bribe to the doctors, and what is doctor doing? He is going and telling, please buy Dolo. During what do you say, our COVID second wave, everyone had Dolo only, no? We were having Dolo like we were having some poriyal. Rice and poriyal, instead of poriyal, Dolo poriyal, correct? We used to have like that only. So the thing is, most important thing is, yes, it is obviously one is having a dominating will. Oh, this is acting funny. One is having a dominating will over the other, correct? One is dominating will over the other. The other thing is what then? Dominating will is okay. What is the other point? Having an unfair advantage over the other party. Unfair advantage over the other party. Let me just restart. It's okay. But yeah, unfair over the other party. I'll keep giving you examples, so no problem. So one is a unfair advantage over the other party, and the other thing is what? Having a dominating will. Dominating will is okay. Dominating will is actually, what do you say, okay. But what is the problem? Having an unfair advantage over the other party. So if you see below in the notes only, there are many things. That is what, who can, I mean, the law will presume that you have done undue influence, or you have to prove. Yeah, so basically 2 things should be there. Having a dominating will is absolutely okay. Thank you. Having a dominating will is absolutely okay. But what is not okay? Taking advantage of that is not okay, correct? So if you see, two things are there, write down there. One is what? There are two items to remember. One is what? Dominating will. One is dominating will. Two things that you have to keep in mind. One is dominating will. You have to keep two things in mind. One is dominating will. What is the other one? Yes, I mean that is using that will to obtain an unfair advantage over the other party. One is dominating will. One is dominating will. One is dominating will. Second is what? Using that will to obtain unfair advantage over the other party. One is dominating will. One is dominating will. Second one is using that will to obtain unfair advantage over the other party. Now, is that allowed or not? No, that will not be given. Dominating will is okay, but using that will to obtain unfair advantage over the other party is absolutely not allowed. So, did you write that down? One is dominating will, other one is what? Using that will to obtain unfair advantage over the other party. Using that will to obtain unfair advantage over the other party. That is 100% not allowed. That is not allowed. Using that will to obtain unfair advantage over the other party is not allowed. So, see these examples, guys. In these examples, undue influence is presumed. Means what? No need to prove. If, for example, a religious guru, this was also there. Have you heard of this guy called, you know Nityananda anyway. So Nityananda was obviously, many people went and told that we were just blindly following Nityananda and he has cheated us so many times. That is one part of the story. And there is one more guy called Ram Rahim Singh Insan. Have you heard? Ram Rahim Singh, such a long name. Ram Rahim Baba. So if you see this guy, Gurmeet Ram Rahim Singh Insan, this fellow, he made a movie called MSG also, which became a super hit because he has crores of followers, not one or two, crores. Imagine, he has crores of followers, guys. Ram Rahim Singh Insan is his name. What did he do? He did undue influence. He started going to these families and telling, I am the real God, you can send your children here. And he started, unfortunately, he raped a lot of people. And in his ashram, there was a secret passage between his room and the ladies' hostel, ladies' room there. And this is the most shocking thing. The more shocking thing is what? In his ashram, below his ashram, there were around 252 skeletons found. He had killed 252 people. Now he is in jail. All that he used only using undue influence. He used to convince the parents, you should sacrifice your children. Imagine. And people used to believe. Because they thought that he was God. So all that happens in our country, guys. I am not telling some story. These are all true stories. Right? So this is what? Again, 2 points to remember. One is, and having a dominating will is okay. But using that will to obtain unfair advantage. Using that will to obtain unfair advantage is something that obviously is different to understand. So having a dominating will is absolutely okay. So no problem with that. Having a dominating will is absolutely okay. But using that will to obtain an unfair advantage over the other party is something that we need to keep in mind. Using that will to obtain an unfair advantage is something else. So if you see, that is going down here further, check this out. See this. Read this please. In these cases, undue influence is presumed. What do you mean by it's presumed? Undue influence is presumed in this means what? Assumed to be already there. Yes, in these cases, undue influence is assumed to be already there. For example, if a doctor goes to the court, patient goes to the court and said, doctor performed undue influence on me, court will agree or court will disagree? Court will agree. Then who has to prove that they did not do undue influence? doctor. So in the left side cases, in all the cases on the left, in everything on the left, who has to prove? Who has to prove? Yes, correct. The defendant has to prove. In the cases on the left, all the cases on the left, the defendant has to prove. In these cases, the pen is acting funny today, right? So who has to prove? The defendant has to prove. What about the cases on the right then? The plaintiff has to prove. So the cases on all the right side, the plaintiff has to prove. Only there are three cases. What are the three cases? One, creditor and debtor. Second, landlord and tenant. Third one, husband and wife. Yes, in these three cases, who has to prove? Yes, plaintiff has to prove. Plaintiff has to prove in these three cases. So that is what it is. Plaintiff has to prove in these three cases. So there are many cases that are important, not the name, guys. So go down if you see all these cases. Mano Singh, I know the screen is not there. I need to just check this tablet why it's not working. So what you can do is you can read rather than wasting time. Please read those cases. Case law names are not important. Case law names are not important, but you will get an idea as to what is undue influence. So please read those cases. I'll just probably update this driver and then we are good to go. Just check that once, guys. Today is issue day. Yes. Please read that once again. This is not some problem, is there? I'm just checking. Did you read all the cases? Okay, so you go to this below. There is one chart with respect. We'll come back to undue influence. Just go to this summary chart. 3-4 pages later, there is a summary chart on what? Coercion, undue influence. Page number 19. So check that summary chart. We still have to do fraud, I understand, but check that. coercion is voidable, undue influence is also void or voidable? Voidable. But you see, mistake. What do you understand by the word mistake? Mistake is of two types. One is mistake of law, mistake of fact. What is mistake of law? What is that? Okay, appropriate laws are not exercised as per the content. Mistake of law, there are two things. Mistake of Indian law, foreign law. What do you mean by that? Mistake of Indian law, foreign law. What do you mean by that, guys? Mistake of Indian law, foreign law. What do you mean by that? Sorry? Indian law means what? Can I make a mistake of Indian law? Like, for example, I am going on the street and suddenly this mama will catch me. Correct? I am not wearing helmet. He'll tell, give me 500 rupees. Can I say, sorry sir, I did not know that I should not have, I should wear helmet? No. So, yes, there is one Latin dialogue. What is that? Ignorantia juris non excusat. Ignorantia juris non excusat. Correct. Ignorantia juris non excusat. There is a thing that we need to understand. Ignorantia juris non excusat. So, what is that? What does ignorantia juris non excusat say? Ignorance of law is not an excuse. Correct. Ignorance of law is not an excuse. Can you ignore law? No. Ignorance of law is not at all an excuse. That is what they try to say. Next, what did we see apart from that? Mistake of Indian law is that. Mistake of foreign law means what? Okay, before that, come to the left hand side. Unilateral mistake, bilateral mistake. What is unilateral mistake? Yeah, one person makes a mistake. What is the example of unilateral mistake? What do you mean by unilateral mistake? Anything? What is unilateral mistake? One of the parties make mistake is unilateral. Okay. Means what? Example. What is unilateral mistake? Your, what do you say? Mom will say, go and buy rice. And she'll specifically take, go and buy, normal rice. Basmati rice only when relatives come. Right? When you go for your daily thing, what? Normal rice. You will go and buy basmati rice and come. First you will get slapped. After that she'll say, go exchange and come. When you go down, that fellow says, sorry sir, no exchange. Then many shops have that no exchange policy. Then what will you do? Will the contract be valid or invalid? Invalid, really? Can you go and cancel the contract when you made a mistake? No. Unilateral mistake, contract is valid or invalid? 100% valid. In unilateral mistake, contract will be 100% valid. In unilateral mistake, contract will be 100% valid. Can you cancel any contract, guys? No. Why? Why can't you cancel any contract in unilateral mistake? Can anybody tell me? Why can't you cancel contract? Unilateral mistake, contract cannot be cancelled. Why? Why? Because the mistake was done by whose side? Mistake was done by one person's side. It was not done in the other person. So it's a unilateral mistake. You by mistake went and told that I want this. Right? It was totally on your head. You did not, even think of what would the other person, what if the contract gets cancelled? You did not think. Now, if you say, I want this rice, what do you say, Sona Masuri, basmati rice, you have gone and made a mistake from your end. Can you cancel the contract? No. But if he agrees, okay, let me replace, then it's on him. If he agrees, that's a different thing. But if he doesn't agree, what can be done? Nothing can be done. Absolutely nothing can be done. Gone. So, mistake of Indian law is what do you say? Mistake of Indian law, nothing can be done. Mistake of foreign law, we'll come to that. Unilateral mistake, what to do with unilateral mistake? Contract is valid or void with unilateral mistake? contract is valid. Unilateral mistake, contract is valid. Unilateral mistake, contract is valid. What about bilateral mistake? Bilateral mistake, contract is valid or void? Void. Bilateral mistake, contract is void. Why? Yes, bilateral mistake means what? No consensus ad idem. No consensus ad idem. What do you mean by consensus ad idem? Meeting of minds. So in a bilateral mistake, there will be no meeting of minds. In a bilateral mistake, there will be no meeting of minds. There will be no meeting of minds. In a bilateral mistake, absolutely no meeting of minds will be there. In a unilateral mistake, however, there will be meeting of minds, but still, the thing is, you will goof up by telling something. You will not give the correct picture. That is the problem with unilateral mistake. So what is bilateral mistake? I want to sell my mobile phone. As I told you, 2 mobile phones will be there. I want to sell 1 phone. You want to buy another phone. That's the problem. So what I intend to buy and what you intend to sell, or rather what I intend to sell and what you intend to buy are 2 different things. So that is the concept of unilateral mistake and bilateral mistake. So in bilateral mistake, is the contract valid or void? In a bilateral mistake, is the contract valid or void? Void. Unilateral mistake, what happens to the contract? Yes, in unilateral mistake, contract will be valid. It will definitely be valid. Bilateral mistake, contract will be void. Is it void ab initio or just void? Is it void ab initio or just void? It is void. Yes, it will be void. Now, just go to the other. I'll just show you one more thing. You just read that. I want you to answer that question because you know what is fraud already. But what is fraud? Intentional misrepresentation. So until I just figure this out, give me 2-3 minutes. But solve this question. Page number 17. Page number 17. 4 marks question in CA Foundation. It is Sohan induced Suraj. Page number 17. 4 marks question. Sohan induced Suraj. Kindly solve it. Sohan induced Suraj. Sohan induced Suraj, that case. What is the answer, guys? Is it a misrepresentation? Really? Suraj wants to rescind. Rescind means cancel. Possible or not? No. Why? He accepted? Before the repair, he could have rescind the contract. Did he do it? No. So, what is the answer? Can he rescind the contract? No, because that time he didn't do. No. He could have done it before, but now he did not do it. That's why possible or not possible? It is definitely not possible. Why is it not possible? Because obviously he could have cancelled it that time only, but he did not. He chose not to cancel. Why did he choose not to cancel? Because of the fact that the other fellow came and said, why don't we try this? So he said, okay, let me try that. He said, let me try. But eventually that same thing happened. He could not try it, and he said that, okay, let me do that thing where 40% I will pay. So anyway, there are two contracts said. First contract is what? The word induce. What do you mean by the word induce, guys? Induce means what? Is it like negative connotation in BCR? Is it negative connotation or positive? Induce. Induce is 100% negative connotation. Induce is 100% negative connotation. So induce is a good thing or bad thing? Bad. So I am trying to cheat you. That is called inducing. Inducing means trying to cheat. So when I induce you, one fellow induces the other person to buy the vehicle, and he knows that that vehicle is not good. Later he comes to know. Could he not have cancelled the contract immediately? Yes. But did he choose to cancel or choose to continue? He chose to continue. So then what happens if you choose to continue? New contract. How did he choose to continue? Because the other fellow gave another offer now. You get it repaired. What I'll do is I will give you the 40% I will give you. So repair the contract, I will give you 40%. Now is that correct or wrong? 40% I am telling that I will give you. Correct or wrong? He could have cancelled the contract, but what did he do? He decided to accept the contract. And he accepted the contract, and what happened to that contract? It became valid. The old contract is no longer there now. Old contract is no longer there because the new contract he, like a fool, accepted. Once you accept the new contract, what happens? Old contract will continue or not? No. He could have cancelled that time only, but he chose not to cancel. What happened by choosing not to cancel? Yes, he will have to bear the loss. And did he have to bear the loss? Yes, he definitely had to bear the loss. No choice about it. So that is the case with respect to Sohan versus Suraj. Sohan versus Suraj, that is what happened with him. He could have borne the loss, but he chose not to do so. He could have cancelled the contract, but he chose not to do so. He went ahead with another contract or another new offer which that person brought about, and that is what happened to it, unfortunately. Nothing could be done. Then next, what do you say? That was regarding the question. The previous question you solved, Smith versus Chadwick. Try to solve that question. Is it there? Yeah, previous one, Smith versus Chadwick. Smith versus Chadwick. Smith versus Chadwick. Answer. Why? information was not at all required, or he didn't rely on that information? Yes, he didn't rely on the information. So basically here, did he rely or not? Basically, if in the what do you say, concept, there are, in a prospectus, what all details will be there? Directors details, financial details, so many details will be there. I never relied on the directors details and then went ahead and bought shares of the company. Tomorrow they came to know that one of the directors name was inserted wrongly. So did I rely on the directors, did I rely on that information before? No. How can you claim that it is fraud or misrepresentation when you never relied on any such information? That was the concept. You cannot, how can you claim that yes, you have been cheated in the first place when you never relied on the information? The court asked one simple question: sir, when you were buying the shares, reading the prospectus, did you read about the prospectus? Did you read about the directors? He said no. And now director's name is changed. Does it matter to you? Actually no. Initially also it never mattered. Now also it didn't matter. And now you are telling fraud. There may be fraud, I understand, but did you rely on the fraud? No. So if you did not rely on the misrepresentation, how can you claim money? So that is Smith versus Chadwick. That is Smith versus Chadwick. You cannot claim. You cannot claim anything. Cannot claim anything. So one foundation question recently you can write, because I need to check this. I don't want to waste time also, which is obviously part of your syllabus, and let's see how you will write now, because I'll time it also, guys, 5 minutes or whatever, depending on the question. 4 marks means 4 into 1 point, how much? 6. 4 into 1.6 is what we will time. Just let me see. Examination question only I am reading. I will show it to you, no problem. You can see it and answer. This is which paper? Not, definitely not your paper, as in not when you wrote, not that paper. Let us see. One person company, define consideration. Okay, let me use this. 3 marks question, how will you write? Check this question, guys. 3 marks, how will you write? First is 3 marks, second is 3 marks. So first write only this 3 marks question, it's okay. Solve. Actually write and solve. I am timing it. 3 into 1.6. 4.8 minutes. Solve. This is December 19 question paper. Answer is very easy. Let's see how you present. Right, guys, right. Provisions, analysis, conclusion. Like that you should write. First is provisions of law. It's okay if you don't know the section number. First is provisions. Then it is analysis. Third is conclusion. Then one of you will read the answer. Then I'll tell you what mistake you did. That's how you can learn. I wanted to do this in the next session. Now because of this technical issue, I'm doing it now only. Later I'll do the classes. Just 5 minutes. Start. Sorry. 1 second. This one. Yeah, it's on the group also, you can check it on your phone. Check it on your group, guys. Did you get? He's sending. Please solve. I shall figure out the technique. Anybody? It's okay, don't be scared. Tell me, what have you written? There is still some problem here, we cannot help it, we'll have to manage today one day. Come on, tell me. What have you written? Read. First one, which question was that? Let me open the question for you. Yes, tell me, what have you written? First, provisions, analysis, conclusion. Tell me. Okay. Okay. No. This the facts of the case. Okay. Have you written the provisions first or facts? First facts and then provisions. Okay. Facts should you write for a 3-mark question? That is the first question that I want to ask you. Should you write facts and waste time if it is a 3-mark question? No. Directly we can start off with provisions. Read the provisions. Okay. 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 Then personal liability. Personal estate. Okay. Cool. Conclusion. Perfect. So initially, that facts of the case you can avoid because it's just a 3-mark question. 5 minutes. You can first write the provisions as per the Indian provision. Provisions of the Indian Contract Act. So and so. Write the basic provisions in your own words, and then you can go ahead with the analysis and conclusion. Facts of the case is a waste of time. It's like copy pasting the same thing. They have already given the facts of the case, so do not waste time. It will annoy the evaluator. Evaluator will be like, what the hell? He's copying the question. This is a tactic which you use in BCom. Alright? Yeah, in BCom we use this tactic. Active voice, passive voice, inner voice. What is active voice? I am writing the exam. Passive voice, exam is being written by me. In CA exam, inner voice, next attempt guaranteed. Right? That inner voice will come. So yes, come again, CA. So that's what it is. So that should not be there. Cool. Very good. Anybody else wants to read? Anybody? Yes, boss. Tell me. What's your name? Shreya, tell her. Little loud. Okay. One second. The mic is there. You speak because everyone will also understand what you have written, and also we all can learn. That's why. Read. This fellow, why, all that will be thinking now. No, but read because it's important. How to write. Others you can evaluate, guys. Come on. Read.
Provisions. As per Indian Contract Act 1872, a person who is below the age of 18 is a minor and the contract entered with him is void ab initio. It cannot be enforced in court of law. But when a minor borrows for his personal use, his properties is liable for his acts. He is no way liable when he attains majority also.
Okay.
Conclusions. The lender cannot sue him as he was a minor when he get the loan, but he can sue the property of the minor as his property is liable as per the provisions.
Why is property liable? Is the property liable? Even is his estate liable? No, this is not a necessary. So that would be a wrong answer. First part is very good. But then you should connect it to the question. You should say this, in this particular case, X was age 60. That facts of the case you wrote, no, instead of that, you should analyze, saying that in the given case, Mr. X, X was age 16 years, he borrowed a loan, 50,000 rupees. This is void ab initio. Like that, you should connect with the question. In your answer, there was no connection only. However, the first part was excellent. The provisions superbly were written. But the thing is, the personal purposes, his property is definitely not liable also. Why will his property be liable? Property will be liable only for what? Necessaries. Is this any necessary? No. Correct? So actually, because of that, no, you will actually get some 1 mark. That's all, unfortunately, because your conclusion was wrong. Conclusion was wrong, and it was conceptually also wrong. It's not that some wordings that you wrote wrong, but the first part was really good, where you have written the provision. So for the provisions, I would give 1 mark, but the analysis was not there only, and conclusion also was wrong. So just 1 mark, and if that fellow is in a bad mood, 0. Unfortunately, because the thing is, you have not connected it. In the end, the answer is completely wrong. So that sense of the term. Next, what about the second question? Anybody? J contacts to take cargo, afterwards declare war. What will you write? Anybody? Yes, pass on the mic, pass on the mic. Last. Read down. That fellow will start singing song now. Yo boys, I am sing song. Tell the second question. Read.
As per the provisions of Indian Contract Act 1872, at the time of making a contract is valid, but the performance of a contract becomes void due to the wars of two countries. Void contract is not having any legal effect and cannot be enforced in the court of law. As a result, in this case, K doesn't suit case against J.
K cannot. Okay, but again, very good. The provisions were perfect actually, but analysis only was not there. So always remember, guys, you should have 3 items. One is what? Provisions, analysis, conclusion. It's full dancing. Kindly adjust. Provisions, analysis, conclusion. First should be provisions. You have superbly written. Then analysis, I am seeing that none of you are writing any analysis here. This should be, analysis should be there. No, in this given question, J has contracted to take has contracted for a cargo, which unfortunately the one country declares war against the other country. So this, as explained above, this would amount to a initially which was valid contract, later it becomes void. That part has to be written. So how they'll give is, first provisions 1 mark, analysis 1 mark, conclusion 1 mark. In his case, conclusion was wrong, so gone. And analysis was not there only, so 0. But the first provisions were correct, 1. But some evaluators will think provisions he has written, but his analysis only is wrong, so 0. Some mental fellows will be there. Nothing can be done. But ideally, you should give 1. Provisions 1, analysis 1, conclusion 1. So good, very good, man. So his provisions is excellent. Analysis he didn't do only. So for that he will not get marks. Conclusion is also okay. So maybe 1.5. 1.5 is what you will get. But if you really want 2.5, you need to write provisions, analysis, conclusion. And we cannot take more than 3 into 1.6, 4.8 minutes. Okay, 5 minutes. Cannot take more than that. This is to read the question, understand the question, assimilate the answer in your mind, and then write the answer. So all these things should happen in that. Yes, you want to read? Sit. Sit down, it's okay. Too much respect all is injurious. Yes. Yeah. Which one? Okay, good question. She's asking if the amount that is there is unspent or not spent. Can the person get the money back? Yes. Which case is that? Yes, specific relief act. But the thing is, for a 3-mark question, need not write that. If it was a 4 to 5-mark question, as a note we can write that. Kangul versus Laka Singh. No need to remember the name of the case, but you can say, as per specific relief act, if the money is traceable, then you can return the thing. Yes. Sorry? No. You can write it for anything. It was held in a decided case law, Mohiri Bibi versus Dharma. Even this also you could have written. You could have said this, agreement with minor is void ab initio, within bracket, Mohiri Bibi versus Dharmodas Ghosh. You can write. But I did not suggest that because actually it was just a 3 marker. If you had written, it will add weightage, no problem. But do not waste time writing the facts. But do not write the analysis also. Analysis is very important. Analysis is linking your provisions to the question. That doesn't mean copy pasting the question. No. That means that you are saying in the given question, this had happened. Like in this given question, X had borrowed 50,000. And since he was a minor, it is void ab initio. Provisions, they will only check 2 things. One is agreement with minor is void ab initio. Second, a minor cannot ratify the contract upon attaining majority. One is agreement with minor is void ab initio. Second, cannot ratify the contract once you attain majority. 2 things have to be written. If you have written that, superb. Very good. See, now you know 3-4 different answers we saw. But if you see, the marks cannot be maximized. So to maximize the marks, you need to write the same way. One, you will get direct questions like this, guys. Direct questions like this. This though you will not write what provisions you will write. You will just write the questions in pointers. But when case study questions come like this, case study questions, then things will change. So you need to write something more. I wanted to do it in the afternoon session, like 10:30 to 12:30 session, but because of this problem, we have to do it now. No problem. I hope you understood. This is what you write. Now let's move on to our concepts. I am sorry for the technical problem. Sometimes happens. Really cannot help it. We came on time also, but then these problems are, it all happens. No problem. It's okay. Sometimes you have to adjust. Yes. So undue influence. 2 things. What points to remember as I discussed? One is having a dominating will. It will all dance and show now. Having a dominating will. Stupid thing, now it's working. Yeah, dominating will. Second one is what? Use of such position to obtain unfair advantage over the other party. Unfair advantage over the other party. Unfair advantage over the other party. I already ordered one new tablet also. It is going to come today. On Amazon I ordered. Yes, because I can't trust this, guys. Again, if it goes means who will bloody wait. It's okay. General Indian mindset, I think, shall I cancel the order now? But then I was like, what if again in 5 minutes this will again, I cannot keep you waiting. It's okay, it will come today, 1 o'clock it will come. New one, Wacom. Wacom is the actual very good tablet it is for writing, drawing and all that. Yes, how much? I think some 6-7K. I think it was 6,000. I didn't even see, I just ordered because I don't want to waste this nonsense. If it's 30-40K and all, I would have seen. 7-8K and all is what it is, nothing. Yes. Yeah. Alright, so dominating will is one. Use of position to obtain what? Unfair advantage over the other party. Case Academy address I have given, so it will come there. Alright, so use of such position to do what? To obtain an unfair advantage over the other party. Yes. So now you see these 3 things. A person who is deemed to be in a position to dominate the will of the other. Who is a person who is deemed to be in a position to dominate the will of the other is this. Where he holds a real authority, apparent authority. What is real authority? Parent and child. Parent and child is real authority. What is apparent authority? Apparent means when you see, you will feel that okay, there is authority. For example, teacher and student. So I'm just giving you an example. Law says real authority. Real authority means parent and child. Apparent authority means teacher and student. Correct? Yes. Or where he stands in a fiduciary capacity. See, again went. Fiduciary capacity. Fiduciary means what? Fiduciary means from the word fide, which means faith. Faith, correct? So fiduciary capacity will be anybody in a person of faith. For example, doctor and patient. Then lawyer and client. Chartered accountant and client. When a CA comes, when a person comes to a CA, he will blindly trust the CA. You cannot misguide him. If you misguide, it's going to be a problem. So next is fiduciary capacity. So having a dominating will over the other is absolutely okay. I do not have a problem if you have a dominating will. What is the problem? Misusing that trust and having an unfair advantage over the other. Second one, where he makes a contract with a person whose mental capacity is temporarily or permanently affected by reason of age, illness, mental or bodily distress. Means what? Generally, when you are sick and your mom takes care of you or anybody takes care of you, won't you feel nice? Yes, 100%. And in that, when you are completely down and out, if anybody offers something that they want something to buy, etc., you will blindly go and give it to them. That's how it is. So, where the makes the contract with a person whose mental capacity is temporarily or permanently affected by age, illness, mental or bodily distress means what? That person will be so down and out. That person will be so down and out that something, you will obviously do in such a way. For example, let's say you are almost dying and your long lost brother will come to you and say, let me look after you now for a while. So it happened with my distant relative. He was not talking with his brother for almost 20-25 years. Suddenly when he was on his deathbed, or basically he was sick, suddenly that brother came and he started looking after him. So my distant relative felt very nice. That brother has come after so long. He has forgotten all about the past and is helping me. And then towards the end, and this guy who was about to die was very rich. So now we know why he came. Suddenly he came and he looked after him for 1 or 2 months. After that, slowly he said, see, I have looked after you. I will also look after your property. Correct? When you are not there. Anyway, it's in the family only. No, we are all together. All that nonsense he started. Now tell me, is this correct or wrong? Yes. So my distant relative understood this, thankfully. And he actually slowly came out of that situation. So that time I realized this is the example of undue influence. Coercion, on the other hand, we know. Coercion, force. Whereas moral pressure, physical pressure is which one? Coercion. Moral pressure is undue influence. Moral pressure is undue influence. Physical pressure is different. Moral pressure is something else. Physical pressure, moral pressure. Undue influence. Undue influence. Now what happens to the undue influence, guys? Again voidable. All that we have seen, this we have done. Next interesting area, fraud. Fraud and misrepresentation, what's the difference? What's the difference between fraud and misrepresentation? Fraud and misrepresentation. Difference. Yes, basically we are very right. Intention. Intention is the most important thing. If you have an intention to sort of, what do you say, deceive somebody, then it is fraud. Intention to deceive is what? Fraud. Intention to deceive is fraud. And unintentional thing is called misrepresentation. Unintentional thing is misrepresentation. So if you come back here, there you go. Representation made to deceive the other person is called as fraud. Whereas if you see this down, misrepresentation, representation made wrongly, either innocently or intentionally. If it is innocently, it is simply called as misrepresentation. If it is intentional, it is called as fraud. So basically, misrepresentation, it's actually two types. One is intentional, one is unintentional. If it is intentional, it is called fraud. Unintentional, it is called misrepresentation. Unintentional, it is called misrepresentation. That is what it is. Now, are all things, what do you say? If you come back to the notes, see this definition. Suggestion act as to a fact of that which is not true by one who does not believe it to be true. Suggestion as to a fact of that which is not true by one who does not believe it to be true means what? Does not believe. Like for example, let's say you will know that, let's say you will say that the foundation exam has been in Indian language, preponed. Correct? foundation exam has been preponed to November. Correct? If I tell like that, and you somewhere you get the news, you will spread like a rumor, wildfire. It will spread. You generally, genuinely believe it to be true. I'm not saying that you know it is not true. You genuinely think it's true, and you spread wildfire like wildfire. In WhatsApp forwards, we do know some nonsense will come, will forward. During demonetization, they said there will be chip in every note, it seems. You remember that? We sat and forwarded everything. Chip in the notes. You will know where the notes will be and all that nonsense. Somebody, generally in this uncle auntie group, our parents who have no job, sitting and doing all WhatsApp university, they'll create and and keep on posting. Sheila auntie group, correct. So they'll be posting this nonsense every day. All uncles, aunties together posting all nonsense. So yes, in that case, now because of your rumor that somebody started, and then it, let's say you only started it, and you genuinely believed it to be true, by the way, it's not something that you did, you genuinely believe that to be true. Now what happened, guys? Now you will, because of you, KSA has to call each and every parent and try and convince the parent, saying that no, it's just a rumor, don't worry. So now this went to the, basically they have spent almost 25,000 in convincing. Sarasar had to organize one session also, all that waste of time and money. They figure out that you were the one who started this. Can they sue you? That is one question. Second area, you genuinely knew this was false, but you wanted to create some, fun and chaos and confusion and fear. So what you did, you planted all these messages in all the groups on purpose. Now, is it, what do you say, fraud? Yes. In which case can you sue for damages? Second case, that is in fraud case, you can sue for damage. So the difference between fraud and misrepresentation, both the contracts, if you see here, fraud and misrepresentation here, you have a right to rescind the contract. Rescind means cancel the contract. You have a right to cancel the contract. You have a right to insist on performance of the contract. Means what? You can say specific performance. You can say specific performance. For example, you are going with a tour operator in some country abroad. He has given in the itinerary, he has given around 10 items that he will finish. He has only finished 8 things. Remaining 2, he said, no, it is not possible. Is it fraud? Yes, because you had paid for 10 items. He has only showed you 8 items. One of the things was boating. So he says, no, boating has become too late. It cannot be done. You will say, boss, he'll say, sir, we'll give you refund. You will say, I have come here to experience boating also. I don't want your bloody refund. I want boating. So if not today, tomorrow morning you organize. Boating, you have taken money from me that you will organize boating. Boating has to be organized. No, sir, I'll give you a refund. I don't want refund. Because after coming so long, that lake looks so beautiful, I want to do boating. If not today, I understand today it's too late, let's do it tomorrow morning. You organize, that's all. Tomorrow anyway, we are leaving at 11 o'clock. It's okay, we'll get up at 7 a.m. We'll go boating, no problem. Now, is this valid? Yes, because you tried committing fraud. And when I actually challenged you, you then said refund. First you said, no, sir, this is not possible. Then when I actually blasted you, you said, no, I'll give you a refund. Now I'm saying, I don't want refund. I want performance. Can I do that? Yes, that is the second one. Right to insist on performance. That is called specific performance. Third one, as I told you in this example of Case Academy where you spread the rumor, right to claim damages. Right to claim damages. You have every right to claim damages. You have every right to claim damages. You can definitely ask them and ask for damages. Right to claim damages. Right to claim damages. On the other hand, you see in misrepresentation point, however, here contract is voidable, okay. Insistence on performance, okay. See here, no right to claim damages. There will be no right to claim damages. Absolutely no right for damages. Why? Because there was no intention to cheat. Intention to cheat only was not there. That's the reason can do so. Now, you see, that is the first part. Suggestion as to a fact of that which is not true. What is suggestion as to a fact? For example, exam has been preponed to November. Is that true? No. By one who does not believe it to be true. Do you believe it to be true? No, you know it's not true, but still you tell it is true. Suggestion as to a fact of which that is not true. What? Exam is preponed to November, which is not true. By one who does not believe it to be true. Second, active concealment means what, guys? Active concealment. Yeah, knowingly hiding. Simple. Knowingly hiding. Active concealment, knowingly hiding. A promise made without any intention of performing. You don't want to perform the promise only. Simply you have made a promise. But let me explain this, active concealment point with an example, which anyway it's already written here. Yesterday I was doing the same there. Active concealment. Active concealment is, let us see, try to understand that active concealment point. Active concealment point. Yes, so let us see this example. Yes, there was a guy called Vignesh. He wanted one bike. Yesterday when I was drawing this bike, current only went. Because of the way I drew, projector also got switched off. All that happened in yesterday's class. This was a regular batch that was going on. Actually, projector got switched off only, didn't come for 10 minutes. Right, that's the power of my drawing. Yes. Today, because of my drawing, the stupid Wacom only stopped working. Yes. Yes. So, Vignesh has, what do you say, has a bike of 60 lakh, some, Suzuki something. Right? Yes. Yesterday when I was telling, somebody is selling Activa, it seems. 60 lakh. So, yes. So, he has, what do you say, some Kawasaki Ninja, some bike. Assume this is Ninja. It doesn't look like that. Yeah. So, I gave a different handle also. One is like this, one is like this. See, different. Alright? Yes. So, 60 lakh rupees. 60 lakh rupees, yes. He has bought it actually, but it's a smuggled good. He did not pay customs duty and all. It is smuggled good. Obviously, then if smuggled goods is there, warranty and all will not be there. If anything happens, gone. He had bought it for 40 lakh rupees, smuggled good. Then he will sell it on OLX because he'll know that there is some problem with the engine. After every 20 kilometers, smoke starts coming out. So basically he'll be like, okay, let me sell it off. On OLX, he will put an advertisement. He will say, bike for sale, 1000 kilometers run, 3 months over. MRP was 60 lakh. Selling price is 20 lakh. That's all. Does he tell that it's in bad condition? No. Does he tell it's in good condition? No. So one more guy, Arvind, wants to buy this and he will come buying. So both of them are running. They'll not come and hug and all. It looks like that, but it is not like that, right? So, but the thing is, he will come and say, can I use it? Can I go for a round? Obviously, yes, please go. He knows that nobody will go 20-25 kilometers and they'll go some 5 kilometers. That's it. So he goes for 10 kilometers. Everything was smooth. Without asking any question, he will pay 20 lakhs and he will start the bike and go. Midway on the bridge sometime, engine, what? Everywhere, again, smoke from everywhere. He will go to a normal mechanic will say, sir, engine only gone, sir, replacement 40 lakhs. Engine is the most important thing, no? 25-30 lakhs engine, sir. So he bought only for 20, again 40, he could have bought a new bike. So he will call up Vignesh and say, boss, this is cheating. This is active concealment. He'll ask him, did you know about this? Vignesh says, yes, I knew. Active concealment. Is it fraud? Is it fraud? Yes, it is fraud. In law, there are 4 steps that you need to follow to get the correct answer. Step number 1, close your eyes. Step number 2, take a deep breath in and breathe out. Step number 3, from the pit of your stomach, one gut feeling will come. Correct? Gut feeling is from the pit of your stomach. Have you had that gut feeling? Yes, there will be that inside, from inside one feeling will come. So inside one feeling will come about law. What is the answer? Step number 4, reverse the gut. Reverse the gut feeling. So when I asked you, is it fraud? You said yes. What is the correct answer? No. This is not active concealment. Because there is one dialogue also in law. Mere silence is not fraud. This is inserted in the Indian Contract Act only. Indian Contract Act only, they have said mere silence is not fraud. Mere silence is not fraud. Why? Because one more concept in Sale of Goods Act called caveat emptor. One more concept called caveat emptor. In caveat emptor, what did they say? Let the buyer beware. They said Arvind should have asked at least one question. What question? I hope everything is okay with the bike. That's all. I hope everything is okay with the bike. If he had just asked one simple question, I hope everything is okay with the bike. That's it. Then who would have, then if, what do you say, Vignesh had told yes, then he is lying. Correct? But he didn't even ask anything. Let the buyer beware. Buyer was not aware only here. He did not even bother asking any question. So what will happen? What will happen? Yes, nothing is going to happen here. Will he win the case, Arvind? No. Because he did not ask the question. What is active concealment then? Active concealment is even after asking the question, if Vignesh is silent. Even after asking the question, if Vignesh is silent, then that is called active concealment. Here, he asked the question. He did not ask the question. Now tell me, if Arvind had asked the question, I hope everything is okay with the bike. Vignesh had said yes, then it amounts to active concealment, fraud. On the other hand, Vignesh just said, Arvind just said, I hope everything is okay with the bike. Vignesh just smiled. That smile is equal to saying yes only, no? If you don't say no, and if you simply smile, it means you're saying yes. So in this case, that smile also is like saying yes. Which means what? Silence equals to speech. Silence equals to speech. If silence equal to speech, it is fraud. Mere silence is not fraud. But if a silence equals to speech, then it is 100% fraud. On the other hand, what if Arvind and Vignesh were friends? What if Arvind and Vignesh were friends? Then what will happen? Relationship of trust will come. When Vignesh and Arvind are friends, will you ever go and ask him, I hope it's okay, I hope it's fine? No. You will trust your friend. Sir, I will not trust my friend, you will tell, I know. But yes, generally we should trust our friends. Correct? So here when Arvind is telling, Arvind is giving the vehicle to, Vignesh is giving the vehicle to Arvind. Arvind is entitled to believe that Vignesh will not cheat. So he need not ask any questions. Caveat emptor will not apply when there is a position of trust and when you know the person. So is there a duty on Arvind's part to ask, or is there a duty for Vignesh to tell? Duty on Vignesh to actually tell. No need to ask any question. So law says when there is a duty to speak, then also it is fraud. Duty to speak is also fraud. Then what is also fraud? Duty to speak is also fraud. Then silence equivalence to speech also is fraud. Both are fraud. But what is not fraud? Mere silence is not fraud. So what is the actual meaning of this word active concealment then? Active concealment means where silence is equal to speech or where there is a duty to speak. What is active concealment? Where silence is equal to speech or where there is a duty to speak. Only then it is called fraud. Mere silence is definitely not fraud. Mere silence is definitely not fraud. So that is what it is. Now I showed you that Smith versus Chadwick. You have solved it already. In Smith versus Chadwick, did you believe that the directors, who the directors were? Did you even read about the directors before? No. But today you are saying that directors are important, and just because you come to know that the company has not given directors details properly, you want to sue the company saying that you believed about the directors, but it's actually false. You never believed about any directors. You never read about the directors. So if you have entered into a contract ignoring the fraudulent thing already, can you go and say that it is fraud? No. So if you see, fourth point, some 2 to 3 mark question they can ask. This is the last part before we break. You see, loss of right of rescission. Loss of right of rescission. You will lose the right to cancel the contract under these 3 circumstances. You will lose the right to cancel the contract under these 3 circumstances. Circumstance number 2, contract in ignorance of misrepresentation. Smith versus Chadwick. You did not even know about the fraud. Just because later fraud comes, now you are telling fraud. No. You lost your money because of some other reasons. Now you are blaming the fraud concept and you want to take the money away. So contract in ignorance of misrepresentation is what? Fraud or not fraud? Even though it may be fraud, can you cancel the contract? No. Next, Sohan versus Suraj. In Sohan versus Suraj, initially you could have cancelled the contract when he said that everything is okay, but the bike turned out to be very bad. You could have cancelled the contract. Did you cancel the contract? No. Then you agree to his new terms and conditions like a fool. It's your mistake. So tomorrow, can you, after you have known about the fraud, if you yourself have agreed to the contract, can you cancel the contract? No. Point number 3. Legal language, you should write like this: affirming after knowing about the misrepresentation. Affirming means what? Saying yes. Affirming after knowing about the misrepresentation. Second one, contract in ignorance of misrepresentation. Contract in ignorance of misrepresentation. Last part before the break. If I sell this mobile phone on Amazon, no, mobile phone. I will put this mobile phone. I will say this is the mobile phone. I'll put pictures in different angles. 20,000 rupees I'll sell this for. On Amazon, have you seen products like that? Correct? Some normal bucket was 40,000 once I saw. Plastic bucket made in China. 40,000. So like this mouse I will put and I'll say it's mobile phone. Now you will buy this mobile phone. Imagine, that's the best part. You will buy this mobile phone and then you will figure out it's a mouse. See, I'm not saying I'll show mobile picture and then give you mouse. No, I'm not saying that. I will show you mouse picture, all angles I will show, and then I will claim it to be mobile phone. You believing it to be mobile phone will buy. Then you will realize it's a mouse. Can you sue me? No. Law does not provide any protection to dumb fellows who do not use even their basic common sense. Yes, more than caveat emptor. Caveat emptor, there's not even caveat emptor here, because why? It's normal common sense. You should see carefully what is being sold. At least you should open your eyes and see. See, if I have promised a mobile phone, you would have seen many times, no, Amazon, they ordered iPhone. When you opened, some brick was there. You would have seen. Now that is fraud. That is fraud because you ordered iPhone. Correct? Open, brick was there. At least if you open kidney was there, then it made sense. You can sell the kidney and buy one more. Your kidney anyway gone. Yes. So if you see, on the other hand, if you have ordered a mouse thinking it is a phone, it is your stupidity. This is the concept of unilateral mistake, single-sided mistake. Contract will always be valid. Can you cancel the contract and get the money? No. See this. Ability to discover the truth by ordinary diligence. Ability to discover the truth by ordinary diligence means what? If you have the ability to use some normal common sense and get the, product that you want, and if you can see whether whatever you're being sold is some nonsense product which is doesn't even make sense, then what? You can actually cannot cancel the product, cannot cancel the contract. They can ask you separate 3-mark question. What are the cases where even though you are defrauded, you cannot cancel the contract? 3 cases. 1, ability to discover the truth by ordinary diligence, mouse example. Second one, Contract in ignorance of misrepresentation. You have ignored totally the misrepresentation and then you again gone ahead with it. Third one, affirming even after knowing about the misrepresentation. These are the three things to keep in mind. So let's take a breakfast break. After that, we'll finish off this chapter. A lot of examples. I hope you understood how to write the answer. Right? We'll do one more later. Maybe tomorrow we will do one more. Well, one more question. I'll just pick up some random question. You only write, then we'll discuss that. No problem. Yes. 10:30 we shall meet. Might restrict. Yeah, it's coming. Alright guys, can we begin? Okay, so misrepresentation is what we were doing all these things. Mistake, misrepresentation, undue influence, fraud, all was done. And yeah, coming to this chart now here, again, so coercion is voidable, undue influence is voidable, fraud is generally voidable, but exceptions apply. What are the exceptions? Silence is not equal to fraud. Then those three examples: agreement that you have entered into after misrepresentation, that is affirming the contract even after misrepresentation is done, that is Sohan versus Suraj case, and Smith versus Chadwick case, and the mouse example. In all these three cases, it is, even though it is fraud, basically it's like an exception because you can't do anything. You cannot sue. When you cannot sue, what is the point? You cannot claim damages, you cannot do anything. It is as good as the contract is valid, honestly. So that is useless. Next is misrepresentation. Misrepresentation is voidable, as we have seen. Exceptions we'll see now. As far as mistake is concerned, there are two things again. Let me quickly explain. Mistake of fact, mistake of law. Mistake of Indian law, mistake of foreign law. And in mistake of fact, you have unilateral mistake, bilateral mistake. If you make a mistake from your side, it is called unilateral mistake. And the contract will always be valid. There are certain exceptions which we'll discuss through an example now, but generally it is always valid. So if you, as I told you, the example of rice, if your mom asks you to buy some rice and you buy some other rice, and then ultimately you cannot go cancel the contract will be valid. Mistake of Indian law. So that's what. You cannot go when a police officer will put a case against you, or rather will cut a challan because you need to pay that amount, and you cannot say, sorry sir, I did not know the law. Ignorance of law is not an excuse. Ignorantia juris non excusat. Mistake of foreign law, on the other hand, so it unilateral is not here, this should come here. Mistake of foreign law, on the other hand, will be treated as mistake of fact. Mistake of foreign law will be treated as mistake of fact, and it will be treated as what? Bilateral mistake of fact. Bilateral mistake of fact. So that would be valid or void? That would be void. What is mistake of foreign law? That is, sitting in India, if you make a mistake in framing certain provisions of law which is not applicable to your country, then they say, okay, no problem, both of you did not understand the law, foreign law, so they cancelled it. So for example, in India, can you eat jackfruit in public? Yes, you can eat jackfruit. You've had jackfruit. Can you have jackfruit in public? Yes. But in Singapore, if you have jackfruit in public, 50,000 rupees fine. I'm not joking. There is a fruit called durian. There is a fruit called durian in Singapore. So if you eat that, it's nothing like, it's like jackfruit only, but it has more smell than jackfruit. So if you have durian anywhere in public, if you have durian anywhere in the metro, 50,000 rupees fine. So now tell me, in Singapore it is obviously do not know the law. Correct? Chewing gum also. Chewing gum, spitting will be 1 day jail. Like that, if it is there, and 80% of India will be in jail if we do spitting here. 80-90% of India will be in jail. If we say for spitting, it is jail. So in Singapore, I'm not joking. If you spit, 1 day jail plus some 1 lakh rupees fine. Crazy it is. Right? So if you see, that's what it is. So if you sit in India and make a mistake about some law abroad, then obviously it will be treated as both of you don't know the law, hence the contract will be void, because you have to follow the foreign law always. If you are, especially if you are there abroad, you need to follow that respective law. You cannot avoid the you cannot say that I've already entered into a contract, let it be valid. No, it will become void. Mistake of law of the land, on the other hand, it is always valid. You cannot escape Indian law by telling that I did not know about the law. So mistake of Indian law is always valid. Mistake of foreign law is always void. Similarly, bilateral mistake where there is no consensus ad idem, it is always void. So if there is any confusion from both the sides, if now the confusion is cleared, then they can enter into a new contract. Old contract is always void. On the other hand, unilateral mistake, that is valid. Single-sided mistake is always valid, but there are certain exceptions, is what we need to see. There are certain exceptions, that is what we need to understand. In this case, all these other cases that I have given can be read on your own. That is nothing great, except for this one thing which I need to explain, and of course 2 other cases, important cases. Philip versus Brooks and Lake versus Simmons. Other things, there is nothing much to for me to add in the crash course. It is self-explanatory. If it's a regular batch, I would have explained, but in a crash course, as I told you, it's mere revision. So as far as revision is concerned, 3 important areas has to be revised again. One is Cooper versus Phibbs, then we have Philip versus Brooks, then we have Lake versus Simmons. These 3 cases have to be revised. Should you remember Philip versus Brooks? Yes. Should you remember Cooper versus Phibbs? Yes. And should you remember Lake versus Simmons? 100% yes. These 3 case laws you have to remember. Other case laws, no need to remember the name, content you just go through for your knowledge. That's it. Generally, they don't ask all that in the exam. What they keep asking is Lake versus Simmons, Philip versus Brooks, and Cooper versus Phibbs. Cooper versus Phibbs is what they keep asking in the examination. So, let us see. Anyway, let's see here. So, guys, there was one, what do you say? There was an uncle. He had his, obviously, son. An uncle had a nephew. This fellow's dad had passed away, so that's why this guy was living with his cousin and with his uncle. Uncle had a land also on his own. He had a land. Now, so 2 cousins were living together. Uncle was obviously looking after his son and also his nephew, because the nephew's dad had passed away. Now what happened? Uncle had a land also, and they were cultivating and all that. One day uncle went for a business trip and he became late uncle. Died. He also died. Correct? So true story this is. Correct? He also died. So obviously this fellow was an orphan now, and this fellow also was an orphan. They started obviously, there was a house already there, so they were living together in that house, all that fine. Now this guy had a land, right? This had a land. So this had a land where you could develop fish. Generally it's called fishery. Fishery is a land where, when I say land, it is obviously covered with water also around. So you can develop, you can obviously rear fish, you can groom fish, breed fish. So that's called a fishery. He had a factory also where all these fish and fish products, everything. So basically this guy, nephew, this fellow didn't have any interest in starting any business. This nephew told the, his cousin, see, when the uncle dies, that is this fellow's father dies, the land will go to whom? Son. So obviously there was no will, but since he was the main guy there, it went to him. So this cousin said, bro, please give me this fishery land to me. I will take it on rent. So the land was given to him, so the nephew became the tenant, or rather the cousin became the tenant, and the nephew started paying rental. He was using that land for fisheries and he was doing business. One day this nephew went to the attic of his dad's house. Attic means what? Near the roof there will be one room, storeroom. He went and checked there. To his shock, he found what? One document in which this land actually belonged to this guy. Correct? So because these are brothers, no? His uncle and dad are brothers. So this land actually belonged to this guy's dad. So obviously, who should be the real owner of the land? That guy. So that dad, after he died, who should be the real owner? This nephew. I mean, the uncle's nephew should have been the owner. Now he went to his cousin and said, "Bro, I am paying rent to myself all these years. Correct? No, my land only. You thought it was your land. I am paying rent to myself. Obviously, no. Why am I paying rent to myself? I own the land. You thought that you own the land. So I am actually paying rent to something that I own." So this contract of rent between cousins, valid or void? Valid or void? Void. It went to the court. Court also said yes, it is void, because the son did not give refund. He said no, now it came, from now you take it, from next time I will see. No next time. Whatever rent I have paid till now, please pay back. Went to court. What did the court say? Court said this is a bilateral mistake. Bilateral mistake of what? Bilateral mistake of what? Bilateral mistake of fact of the title. Title means ownership. The nephew thought that his cousin was the owner. The cousin, this son thought that he was the owner. Both did not know. Nephew did not know that he was actually owner of the land. Son did not know that he was not the owner of the land. Bilateral mistake of title. So what happened? Issue went to court and court said the contract is void. Since the contract was never there, only void, you have to return all the money. So this was Cooper versus Phibbs. Check it out. Cooper versus Phibbs. Please read. A took a lease of a fishery which, unknown to either party, already belonged to A. Held lease was void. Lease was void. Which sentence? Which sentence, man? So land already belongs to A, right? Land belongs to the son. But then this, what is nephew? What did he say? Nephew, did he know that the land belonged to him? No. What bilateral mistake happened? Nephew thought that the land was somebody else's, but actually the land was his. Similarly, the son thought that the land was his, but in fact the land was not his. It is a bilateral mistake of what? Ownership. That's why void have been. It's void. Basically, bilateral mistake. All bilateral mistakes are void. All bilateral mistakes are void. So what do you think when the a jeweler will sell jewels to anybody who walks into the company or to the jewel shop, or only to few people? Obviously, he can give it to anybody. He should give it to anybody. Anybody who walks in will get the jewels. So let us say Mr. A walked in and he took the jewels worth 1 lakh rupees, and he immediately went to a, what do you say, goldsmith, or rather a pawn broker, who will obviously buy and sell goods, pledger and pledgee. So he will take goods on pledge. So he will be a pledgee. He will take goods on pledge. He will take the possession of the goods and give money. Correct? You would have seen the pawn brokers on these streets. Which street like that is there in Chennai? Saukarpet. Yes, Saukar Pet. Saukar is from the Sanskrit or Hindi word Sahukar, which means rich fellow. Correct? So Sahukar means rich. So correct? So if rich fellow. So Saukar Pet is obviously what? People where they feel, they think, they show that they are not rich, but they'll be minting money. Correct? They'll have small shops. Correct? But if you go to their house, if you dig the toilet, there one full chest, all black money will be kept there. Correct? Yes. So that is the thing. So Saukar Pet. So on Saukar Pet, one fellow will be sitting. So this fellow will go and give that gold to him and say, give me a loan on this. So this broker will give him money. How much? 70,000 rupees. He'll give him money. This fellow will go away. You will wonder why the hell should he first buy by paying 1 lakh rupees, get a gold, again get a loan of 70,000. Why is this happening? But the beauty of the story is when Mr. A went and swiped the card, Mr. A went and swiped the card, Mr. B's account got debited. Basically, A was a scam. He had stolen B's card and swiped the card. So it has already gone to the broker, right? The question is, should the broker return the jewel? Now B comes to know, oh, money has been debited. Immediately launch a police complaint. Police will find out what has happened. Everything, they'll eventually figure out that the jewel has now reached the pledgee. Police has a great connection. The moment any gold chain is lost, they exactly know which shop in Saukar Pet it will be there. Police have super connection. Just that they don't do the job until you pay some bribe. Not all, but few. Until you pay bribe, they'll not move. But they are very smart. They know exactly which shop, which fellow in Saukar Pet does this scam business. He will know. They will immediately go to that shop and say, boss, tell me if it's there with you. So they immediately went to this broker place. They found the jewel also. The question here is, as per Indian Contract Act, should it be returned to the jeweler? 4 marks question. You'll write yes, sir. Yes, sir. 100%, sir. Mother promise, sir. No. 4 marks. What will you write? No. Oh, yes. No. No, yes. Yes, no. Then you will tell the evaluator, choose, macha. Option MCQ. You choose. Correct? You will only tell. What do you think? We should obviously tell the answer. We should write the concept. What is the answer? This contract between the jeweler and Mr. A, all this, whatever he did, was it a mistake or a fraud? Fraud. 100% fraud. And fraud is what? Voidable or valid? Voidable. Fraud is voidable. So the broker, will caveat emptor apply? Should the broker have seen, okay, now it started again. Will caveat emptor apply? Should the broker have seen what has happened? Should the broker have understood whether Mr. A is the owner? No. In a voidable contract, caveat emptor doesn't apply. Caveat emptor doesn't apply in a voidable contract. If I give you a faulty phone which doesn't work properly, technical defects are there, and then you use it and you come back to me saying that, boss, technical defects. Can I say caveat emptor? You should have checked. How will you know the technical defects? You will not know. So how will I know? How will the broker know that A is not the owner? A has given the bill. In the bill, his name only is there. How does broker know that A has used some other money? Will you have to check all that? No. If you today you give me a bill and give me your phone and say this is my phone, I am entitled to assume that it is your phone. Should I show me the bank statement where you paid the money? You had bought that phone 6 months ago. Will you show all that? No. So caveat emptor will not apply, especially when it is a fraudulent transaction. If caveat emptor doesn't apply, there is one more concept in Sale of Goods Act called implied condition as to title. Implied condition as to title. Under implied condition as to title, the broker is entitled to assume. The broker is entitled to assume that A is the owner. A is the owner. Then there is one more concept, nemo dat quod non habet. Nemo dat quod non habet. You cannot transfer to somebody what you don't have. You cannot transfer to somebody what you don't have. So in this, the jeweler does not, Mr. A does not have ownership. Can he transfer better ownership to the broker? No. But there's an exception. under Sale of Goods Act, nemo dat quod non habet has an exception. What exception? Nemo dat quod non habet has an exception. What is that exception? That in a voidable contract, nemo dat quod non habet will not apply. Means what? Mr. A, even though he is a non-owner, he can transfer better ownership to the broker. He can transfer better ownership to a broker. Which means if I have received some stolen goods, and if it is proven that it is yours only, in the sense it is, you have some documents to prove it, and even though you have obtained it through stealing it, still I will get a good title. That is as per Sale of Goods Act, because I have bought it in good faith, bona fide arrangement, especially if it's a voidable contract. If it's other contract, it will not come. So this decision, I'll make you write, don't worry, this decision is nothing but Philip versus Brooks. Philip versus Brooks. So as per this, what happened? Again, I'll repeat what happened as per this. Broker need not return the jewels. Why? Broker is entitled to assume that Mr. A is the owner. Broker need not show caveat emptor because it's a voidable contract. In voidable contract, caveat emptor will not apply. Anyway, he would have checked the bill. He need not go into the sources of funds of Mr. A. And lastly, nemo dat quod non habet will actually say Mr. A cannot transfer better ownership to broker. But there is an exception to nemo dat quod non habet. What is the exception to nemo dat quod non habet? That even though you are a non-owner, you can transfer better ownership to the jeweler. Better ownership to the broker. So Mr. A can transfer better ownership to the broker. Broker has every right to retain the goods. Jeweler has got his money. He is out of the picture. Broker will now sell the jewel and get back his money. 70,000 he has paid. No, so will recoup that money. Only person who is now affected is Mr. B. What should Mr. B do? Go to the police station and lodge a complaint against whoever has sold. So obviously they'll come to know. If they come to know it is Mr. A, then they will recover from him. Until then, nothing can be done. Got it? Yes, check it out. Read, guys. Please read. Philip versus Brooks. Philip versus Brooks. What do you think, guys? N later took the jewels which he pledged with B. Held B dash. B need not return the jewels. So there may not be space here, but write down. I'll dictate. B need not return the jewels. B need not return the jewels. B need not return the jewels. Full stop. Point wise. 3-4 points. First one. Caveat emptor will not apply. Caveat emptor spelling I write here. Caveat emptor will not apply. One more spelling. Nemo dat quod non habet. Both I'll make you write. Nemo dat quod non habet. Caveat emptor will not apply since it is a fraudulent transaction that is voidable. Caveat emptor will not apply since it is a voidable transaction, fraudulent transaction, since it is a fraudulent transaction that is voidable. since it is a fraudulent transaction, that is voidable. Next, what will not apply? Yes, next point is the final bona fide in this example. Let's see who's this fellow's name. Let's see. By check, let pledge with B. So B is entitled to assume. B is entitled to assume that N is the true owner. B is entitled to assume that N is the true owner. B is entitled to assume that N is the true owner. Because implied condition as to title will apply. Because implied condition as to title shall apply. Because implied condition as to title shall apply. Implied condition as to title shall apply. Last, nemo dat quod non habet. Nemo dat quod non habet means, nemo dat quod non habet means you cannot transfer to somebody what you do not have. Nemo dat quod non habet means, nemo dat quod non habet means you cannot transfer to somebody what you don't have. Right, full stop. However, in a voidable contract, nemo dat quod non habet will not apply. However, in a voidable contract, nemo dat quod non habet will not apply. However, in a voidable contract, nemo dat quod non habet will not apply. In a voidable contract, nemo dat quod non habet will not apply. And what? N can transfer a better ownership to B. N can transfer a better ownership to B. N can transfer better ownership to B. Yes. Yeah. Why will it apply, man? In a voidable contract, it's an exception. Nemo dat quod non-habet means what? You cannot transfer somebody what you don't have. Exception means you can transfer. That's why I said nemo dat quod non-habet will not apply. That rule will not apply. Normal English, man. In a voidable contract, nemo dat quod non-habet will not apply. Means what? English. Read aram se, you will understand. So, caveat emptor, in a voidable contract, nemo dat quod non-habet will not apply. Means what? You can transfer. That's what even I meant. You can transfer. So, can you transfer better ownership? Yes, next sentence should have written N can transfer better ownership to B. Hence, B need not return. Hence B need not return. Hence B need not return the jewels. B need not return the jewels. In this example, same example that we took, let us say jeweler, one guy called Naveen came and ordered 1 lakh rupees worth of jewel. One more guy called Naveen came and ordered 10,000 rupees worth of jewel. This guy had written, Naveen on both the things. He called both custom made jewel. Whatever that 1 lakh rupees was supposed to be given to Naveen, to whom did he give? He gave it to Naveen. And this Naveen opened the jewel and he saw, oh, this is definitely not what I had ordered. But he didn't return. What did he do? Immediately he went to the same, broker, Mr. B, and gave the thing to him, took 70,000 rupees and he ran away. This Naveen came to the shop and he realized that he had been, what he got was just 10,000 rupees one. Can he sue the company? Can he sue the jeweler, I meant? And later they came to know that it has already gone to B. Now same question. Should the jeweler return the jewels? Should the jeweler return the jewels? So now tell me, is it a unilateral mistake or is it fraud? From the jeweler's side, okay, what Naveen did later was fraud. But initially, jeweler to Naveen, was it unilateral mistake or fraud? Unilateral mistake. Unilateral mistake, what happens to the contract? Valid. Guys, if you make this contract valid, then you are trying to tell that Naveen is a true owner. And Naveen can transfer better ownership to B. It will destroy the contract act. So in this particular case, what did the court say? Though it is a unilateral mistake, I would deem it to be void. Though it is a unilateral mistake, I would deem it to be void. Though it is a unilateral mistake, I would deem it to be void. I would deem it to be void. So what? I would deem it to be void. Means what will happen now? This jeweler transferring to Naveen, it is by unilateral mistake. But as per the court case, this contract is void. Since the contract is void, can he transfer better ownership to B? No. As per Nemo Dat Code non-habet, what you do not have, you cannot transfer better ownership. Does Naveen have a good ownership? No. Can he transfer better ownership to B? No. So this case went to court and it was held that B has to return the jewels. B has to return the jewels. Why won't exception apply? Exception to Nemo Dat Code non-habet is a voidable contract. Here it's a voidable contract or void contract? Void contract. Hence it will not apply. What will not apply? The exception will not apply. And what will apply? The actual rule will apply. Nemo Dat Code non-habet. You cannot transfer to somebody what you don't have. What don't you have? You don't have a better ownership. Right? That's what. So check it out. This rule now, Lake versus Simmons. Check. Page number 19. Lake versus Simmons. Read. Lake versus Simmons. Read. So here guys, this fellow gave it to somebody who was falsely misrepresenting a wife of a well-known baron. Baron means industrialist. So the thing is, what he did was mistake or fraud? Mistake. But what that other fellow did, woman falsely representing herself to be a wife of well-known baron, she committed fraud. Just like this Naveen committed fraud. But ultimately the jeweler made a mistake. So if you see, read, same example. She pledged them with a broker who took them in good faith. Held there was contract or no contract? No contract between jeweler and woman. And even an innocent buyer or broker dash can get good title, cannot get good. Cannot get good title. Cannot get a good title. Broker dash has to return necklace, need not return. Has to return the necklace. Has to return. Has to return necklace. Broker has to return necklace. Broker has to return necklace to the jeweler. Jeweler intended to deal not with her but with quite a different person, that is wife of a baron. Wife of a baron. So these are the two important cases that we'll have to see. So I'll show you a couple of videos. You tell me whether it is undue influence, fraud, coercion. 1 second, I need to play that. Tell me whether it is undue influence, coercion. What is it? I'll show you. 1 second. To play that video for you guys, you need to tell me what it is. Undue influence, coercion. Didn't touch the person only. Is it coercion? Yes. Why? Because it touched the property. So mental pressure is one, and of course they touch the property and not the person. So what is it? Coercion. So that would amount to coercion. So like that, you can watch movies and understand so many things. Like that, if you want to understand what is unsound mind, watch Legend, like that. Yeah, yes, you will only become person of unsound mind. Yes, right. So if you see, law of the land valid, foreign law, all that we have seen. Cool. So this is regarding mistake, etc. Now moving on, these things are what is there in the next few chapters. Agreement expressly declared void by the Indian Contract Act. That is what is there in the next few chapters. Void agreement, void contract. First one, consideration or object is unlawful. So obviously when it is forbidden by law, when the contract is not allowed in law, like smuggling, then drugs and whatever it is, prostitution, and manufacturing drugs, selling drugs, all these things are immoral, and that is also there. See, immoral or opposed to public policy. So anything which is against the general public, which is not allowed in the normal sense, all these things will be not there. So of course your human trafficking means what? Buying and selling of human beings, that is called human trafficking. All that is a lot, it happens in India. A lot happens in India. Yeah, Mumbai, even Tamil Nadu, even Karnataka. You may feel Tamil Nadu and all, nothing will happen. Karnataka, nothing will happen. It keeps happening. So if you see, human trafficking is something which happens very, 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 frequently. If you see all this, I told you, Saukar Pet. If you see their house, it will be like this only. Correct? This is all during old loans. All these things are, of course, not allowed. All these things are, of course, not allowed. So, 1 second, then let me see. Yeah, see, this is a Tamil Nadu human trafficking. So this happened in Tamil Nadu, somewhere in Tamil Nadu, Saranya Residency. Somewhere in Tamil Nadu, small place where what happened was there's all these rooms. Inside the rooms there was a mirror, and in the mirror they had kept some people there. Those people were sold somewhere else to other people in other countries. So imagine, once you open that mirror, you won't even know. Inside the mirror, if you see, there were people. people there who they removed and all that. And see, this was inside the mirror. If you see, this was the one small bed was there. That's it. So illegally selling human beings is called human trafficking, which happens. All these things, tell me the consideration that you get money, legal, illegal. Yes, this is void, 100% void. So money if you get also, it will be void. So that's what they're trying to tell, it will be void. What is partially legal, partially illegal? Partially legal, partially illegal. Certain parts are legal, certain parts are illegal. Let's say you are an accountant. After you become a CA, you will work as an accountant with a real estate developer. In real estate, you will get black money also, white money also. Both you will get. You will be getting 2 lakh rupees per month salary for both normal accounting and for black money accounting also. Now tell me, they stop paying money to you, salary to you. You go to the court, can you sue the court saying that, sir, they have not paid me money for conversion of black money to white money? No. Is this contract separable or inseparable? I mean, what I am trying to tell is, can you tell for how much black money to white money in that 2 lakh rupees salary that you are getting, how much is attributable to conversion of black money to white money services that you are giving, and how much is attributable to actual white money accounting that you are doing? You cannot say. 2 lakhs is given for everything. So now tell me, what happens to this contract? Valid or void? Void. If the contract here, if the illegal part cannot be severed, severed means separated. If the illegal part cannot be severed, separated from legal part, total contract is void. If the illegal part cannot be separated from legal part, total contract is void. If it is possible to sever the illegal part from the legal part, if it is possible to sever or separate illegal part from the legal part, then I should enforce legal part only. Then I should enforce legal part only. For example, if you can prove to the court that 1 lakh rupees was towards black money, 1 lakh rupees was for accounting towards white money. If you can prove it, if it's somewhere written, though it won't be there, I'm just saying. If it is separable, then yes. Then you can enforce what? Only the legal part. You can enforce only the legal part. So there was one case where one pharmacist was doing, selling and buying of drugs during the day, and at night he was selling other drugs also. Pharmacist will have access to everything. Morning business was what? Selling tablets, Dolo 650 and all that. Evening, other things, narcos, correct? Hashish, marijuana, all those things he was selling. Cocaine. Cocaine is obviously not easily available as such across the world, but other things are definitely. Hashish, marijuana, all those things. All experience they're telling, see. Whole experience here, yes. So what can you do that? Partially legal, partially illegal business. If it is separated like that, you can enforce only the legal part. If it is cannot be separated, then it will not be possible. Cannot be separated, it won't be possible. So that is what it is. Unlawful. Okay, what is unlawful and illegal agreements then? Unlawful and illegal agreement. So basically, if A enters into a contract with B to do liquor business, is it valid or invalid? 100% valid. And he borrows money from C also. He borrows money from C. C gives a loan to Mr. A. A will pump that money into liquor business. Absolutely valid. Problem now is, today government bans liquor. Assume today government bans liquor. What happens to this contract between A and B? It was valid before, now it has become void contract. My question is, can C recover the loan from A? Can C recover the loan from A? That is the main question. This is what? This is a main contract. Yes, it's a main contract. One more example. C has given money to A. A is using it for smuggling activities, and C knows about it. C is also getting a cut. C knows about it. Now tell me, is this void contract or void agreement? Void agreement. Void ab initio. Correct? This is void ab initio. This first one was void contract. In both the questions, I am asking the same question. Can C recover the loan from A? Here, can C recover the loan from A? First one he can recover. Second one, no. Why? The contract agreement itself is void ab initio. Now, this between A and B, it is called as the main contract. Contract between A and B is called as the main contract. What is the contract between A and C called? Yes, it is called ancillary contract or secondary contract or one more, collateral contract. Ancillary, secondary, collateral. Collateral, co is together, lateral, side by side. I repeat, contract between A and C is called ancillary contract, secondary contract, collateral contract. Contract between A and B is called the main contract. Contract between A and B, main contract. Contract between A and C, secondary or collateral contract. Ancillary, secondary, collateral. Ancillary, secondary, collateral contract. Now, can the collateral contract be enforced? That depends. This agreement, which was initially legal, now it has become unlawful. I mean, now it has become, what do you say? From now it's not possible. Such contracts are called unlawful contracts. Unlawful. Whereas the first one, isn't it void ab initio? Yes, this is void ab initio. These contracts are called illegal agreements. It can never be a contract. It is illegal agreement. So now the question is, in an illegal agreement, what happens to the ancillary agreement? Valid or void? 100% void. Okay, in an unlawful contract, what happens to the ancillary agreements? Valid. That's all. Very simple. So to summarize with background music, yes. To summarize, how do we summarize? Let's do it. Correct time it came. Timing, super timing. So what is it? First you have unlawful, then you have illegal. So the applicability was what? Whether it is, I mean, what happens to the main contract? What happens to the ancillary contract? Tell me, what happens to the main contract in unlawful contract? Void. Main, yes, void. What happens to main contract in illegal agreement? It is illegal and void, and definitely void ab initio only. Correct. Illegal and void ab initio. Pakka. Correct. 100%. What happens to the ancillary contract or ancillary agreement in illegal contract? Same. Illegal and void. What happens to the ancillary arrangement in an unlawful contract? This part is valid. This part is valid. Ancillary arrangement in an unlawful contract would be void. Sorry, valid. Ancillary arrangement in an unlawful contract would be valid. Ancillary arrangement in an unlawful contract is valid. Very, very simple. Yes. Both what? Void is, see, illegal agreements are they void? Yes. But are all illegal agreements void? Yes. But are void agreements illegal? I'll come to your question. Are all void agreements illegal? No. All void agreements need not be illegal. Agreement with minor is void ab initio, but it is not illegal. What are illegal arrangements actually? Smuggling, something which harms public policy completely. Smuggling, rape, murder, or rather, entering into an agreement to commit murder, entering an agreement to commit rape, all these things. dacoity, all these are illegal. But agreement with a minor obviously is it's governed by civil law, where it's not a criminal legislation. Generally, criminal arrangements are illegal. Whereas unlawful is what? Unlawful is something which became valid, and later it became void. So it's a void contract. So it is a void contract. So such contracts can be enforceable initially, later it is not enforceable. But what happens to the ancillary arrangements? At the time of entering into that contract, it was valid, no? So that is why it is going to continue. So all unlawful arrangements will actually have the flavor of void contract. That was your question, right? That's what I told. These examples are the same. So it has the essence of the being a void contract, not a void agreement. Illegal agreement has the essence of having a void agreement, void ab initio. But as I told you, all illegal agreements are void, but all void agreements need not be illegal. On the other hand, every void contract will also have the nature of it being unlawful because of change in law, circumstances, etc. Yes, but you can't write it like that, because when I'm discussing unlawful contract, I'm only explaining what happens to the collateral. So the unlawful, the question will only come when I'm discussing what happens to the collateral. In normal law, you always have to write void, because in Indian Contract Act, unlawful word is not given. What is given? Void. So that's why you should use void. But to explain the concept of the collateral arrangement, what happens to collateral, then I have used the word unlawful. Okay, that's all. But ultimately it's the same: void contract, void agreement. But void agreements are need not be illegal, but all illegal agreements are void. That much you should know. Next, here, unlawful and illegal agreements. Unlawful agreements, collateral agreements are not affected. Illegal agreements, collateral agreements are tainted with illegality. Tainted means it will have that thing. It would have a taint. Taint means a black mark. Yes. Agreements in restraint of trade is void. This also you know. Any agreement if you do against the trade means what? Can I tell you cannot sell this particular product? Can I restrict your business? No. Once you become a chartered accountant, can I come to you and say, please do not practice in Chennai? No. I'll give you 1 lakh rupees, don't practice in Chennai. No. Anything in restraint of trade would be void. Then I told you, what about non-compete clause? Is non-compete clause void? For example, you are a chef in a 5-star hotel. While leaving that particular hotel, you will sign an agreement saying that you will not work anywhere else. Is that valid? You will not work anywhere else. Or you will say you will not disclose the secret recipes that you have found out. Second one is valid. So that's what. So are all agreements in restraint of trade void, or there are certain exceptions? Exception. These are the exceptions. Agreement with the buyer of goodwill. Agreement with the buyer of goodwill. So if I have bought goodwill of something, for example, as I told you, would have told in regular batch also, there is this MTR, food division. MTR is a very famous brand across Karnataka, and it is there across India also. Just like Haldiram's, you have MTR products also. You have MTR Murukku, MTR gunpowder, MTR rasam powder, sambar powder, all these things. So MTR has a restaurant also. MTR has food products also. MTR has sold its food product division to a Swedish company. Now you will not like it if it says John Murukku, Andrew Appam. Correct? You will not have that. You will not even like it. Correct? You will not have any of those things. Correct? Racial rasam powder. Will you buy? No. Correct? So if you see, that is why what the Swedish company did, they said, boss, we will pay you some amount and we will use your name. Obviously, goodwill. I am buying your goodwill. I am a Swedish company, but I am producing MTR powder and I'll use the name MTR. Now, I have paid you so much money. Can I tell you, you should not use MTR name? Can I tell the old MTR brothers, since I have purchased your goodwill, you should not use MTR name? Is it valid or void? 100% valid. That's why I paid you so much money. Can the old MTR brothers say what they are doing is cheating? No. Because for that you have been paid properly, no? So that's what agreement with buyer of goodwill. So buyer of goodwill, seller of goodwill can enter into a contract with buyer of goodwill not to start the same name again, not to start the similar thing again. That is agreement with buyer of goodwill. Trade combination without monopoly. Trade combination without monopoly. Trade combination means what? What is the difference between trade combination and monopoly? Monopoly is two big companies, big associations coming together to completely curb competition in such a way that competition will not even hold good. For example, today if Jio and Airtel come together and want to create their own network, it will destroy all other players. First of all, there is no other player, but assuming the other players are also want to come, BSNL is waste actually. In terms of market share and this thing, if you see, these two are biggest players, Airtel and Jio. Even that idea is there, this thing, Vodafone idea, all are on. It's gone. VI is all gone. It's gone. So the thing is, now assume if these people to take on BSNL and Vodafone idea, these two people come together, it is 100% what? Monopoly. So monopoly, whether it is monopoly or not, who will decide? This is called CCI, competition. In your BCK, you would have studied this, correct? So there is a thing called Competition Commission of India, CCI. CCI would discuss whether it is monopoly or not. So same when Vodafone idea merged also, the issue went to CCI. CCI said, you are also Chapadasi, you are also Chapadasi. You don't have any market share. Two Chaprasis coming together, nothing will happen. But if Jio and Airtel go, then there are two huge players. There are two huge players coming. Assume if it happens, monopoly. It is monopoly. It will not allow. In Bollywood, two biggest producers. One is Yashraj Movies. One is Dharma Productions. They are the two biggest producers in Bollywood. What if they merge? Imagine. So that would definitely result in monopoly. There will not be any position for other people to come in. That's what I'm trying to tell. So basically, what is monopoly, what is not, you and I will not decide. The CCI will decide, Competition Commission of India. That's why if two companies are merging, apart from all the approvals from the court, apart from approvals from the shareholders, etc., you also need the approval of CCI, Competition Commission of India. They will analyze whether your merger is monopoly or not. If it is not monopoly, then can I do a trade combination? Yes. Trade combination not amounting to monopoly is valid. For example, the chartered accountants of Chennai can come together and form an association. And they can say, see boss, we are all CAs, we have died and we have passed. Let us not charge some peanut amount. Let us not have competition, we'll have competition, healthy competition among ourselves, but at least let's fix the base price. Don't do work for 500,000. BCom fellow also can do. You have passed the exam by, struggling. Let's keep some minimum fees, 3,000, 4,000 minimum. So can they agree like that? Yes. Will this amount of monopoly? No. And they'll say, we will be there together for each other. If anything happens, don't worry. Let's say one of the chartered accountants falls sick or any emergency is there, we'll have a fund and from that fund we'll pay him. All that for the betterment of the community, for the betterment of their group. If they do you think it is a monopoly or it's valid or void? Valid. 100% valid. So you can have Steel Manufacturers Association, you can have Chartered Accountants Association. In Karnataka, we have Karnataka State Chartered Accountant Association. Tamil Nadu is also there. Tamil Nadu State Chartered Accountant Association. Are those associations void? No. 100% valid. They come together for a common purpose. All members are there in that. They will ensure that basic minimum rate they will charge. They will be there for each other. If any CA is undergoing some financial crisis, others will pitch in and pump in, give like a loan. It's like helping your own community. Like that, there are many such communities. You know Jain community? Jain. So Jain also has a community. I mean, they have lot of associations like this. So there is in whole of India, there's something called JITO. I don't know the full form, but it is Jain International Trade Organization, something like that. They have lot of, they have Jain, JITO IPL, like Indian JPL. They have JPL, and I'm not joking. It's not some normal tournament that they do. It is some crazy tournament with some sponsorships worth crores. It happens in Bangalore and other places in India. Actually, it happens. So like that. Now that association, they do good work also. During COVID, they did a lot of donations. They donated oxygen cylinders to so many people, and they had vaccination drives for the Jain community. So why not? Is that contract void? The association, no. So that's what they try. If it creates monopoly, void. Doesn't create monopoly, not void. So like that, 3 cases are there. Please read here. I'll show you. No need of the name, guys. No need of the name. Just read the case, just for your knowledge. Check it out. Read now. Page number 21. Yes, please read. Yes. It can be any form. It can be cooperative society, it can be normal society, it can be a trust. But it's a contract. So is that valid or void is the question. Please read those 3. Yes. So, in all this is between ice manufacturers not to sell ice at a below a stated price valid. Then uniform for ginning cotton yarn which they produce, that is also valid. All an agreement between crop society to deliver all crops grown by them to society, that is also valid. All these things are valid. If it doesn't result in monopoly, 100% valid. Then, if you join Infosys, can I enter into a contract with you that during Infosys time you cannot work anywhere else? Yes, 100%. What is a technical term if you actually end up working somewhere else? It's called moonlighting. It's called moonlighting. So recently only you would have seen in the news, moonlighting. Infosys warns other employees of moonlighting. 3-4 days ago it had come, because they have realized that people are not only working in Infosys, also working elsewhere. That's a breach of contract, moonlighting. So you cannot do moonlighting. Means when you are working in Infosys, you cannot go and work somewhere else. Obviously, no, you have given they are giving you salary and they demand exclusivity. Can you say agreement and restraint of trade? You are, not allowing me to do whatever I want? No. If that be the case, don't be an employee. Be a freelancer. Do work everywhere. Why are you an employee? You will get that protection. You will get PF, PSI, you will all get all these other things. That's why you are doing it. Right? So that is what service agreements with employees. Service agreement with employees. One is what? Agreement with buyer of goodwill. Second is trade combination without monopoly. Third one is what? Service agreement with employee. Fourth, agreement under Partnership Act. Agreements under Partnership Act. What do you mean by that? Partnership Act you would have seen. If a partner is merging with, if a partner is exiting a partnership, can he sign one contract saying that he will not work in this area for the next 5 months, 6 months? Yes. Valid. Can he write an agreement saying that he will not solicit the customers or he will not poach the clients? Yes. Yes, all those things are allowed. If a partner is exiting, can he say that I want to pay in my, I want a share of profit also because my capital etc. is still there. I want a small share of profit, but I will not do the similar business. Yes, all those things under Partnership Act is valid. Under Contract Act, it will be void. Right? So, if a question comes in the exam, you should write Partnership Act or Contract Act. 100% Partnership Act. Because Partnership Act, when there are inconsistent provisions between two, what will apply? Special Act. What is a Special Act here? Partnership Act. So you should write Partnership Act. But similarly, they have given here also exception. So it is the same. In restraint of legal proceeding means what? Yes, any legal action. Whenever you have a right to sue anybody in the court of law, can I take away that right? No. Anything that you do in restraint of legal proceedings would be void. I cannot and at any cost not take away the right of, what do you say? Right of the legal remedy. So if two people are fighting in the court of law, I cannot go to the opposition judge and bribe him and say, please do not take up this case. Can I do that? No. Would that be void? Yes, 100% it would be void. Agreement restricting enforcement of rights and liabilities which curtail the period of limitation, everything. Basically, period of limitation is what? 3 years between two people. 3 years between two people. Debtor and creditor relationship, 3 years will be there. Less than 3 years, can I go and do something which will actually ensure that my legal remedy is no longer there? No. I cannot bribe the judge, I cannot bribe my lawyer, cannot bribe the opposition lawyer, not possible. If any agreement like that, where I say I will pay you so much money, don't take up this case, don't go do this, etc., that will be called agreement in restraint of legal proceeding. If I tell the lawyer don't take up this case, it will be agreement in restraint of trade. But if I tell don't argue this way, don't argue that way, please let off this piece of evidence, I'll give you 10 lakh rupees. All these things are agreements in restraint of legal proceedings. Agreement in restraint of legal proceedings. So agreement, exceptions are there though, exceptions. Rather than fighting, when the court case is going on, we'll stop it midway and we will go to something called arbitration. What is arbitration? It's an alternative dispute resolution mechanism. It is an alternative dispute resolution mechanism. ADR it's called. Alternative dispute resolution mechanism. So what is this exactly? You would have seen in movies. Yes, Katra Panchayat. Panchayat will be there and then suddenly one hero will come. Correct? Saravanan Store's legend. Alright, he will put his legs. Vadivel will come. He'll, once he puts one foot on the ground, everywhere, suddenly wind everywhere. There is a cyclone that comes. Correct, from behind 2 lions will come in the desert. Balaya, correct. So all this Balaya, then he will, just slap his thigh, the train will go behind. Correct, all those things. This is called Panchayat. Panchayat, when he decides something, that is the final rule. Panchayat, when it decides something, that's the final rule. So that is called what? Disputes arising in contract. Now, arbitration is an alternate dispute resolution mechanism. Rather than going through the court processes for years and years and years, can I just directly go to arbitration? Yes. But what is the drawback of arbitration? No, it will take less time actually. Actually, normal court will take 20 years. Arbitration should be over in 12 months. Focus? Yeah, but isn't that good? Will you wait 20 years than, settling it? You will compromise and settle. That's better than waiting 20 years as to who will win. What is actually the drawback is it's slightly costlier. But in a normal court procedure, even if it takes 20 years, every time you may have to pay 5,000, 10,000. But here in arbitration, each arbitrator will minimum take 2 to 3 lakh rupees per hearing. So if there are 10 hearings, 30-40 lakh will go in a year, but at least you'll get a settlement. So you should ensure that settlement amount is in crores. Then it's okay. But there will be lot of, as you said, there will be some compromise also. So in a court case, hearing will go on and on and on, and the court will call you, you need to go. So many things are there. Here it's different. What are that? So that's what it is. Disputes arising refer to arbitration. Dispute arising refer to arbitration. So what is arbitration? Arbitration is an alternate dispute resolution mechanism. Arbitration is what? Alternate dispute resolution mechanism. It's ADR. So in restraint of legal proceedings, in restraint of trade, and all these things we have to keep in mind. What is the difference between uncertain, wagering agreement and contingent contract? Uncertain agreements you have done, guys. It should be certain or capable of being made certain. What's the difference between, tell me, wager and contingent contract? What is the difference between wager? It is not wager and all, wager, and contingent contract. What's the difference? Or what's the similarity? What is wager? Sense of acceptance. Then main contract is uncertain. LIC policy, when you have life insurance, is it a wager or is it contingent contract? Contingent, which means I am buying a policy that you will see, if you die within whatever years, 15 years, 20 years, if you die, then money will be given. Wager means what? Unexpected. See the definition of wager, then we'll understand. Check it out. Sure, wagering. Promise to pay money or money's worth by one person to another on the happening or non-happening of a future uncertain event. Promise to pay money or money's worth by one person to another on the happening or non-happening of an uncertain future event. Future uncertain event. So gambling, betting, etc. Correct. So if I say, if RCB wins, I will pay 1000 rupees. If RCB loses, this is uncertain event or certain event? Certain event. RCB losing, certain event, uncertain event, certain event. So that cannot be a wager. Correct. So if I take some other two teams, correct, CSK and let's say Mumbai Indians. So then in that case what? It's an uncertain event. Uncertain. Whether it will go ahead, not go ahead, don't know. But contingent also is like that only, see, contingent contract. Contract to do or not to do something. If such some event does or does not happen. So, yeah, most important thing is collateral is there. So, what's the difference between the two? Or what's the similarity between the two? We will see. What's the similarity between the two? Wager means betting. If CSK wins, if Mumbai wins. Whereas contingent is your life insurance. If you die, that is 20 years policy. If you die within 20 years, then I'll pay you some amount. Pay your family some amount. Wager means what? It depends on the happening or non-happening of the event. Winning, losing. Contingent also happening or non-happening. That is death. In the when the death will happen. Happening or non-happening. Whether death will happen or not happen. Then of a future event. Yes, winning or losing, future. This is also future event. Uncertain event. Yes, winning or losing is uncertain. Is death certain or uncertain? Death is certain, but when will death happen is uncertain. So this also is uncertain event. When all the three are same, wager is void, contingent is valid. Why? Wager is void, contingent is valid. Why? In all the three things are the same though. Why? Is it illegal? Wagering. Happening or non-happening. Here also same. Why? Valid, one is void. Why? Legal, illegal, not the right answer. Collateral. So the most important thing here is what? In a wager, the event is the, win or lose. The event itself, is it the main or is it collateral? Win or lose is the main part. Whether they will win, whether they will lose, the event is the main part. So ultimately the entire contract rests on one thing, whether you will win, whether you will lose. Whether you will win, whether you will lose. But in a contingent contract, event is not the main part. The contract is between me and you, where for 20 years I will pay premium, and for which you will give me a protection for 20 years that, okay, if something happens, you'll be there. So the contract is for 20 years, that's all, or whatever years, that doesn't matter. But the event of death, is it the main part or secondary? Secondary part. Event of death is always secondary. So the event here is always collateral. The event is always collateral. In the first case, event is the main part of the contract, wager, betting. But in this case, event is always collateral. In the first case, event is the main part. In the second case, event is collateral. In the second case, event is collateral. So that's what you need to understand. Then what is the other difference here? One is valid, one is void. One is valid, one is void. One is main part, one is collateral. What is the other difference? What is the other last difference? One is valid, one is void. And event is the main part in one case, event is the collateral part in the other case. Correct? One is valid, one is void. One is the main part, one is the collateral part. What is the third thing? What's the third? Against public wealth. Okay. Then apart from that, so if you see, in a wager, one person will win, one person will lose. For sure, it's a win-lose situation. In a contingent contract, always it is a win-win situation. The insurance company is getting super premium from you. Every year they're getting premium. What is your win? The protection that if something happens tomorrow, then what? Protection that if something happens tomorrow, what will happen? Your family will be protected. So because you will take a policy for like 1 crore, 2 crore, 3 crore and all, you will be paying 1 lakh premium, assume. 4 years also, if you pay premium and you die, for 4 lakhs your family is getting almost 1 crore. Think about it. So it's not that 20 years you should pay, then you are protected. No, every year you pay premium, you will be protected. Yes, even if you pay 1 premium and if you die, you will be protected. What people used to do, they used to pay first premium and commit suicide. Used to happen, I'm not joking. In India, everything happens. So they used to commit suicide. That suicide clause was not there before. People used to give. That's why after that only they added suicide clause. Once you actually, if you pay premium, no insurance claim will be made of if you commit suicide. For this only they did. Because people, what they used to do, today they used to take the insurance policy, pay 1 premium for 1 crore rupees, pay 1 lakh rupees. Next, while going home only, jump from the building. Used to happen. There was no concept of, they had forgotten or they didn't even realize that in India all this can happen. So there was no suicide clause. Today in all insurance policies, suicide clause is there. If you die by suicide, then you will not get any insurance, or there will be very less insurance. It will be whatever you have invested, that they'll give back and some extra. That's it. So that's what. But it's always a win-win situation. Win-win situation in case of contingent. But in wager, it is not a win-win situation. It is a win-loss. One person will win, one person will lose. So that is the similarity and difference. Now let's see. Check it out. Wager is also important. Read. These are the features of wager. Please read A to H. A to H. Read on your own. Then I'll explain 1 or 2 points in that which are important. Already everything I've explained, but only 1 or 2 extra points are there. Read A to H right now. Finish it off. A to H, please read. A to H. All right. Yes. So what does this says here? The both the parties under no circumstances intend to enforce the delivery of the contract, and they should not have control over the happening. Means in if I say whether RCB will win, RCB will lose, etc., should I have control over the event? No. But what happens if it's a spot fixing thing where I will go to the player and say, I will have bet that you will win, or I will have bet that you will lose, I will pay you that money, please lose. That will it be a wager? No, it will be fixing the wager. Think about it. Right? Spot fixing is called fixing the wager. If I make a wager saying that on the 5th ball of the first over, he will put a wide. So that is a wager. But what will I do to ensure that I win? I will go to that player and say, I'll pay you 5 crore. Actually, just put all you need to do is just put a wide. Bowl of delivery which is wide of the stumps. Now that is what called, that is against the wagering agreement, because in a wager you should not have control over the event. This will amount to what? Fixing the wager. This will amount to fixing the wager. You should not have control over the event, but in this case it appears that you will have control over the event. That's like fixing the wager. Is wager valid or void? 100% void. But is wager unlawful or illegal? Is it unlawful or illegal? Unlawful means void contract. Illegal means illegal void agreement. What is wager? In Gujarat and Maharashtra, it is illegal. In Gujarat and Maharashtra, it is illegal. They have their own laws there which says that any wager is illegal. Gujarat, because it was Gandhiji's, birthplace. That's why liquor also is banned there. And wagering is also banned. No type of wager can be done. But does Indian Contract Act also cover this online gaming which is registered elsewhere? No. So if the app is registered in Bangalore, online gambling, rummy and all you've seen. Even if you see even this, your play, this thing, your IPL, your dream team, Dream 11, you can actually earn money there. It's actually, if you think about it, like a wager. Which player will play well? That's your selection. It's purely based on chance. That fellow may not perform that day. It is purely based on your analysis. You never know who will win, who will not win, who will play. It's a wager. But of course that you can find, that is all allowed. Correct? Otherwise nothing would have been allowed now. Next. No action for recovery. No suit for breach. Nothing you can do. Whether wagering agreements are illegal? Yes, in Gujarat and Maharashtra. Other places it is void. In one place in India, gambling is valid. Goa. In Goa, gambling is valid. There are casinos. There are casinos everywhere. They are what do you say? Allowed casinos, approved casinos. Deltin Royal, it's the largest casino in India. Deltin is actually a casino brand of Nepal and other areas, which is quite famous. Deltin Royal has also come in, and it's there in Goa. So when you enter Deltin Royal, you have to pay a chip of 5,000. You have to entry fees 5,000, but they'll give you 5,000 rupees worth of chips. Chips means not lace, not dead chips, not potato chips, coins. Using that coin, you can play. Correct? Using that coin, you can play. So that is called gambling. Gambling, that is your basically normal things that you do. Casino. Casino actually is also a wager. There is less of skill and more of what you say, luck. So it's a pure gamble. So is it wager? Yes. Is it allowed in Goa? Yes. But in the exam, don't write in Goa it's allowed and all, don't write. So in the exam, what? Gujarat and Maharashtra illegal, other places void. Void or unlawful you can write. But void is better. Other places void, Gujarat and Maharashtra illegal. Yes. Whether wagering agreements are illegal, yes, we have seen. Other places it is void. Then, but what are not wagering agreements? What are not wagering agreements? First one, sale and purchase of shares, stock and goods. Why? These are called what? Sale of shares, etc. are called speculative transactions. They are called what? Speculative transactions. What are speculative transactions? Predict the price of the share. So when you are predicting the prices of the shares, are you gambling? No. There are a lot of scientific tools, lot of analysis that goes into figuring out whether the share price will increase or decrease. Rakesh Jhunjhunwala was an expert in this. Big bull, yes, correct. When you are rich, it doesn't matter what you wear and all that. Do you see what he wears? You just see Rakesh Jhunjhunwala with Modi. You see the picture. You will see. I know he passed away around 10-15 days ago and 1 month ago, and he, see this guy beside Modi. You can wear banyan also and go. Doesn't matter if you are the richest man in India, one of the richest man in India, richest man of the world, considered as big bull. Correct? He was actually the Warren, but he never liked that. He said, I am not the Warren Buffett of India, I am the Rakesh Jhunjhunwala of India, he used to tell. He never used to like people calling him Warren Buffett. He's like, I am not the Warren Buffett of India, I am the Rakesh Jhunjhunwala of India. Correct? So you call other places, you tell you are the Rakesh Jhunjhunwala of Sweden. That you tell. That is what he wanted. He didn't want to copy or have anybody else's name. So he never liked it. So this guy, he told that his worst investment in life was health. He only told that the worst investment of my life is health. He had told it 2 years ago. I have everything in the world, but I don't have health. So 2 years ago only he had told. It's as if he knew that he was going to die. Because he said that I know that I have done so many investments in my life, billions of dollars I have earned, but the worst investment is health. Because people asked him, what is the best investment that you should do? He said, I will not tell what's the best investment. I will tell you what's the worst investment. He told, worst investment of my life is health. So the best investment that you can do is in your health, not in anything else. Right? So you should be, eat healthy, be fit, stay fit as much as possible. So the best investment that we can do in life is stay healthy, is what he said. And that's so true, because in 2 years he died. After getting, so much money, but he was in a wheelchair, couldn't get up. Not that he was so old, some 60, 65. 60, 65 is not old. I understand it's not so old. 62 is not so old also that you cannot walk. But see, he couldn't walk, he couldn't, do anything, poor guy. So if you see, health is most important. Anyway, so like Rakesh Jhunjhunwala, whatever he does, can you call it betting? No. Whatever he used to do, he passed away. Whatever he used to do you call it betting? Definitely not. He's so brilliant. He used to analyze the market so beautifully. And then decide, okay, this will rise, this will end. So he was, so many people took tips from him. His website, if he told that this stock is good, people used to go buy that stock blindly. Because if Rakesh Jhunjhunwala has told, it has to win. is what the idea was. Very simple. So if you see, contract is, wagering contract are void. So sale and purchase of shares is not wager. I am not doing any wager. I am using business analytical tools in my mind to come out with the correct share price, what share price will increase, decrease, etc. Price competition and not exceeding 1000 rupees. Kaun banega crorepati? Is it wager? No. Does it involve luck or skill? Skill. Does it in luck or skill? Skill. So all price competition less than 1000 rupees are not wager. More than 1000 is wager, provided it involves what? Luck. Skill, no problem. Skill is not wager at all. Anything that depends on the happening or non-happening of a future event, they are called luck. Horse race. Now tell me guys, horse race contribution. Horse race is wager, no, 100%. Which horse will win is a wager. But in India, it's a huge business. That's why they have excluded it from Contract Act. Is horse race actually a wager? No. As per Indian Contract Act, if you do a betting 500 rupees or more, mind you, if you do betting 500 rupees or more, is it a wager or not? Not a wager. Less than 500, wager. Imagine if you and I don't have money, we'll do 100 rupees betting. Is it wager? Yes. 1000 rupees? No. 10,000 rupees? No. Vijay Mallya and all used to bet for crores, I remember. We were the auditors of UB Group. When during the thing, we were the auditors of UB Group. Then and we were also the auditors of Turf Club. There is a Turf Club in Bangalore. So when we were auditing the Turf Club of Bangalore, hero had come that time. Who? Vijay Mallya. With some 5 girls this side, 5 girls this side. Yes. So he had come. I remember that very clearly. So he had won. People come there, they dress up so well, they buy suits only for that particular event. If it's a horse race going on, they will buy a proper dress only for that event. It's a very lavish thing. And that time this guy had installed mini breweries in what do you say? You can just like filter coffee, you'll get brewed filter coffee, like brewed beer. You had installed in the Turf Club itself. So you could go and you can have, and also yes, the all the big shots of Bangalore had come there. So then I realized, okay, then this is really legal, because then they were bidding for 2 crore, 3 crore, 5 crore, like nothing, like peanuts on any horse. If any horse wins, 5 crore, like that. So now income tax department also realized that there is no point making it illegal. Let's make it legal. So they said, but they said if I win 1 crore, you will not pay tax, I know. So they created a new concept called TCS, tax collected at source. So what they did, if you win 1 crore, 1 crore will not be given to you in cash, obviously. 1 crore will be given to bank. So income tax department said, rather than me giving you 1 crore, you showing it your income, you paying income tax later, I will only cut 30 lakhs and give you 70 lakhs. New law they inserted. So yes, so they cut 30 lakhs there only and gave only the rest 70 lakhs. 70 lakhs. So good concept, because they knew a lot of money in horse race. So even Indian Contract Act, that time only they knew horse race should not be made illegal. It's an entertainment thing. Money factor should not be made illegal. So next one you see. Horse race contributions for 500 or more is what? Not wager. It's legal. Less than 500, wager. You and me, Chapadasi fellows, will go. 200 rupees will put, that is wager. That's illegal. 200 rupees is illegal. 20 lakh rupees, legal. Correct? 20 lakh rupees, legal. So that's what it is. So should not get confused. Price contribution less than 1000, not wager. More than 1000, wager. That's fine. In horse race, it's reverse. Less than 500, wager. More than 500, not wager. So don't get confused there. Contract of insurance also. Insurance contract is not wager. The insurance company is not betting on your life. If you die, no. Correct? Next. Lottery. The lottery happens in Kerala. Kerala, so much lottery. The moment you go and stop at one, signal, he'll come. Cheta, lottery, he'll come. He'll come on a cycle and stop in front of you. Correct? You will feel scared. Did you do something? He'll come in front of the car only and stop. And then he'll come with all the things. This is state-sponsored lottery. Kerala government only has a sponsored lottery program. People will buy so much money. So basically, guys, I'll keep a gift of 20 lakh rupees. But collection will be 60 lakhs. Each ticket will be 10 rupees, 20 rupees, 30 rupees. Lakhs and lakhs of people will buy in the hope of getting 20 lakhs. So from the money I collect from that only, I'll give 20 lakhs. So I would have collected 70 lakhs. I will give 20 lakhs. 50 lakh is the profit for Kerala government. Almost 30-40% of Kerala government's income is from lottery. Imagine. Other states do not have such lottery schemes, but Kerala government has lottery schemes. Correct? So if you see, check it out. Third one. Lottery is equal to wagering. 100% lottery means wagering. See the bracket. Except when conducted by government. Example, Kerala. Except Kerala. If it is conducted by government, it is not wager. But otherwise, it is 100% wager. 100% wager. So these are all the various things that we have to keep in mind to understand what is this contract, etc. Apart from that, there are some other things. Trading with enemy, committing a crime, stifling prosecution. What is this? This is what our Salman Khan did. When the prosecution is going on, going and sort of creating, stifle means to sort of, what do you say, create a scenario where they will favorably give you a green signal to do whatever you want. So stifling the prosecution, that is what he did. He went and paid off the judge also, apparently, that's what they say. He went and paid the judge. He went and paid the witnesses. He told the witness, don't come to the court only that day. He told some other witnesses, that day you went and told you saw me. Now you go and tell, I am John Cena. You didn't see me. Correct? Correct? You can't see me. You didn't see me. Go tell that you did not see me at all. Paid so much money for that. Yes. That is all those contracts, valid or invalid? Invalid. Then some other important areas we'll see. Restraint of marital duties. So there was one boss, there was a boss, and there was the boss's secretary. Right? Secretary was married. That lady was married, but the boss had what? Like the secretary. So the actual case this is. The boss told the secretary, why don't you leave your husband and come? I will obviously do a proper, what do you say, divorce lawyer, the best divorce lawyer in India I will hire. Go and divorce your husband. That husband didn't even know what came to him suddenly. Correct? Suddenly there was a case where she said, I want to divorce you. Eventually divorce happened, and now the secretary was free to marry the boss. When she was about, obviously when the boss was, the victory happened, boss said, come, let's get married. So the secretary now said, who are you? I don't know who you are. What marriage? What? How? Why? This went to court. Boss said, I had an agreement. Agreement was, I will provide the best divorce lawyer, and in return, she has to marry me. Went to court. Court said, you actually broke up after seeing the facts of the case. The court said, you actually broke up a marriage. You broke a marriage up. They were doing pretty well. You only instigated and broke a marriage. And you removed or you stopped that lady from performing her marital duties. Similarly, you stopped that guy from performing his marital duties. Now the damage has already been done and you will not get what you want. So what happened? That was the case under which one? That entire agreement was void. Why? Because it was in restraint of marital duties. It was in restraint of marital duties. Marital duties. Similarly, let us say there was an old couple, not so old also, but there was a couple living in, let's say, some hill station in India, and they had a, maid, and they had a maid's family looking after that entire huge bungalow that they had. That young couple never had children and they wanted children. The maid already had one cricket team. 11 people already. 12th man was coming on the way. So she was pregnant with the 12th child, 12th man also, correct? Everything, full cricket team she had. So the thing is now, like this people, what do you say, the old couple said, at least the 12th man you give it to me. You already have 11, how much more you want? At least the 12th you give it to me. So she said, okay, I'll give it 12th. So the 12th was adopted by the couple and they went abroad now. They went abroad to live. 10 years later they came back again. So that kid was 10-year-old now, came back again. But that cricket team now, many of them had died because of some bad health and some of them had run away. Basically, there were nobody for that other lady also. So the maid will now come and say, give me back my child. What do you, this went to court. What do you think? The contract of initial contract of adopting the child, was it valid or void? The court ruled it as void because that adoption was not a legal adoption. Simply I went and asked her, give me the child, she gave. Is that legal adoption? No. This is called restraint of parental rights. Restraint of parental rights means what? As a parent, you have right over your biological child. If you want to let go of the rights, there is proper documentation and legal process. In India today, if you want to adopt a child, it is a minimum 4 to 5 year process. Correct? Lot of process is there you have to follow. Only one agency does it, that's a government agency. No private party is allowed to do, what do you say, adoption. Allowed to sort of help you adopt. It's not possible. It is only done through government agency. And it will, and there are just around 3,000, 4,000 kids registered in that agency. Not many, just 3,000, 4,000 are there. So now what should you do? Until you are a major, the parental rights will be with the parents, biological parents, not adopted parents. So restraint of parental rights. Similarly, can I ask you to, can I tell, I will pay you 10 lakh rupees, don't marry. No, nobody can take away the personal liberty. Personal liberty, restraint of marriage. What about marriage brokerage? These brokers will be there, no, marriage brokerage. Can you pay some amount to get a bride or bridegroom? That marriage brokerage, that actually is void. Unless you are a licensed marriage broker. Then what about these websites that you have, your shadi.com, all that, tamilmatrimony.com, all these things are they brokering or are they just providing a platform? Yes, providing a platform is not exactly brokerage. Providing a platform is not exactly brokerage. Correct? So that's what it is. Creation of monopolies has discussed all that. Sale of public offices and titles. You would have seen railway exam leak, paper leak, teachers exam paper leak, sports exam paper leak, whatever important, what do you say? CA exam from 1949 till now, not even once it has leaked. So there is no scene of paper leaking in CA exam. It is purely by your quality and nothing else. Only quality works, nothing else will work. Sale of public offices here is, we have important offices in our country, that if you sell those seats, which is actually happening in India, railway exam scam, teacher exam scam, correct, where the seats of railway exam are sold for 1.5, 2 lakh rupees. Paper will be leaked and given to you. Why will you buy that paper for 2 lakhs? Because your life is settled. You will be a railway employee, permanent job, and after 60 you will get pension also. So yes, quarters also they'll give you. So your life is settled. You don't have to worry. That's why people will go for this railway and all those things. That is what agreement opposed to public policy. So similarly, in contingent contract, on the other hand, contract to do or not to do something, if some event which is collateral to such contract does or does not happen, essentials are what? It should be happening or non-happening of an event, should be a collateral event and uncertain event. First and three are similar to wager. Second one is the important thing. The event is not main, event is collateral. Event is not main, event is collateral. secondary only, secondary only. So like that. Similarly, can I have agreements where it says no service employment agreement? Can Infosys say if you leave Infosys, you cannot work anywhere in India? No. See that. Read this. Some are valid, some are not valid. So if you see, check this case. Deshpande versus Arvind Mills. No need to remember the name. Read it. After you read this, read the previous one. Charles versus McDonald. No need to remember the name. So first read please Deshpande versus Arvind Mills. Then you read Charles versus McDonald. Charles versus McDonald. Charles versus McDonald. Please read, guys. Come on, finish it off. Right. So one part is what? Where an employee undertook his service employer for a period of 3 years but leaves the service after 1 year. What happens? He may be asked to abide by the agreement. Why? Because they had a 3-year bond. On the other hand, agreement of service by which a person binds himself during the term of the agreement not to take service with anyone else. This is also valid. If you are working in Infosys, you cannot work somewhere else. But see this, for example, this Oaks and Company versus Jackson. Oaks and Company versus Jackson. See this. J, an employee of a Chennai based company, agreed not to employ himself in a similar business within a distance of 800 miles from Chennai. 800 miles means what? Radius of 800 kilometers from Chennai, I will not work. That is what called. Obviously, agreement was void. In restraint of trade, 100% restraint of trade. This is an important case. If possible, try to remember next one. Goldsall versus Goldman. Goldsall versus Goldman. Try to remember if possible. If you name you don't remember, it's okay. At least the content is important. S. Seller of imitation jewelry. Imitation jewelry means what? That now fashion jewelry. That looks like gold but it is not gold. Covering, yes. Sells his business to B and promises not to carry on business in imitation jewelry. So I sell my imitation jewelry and you will say, boss, you should not carry on imitation jewelry. Okay, that is fair. But you will tell you cannot carry imitation jewelry also. Real jewelry business also you cannot carry. Is this agreement and restraint of trade? Yes. And real jewelry held. Restraint with regard to imitation jewelry was valid. No problem. You can stop other persons from doing imitation jewelry. But can you also stop that person from doing real jewelry business? No. Real jewelry is void. Imitation jewelry valid. All these things. Last 2-3 points and then we'll stop. See, rules as to enforcement of contingent contract. Contingent contract. Happening of an uncertain future event. Section 32. These are all examples given in the law itself. Check this. What is that? Uncertain future event. A contracts to B to pay a sum of money if B marries C. So it's like telling that if you are getting married, what do you want for your marriage? You will say, I want one mixer grinder. You will say, okay, I'll give. I will give it on your wedding day, the day your marriage happens. When I come there to eat, first of all I am coming to eat only, not to see you. I am coming to eat, then definitely I'll give you the what? Grinder. I will give you I will buy one mixer grinder and give it to you, no problem. When you go there, you will realize that bride has run away with somebody, boyfriend. Marriage is not happening. What you will give mixer grinder? Correct? He has to mix his heart and grind his heart and drink, that's all, nothing. So mixer grinder you will give or not? No. So you see, in this case, contract is valid or void? Void. A contracts to pay B a sum of money when B marries C. C dies without being married to B, or C runs away, whatever it is. Contract becomes void. Contract becomes void. This is what? Happening of an uncertain future event. Happening of an uncertain future event. When will this be valid? This will be valid when the event happens. Marriage also is uncertain. Anything that happens tomorrow is uncertain. Alright, uncertain future event. So when will it happen? If I say I will pay you this money if you marry that person, so if you marry that person itself is contingent. I will pay you that money if you marry that person itself is contingent contract. If you marry, I will pay. If you don't marry, nothing you will get. So it is a very simple contingent contract. Contingent contract. Generally, if one person is marrying into a very rich family, his father-in-law will say, boss, you once after marriage, you will be the CEO of this company. And marriage only doesn't happen, what CEO? Correct? Nothing. Correct? Nothing will happen. So, non-happening of uncertain future event. So, here event is what? Ship returning. Event is what? Returning of the ship. Non-happening means what? Ship not returning. This is nothing but insurance contracts. You will take insurance for what? Ship sinking and all those things. So you see, A agrees to pay B a sum of money if a certain ship does not return. Insurance contract. The ship is sunk. Contract can be enforced when the ship, what? How will you enter? When the ship is sinking, where it will return? Contract is enforced when? When the ship sinks. When the ship sinks. The contract itself is entered into what? When the ship does not return. When the ship does not return. The contract is entered into only when? When the ship does not return. So when the ship returns, or when the ship sinks, sorry, will you pay? Yes, 100% you'll have to pay. Because I entered into a contract only saying that if the ship does not return, I will pay. What about this? Happening of specified uncertain event within a fixed time. What is the event here? Ship returning. I will say if you finish all your voyage and come back within 1 year, I'll give you extra amount of 1 lakh. Contingent contract. It's like telling you if you make sales of 20%, you will get 20% commission. It's a pure contingent contract. If you do it, you will get. Similarly, if I say I will pay you so much amount if the ship returns within 1 year by doing all their work on time. You see, A promises to pay B a sum of money, let's say commission, if a ship returns within 1 year. The contract may be enforced if the ship returns within the year. If the ship returns within the year. And becomes void if the ship sinks. If the ship sinks. Or returns after 1 year. That's all. It will not be given. Money will not be given if the ship returns. If the ship what? Returns after 1 year. Returns after 1 year. If the ship returns after 1 year. Non-happening of a specified uncertain event within a fixed time. A promises to pay B a sum of money if the ship does not return within a year. So I'll say I'll pay you money if the ship doesn't come within the year. The contract may be enforced if the ship what? I'm paying you money if the ship does not return within 1 year. So what? So if the ship returns after 1 year, it's here return within the year. If the ship what? Sinks within the year. If the ship sinks within the year, will you get money? Yes. Why? Because it's not returning within 1 year. Then when will you get money? If the ship returns after 1 year. If the ship returns after 1 year. Or if the ship returns after 1 year. If the ship returns after 1 year. Last part, last two things. Behavior of a person at an unspecified future time. A agrees to pay B a sum of money if B marries C. This is some current or stupid movie. A agrees to pay B a sum of money if B marries C. But C marries D. The marriage of B to C must now be considered impossible, although it is possible that D may die and then C may afterwards marry B. This is not some creation by me. This is actually given in the law. It's given in the Baer Act as an illustration. So it is hence proved that the creator of Baer Act is Karan Johar. Yes. And that C may afterwards die and he may marry and all those things. Impossible event. Last part, impossible event. This is the end of the chapter. Impossible event. A agrees to pay B 1000 rupees if B will marry A's daughter. So I'll say, boss, if you marry daughter, you will get so much money. This is like Ram Gopal Verma style. C was dead at the time of the agreement. Correct? Already dead person can you marry? No, it is an impossible event. It is an impossible event. That is all there is to it. Yes. So tomorrow we will be discussing and finishing Contract Act. They have only given me 2 classes. 2 classes easily we can finish all the important areas and close. After that, I think your other subjects will start. If I am not wrong, as per the schedule that I have, other subjects will be going on. And yeah, that's about it. Okay. Thank you guys. See you. Bye. See you tomorrow. There was a lot of technical issues in the first one. Sorry about that. Yes. Alright guys, happy afternoon, how are you? Fine, okay. This is the first class? Yes, sir. Okay. Are you ready for the torture? Okay, so let's begin. Let's see. Yeah, alright. So, am I audible to all of you? Yeah. Just reduce all these things. Yeah, hope I am audible. Let's go ahead. Alright guys. So yeah, we'll have to finish the Indian Contract Act today. Simple law. It is easy, nothing to worry. Just that little bit of feel that it is difficult, used to feel, but it becomes very easy now. Let's just finish it off. Okay, so we were discussing, where did we stop guys? Which concept? We have to start what? Performance, okay, performance. Let's do performance of a contract. We had finished which other areas apart from this? All other done. Yeah. So we were doing, or rather we had done the happening of an uncertain future event and all these things we are done. Yeah, one example here in page number 22 again. In Patna, 29 out of 30 manufacturers of combs agreed with R to supply combs only to him and not to anybody else. Under the agreement, R was free to reject the goods also if he found that there was no market for them. What do you think? So he said that I can choose to end the contract also if I feel it's not good. Basically, it's more like a one-sided contract. They are saying that you can end the contract also if I feel that the goods are not good. So what do you think? Free to reject the goods if we found no market for them. Held. The agreement amounted to what? Restraint of trade. Because first of all, I am telling you have to supply it to only one person, and even if that one person doesn't like, he can cancel, which means you cannot sell it to anybody else also, which means it is you are at the mercy of only one guy who can do whatever he feels like doing. That's why this also is void. Name and all really not needed. Only Goldsall versus Goldman, if possible, you can remember. And then yesterday we saw Lake versus Simmons and all those things, no problem. Performance of contract. So today we'll finish it off. Whatever contract act we'll finish. It will be much earlier only, I feel. Hardly anything is left. So let's try to wind up as soon as possible so that you can go home and what do you say? See, the thing is, there's one more class. I don't want to start anything because I have to end it. After this, there is no class given for me for fast track because I have other classes, 8 hours. So I think from tomorrow somebody else will take, right? Don't know. Even I don't know. But for me, today is the last class for fast track. Last time also you told that you will tell, but actually there is no session tomorrow. Again, it's filled up with these sessions anyway. So ideally they told at least finish the important law, and of the lot, most important law is contract act. So let's finish it. Yeah. As of today, let me give a disclaimer. As of today is the last class. That day on full build up and all I gave, best of luck and all I told. Then next day my same face, you saw my stupid face, I saw your stupid face. Well, yes, same thing, correct. Right, exchange offer, correct. Like performance of contract, we'll finish it off. There are only three small things are there: performance of contract, and of course discharge of contract and breach of contract. Discharge and breach. Let's see, let's do it. Performance of contract. Correct, performance of contract, very simple. Then of course we will try to see a few question and answers, and okay, this is BCR. Okay, BCR only will have law also anyway. Jan 21. So as we can see, we have seen November 19. After November 19 was May 20 was COVID batch, so that got. Then Jan 21, December 20, July 21 also was there in between. So Jan 21, July 21, and of course May 22 anyway we are seeing. So May 22, these are all the papers. November 19, these are all the papers there. November 19, November 20, Jan 21, July 21, December 21, May 20. But before that also you had May 18, November 19 and May. This May 18 was the first ever paper that you had green color that time. Correct? May 18 was one, and of course November 18 also you had. And of course May 19 is the last. Basically all the papers, these are all everything is available on the institute website. Correct? So November 19, May 19, November. So you have 1, 2, 3, 4, 5, 6, 7, 8, 9 papers till now. 9 attempts they have asked all these questions. So every attempt, if you see, it is the same. Yesterday somebody came and told, sir, somebody told me contract is not important, it seems. I said, who is that somebody? Correct? So the thing is all rumors. Rather than seeing the question and answers, I asked him, have you seen the previous year's question paper? No, sir. Have you seen one or not even one? Not even one, sir. Sir, people told me only 3 marks will come from Contract Act. Correct? So which people? I asked. He had no answer. Correct? Yes. So BCom friends would have asked. So without knowing, we should not obviously, check. Without knowing every single question. See, first only how much? 4 marks question. This is the first ever question paper in the new syllabus, CA Foundation, May 18. See, first question only Contract Act. So you can never say that it is not important. 100% important. Then you see this. Come on guys, tell me the answer. State the exceptions to the rule. No consideration, no contract. Tell me. WB 2P 3C. W, written and registered agreement arising out of love and affection. B, bailment. Then P, promise to pay time barred debt. One more P, past voluntary service. Then 3C, C, charity. One more C, completed gift. One more C, contract of agency. That's it. You have to state like two lines. That's it. Actually, you no need to write the lines also because they have used the word state. But nevertheless, since it's 5 marks, just writing will not help. What should you do? Couple of lines, one line, two lines, you have to explain. That's all. This also we have done, no? Distinguish between wagering agreement and contract of insurance. See? Answer. Wagering means wagering. When you don't know the answer. Contract of insurance is insurance contract. Wagering agreement is not contract of insurance. Contract of insurance is not wagering. In a wagering agreement, wager will happen. In a contract of insurance, insurance will happen. Correct? Yeah. 0, no, minus. 0 also is a lot of marks for this. Minus you have to give, negative marking. Right? So, what is wager? What is contract of insurance? Happening or non-happening of uncertain future event. And wager is void, contract of insurance is valid. And wager, there is a win-loss situation, win-win situation. The main event is the main part of the contract in wager. In contract of insurance, it is collateral. That's all. 2 marks in your pocket. I am randomly seeing. See, next one. Examine with reason that given statement is correct or incorrect. Minor is liable to pay for necessaries applied to him. False. Minor is not liable. Minor's estate is liable. Minor's, correct. Then after results also come, will happen. Yes. Correct? Yes. Examine with reason that given statement is correct or incorrect. Minor is liable. No, minor is not liable. Minor's estate is liable for necessaries. As you can see, I told you in my notes, if you check, I just opened in front of you. I have really not gone through each and every question paper. This only will come. No. If you see, I'm just saying that particular answer we had written as a fill in the blank here. See? Minor's estate is liable for necessaries. So that is the answer. 2 marks in your pocket. You follow this material more than sufficient. Then this also is Contract Act. This we will see today. This is the void contract. Initially valid, later void. That one. Then Partnership Act, Sale of Goods Act, Companies Act, define OPC. See, define fraud. See, when definition comes, unfortunately, you need to write that. Suggestion as to a fact which is not true but believed to be true, acted, fitted to deceive, and this one, active concealment, little bit you have to write that, nothing can be done. When definition is given, you need to write. Whether mere silence will amount to fraud, answer. Mere silence will not amount to fraud. Because caveat emptor will apply. One small example you give, because they have told whether they are asking definition of fraud will have 3 marks, and whether mere silence will amount to fraud will have 2 marks. But exceptions to mere silence will not amount to fraud, where there is a silence, where silence equals to speech, and where there is a duty to speak. What happened? Zoom screen. What happened? Zoom screen. Okay. Which one? Or should I switch on the camera? Camera is there now. It's coming now. Isn't this? Screen not clear, it's blurred. Somebody is shouting. Yeah, 3 times he shouted. It's blurred, it seems. Blur. Maybe directly put OBS only. Yeah. Share. Yeah, I will make it full screen. Now it will come. Full screen. Yeah. It's the best way. It is clear now. Pakka 100%. Okay, thank you. Super. Okay, God bless you. Yes, done. Okay. So that's it. Define fraud. Whether mere silence will amount to fraud? No. But then the two things will amount to fraud, where silence equals to speech and where there is a duty to speak. See? How many examples? That is May 18. Then you see November 18. Jaundice paper, yellow color. Yes. So if you see this, this is what we are going to do today. That is the initially possible, later it becomes impossible. We will see that. See here, what is contingent contract? Discuss the essentials of contingent contract. Full yesterday we explained. What is contingent? Happening, non-happening of event. Then we saw example, ship return, ship not returning, those sections 30, 31, 32, 33 that you have to explain with one example. That's it. So if ship returning, that is happening of an uncertain event, non-happening of an uncertain event, happening of an uncertain event within a fixed time, non-happening of uncertain event within a fixed time. And then what is the conditional nature of the contingent contract? This will come in the last unit in your ISM. One unit is there called quasi contract and contingent contract. In that same whatever I have written is similar to that only, that will come in the exam. This is also so easy. Partnership Act. Though a minor cannot be a partner, he can nonetheless be admitted to the benefits of partnership. Yes, we know that. See here, Mr. Ramesh promised to pay 50,000 to his wife, Mr. Lolly. Not Lolly, lollipop and all, no, Lolly. So that they can spend the sum on her 30th birthday. Mrs. Lolly insisted her husband to make a written agreement. Smart. If he really loved her, you love me. Yeah. So Mr. Ramesh made a written agreement and the agreement was registered under the law. Mr. Ramesh failed to pay the specified amount to his wife, Mrs. Lolly. Mrs. Lolly wants to file a suit. Referring to the applicable advice. Answer. Exception for no consideration, no contract. Written and registered agreement arising out of natural love and affection. But you have to say that if this was related to force, mind you, should also add a note that she insisted. If he really loved her, insisted, no, if at all, as a note you can say, if it results in absence of free consent, then obviously even if it is written and registered, then Mrs. Lolly will not get the amount. Rajluki versus Bhutnath. Rajluki versus Bhutnath case. So easy. Correct? So easy, yes. That is what it is. No stories to be written. Mr. Ramesh thought of his ex-girlfriend. As Mrs. Lolly was always forcing. All those things you cannot write. Right. So if you see, next one. A shopkeeper displayed a pair of dress in the showroom and a price tag of 2,000 was attached to the dress. Mrs. Lovely, Lolly's sister, Lolly Lovely, looked at the tag and rushed to the cash counter. Then she asked the shopkeeper to receive the payment and pack up the dress. The shopkeeper refused to hand over the dress to Mr. Lovely in consideration of the price tag and the price attached to dress. Lovely, seek your advice. Answer. It is that pharmaceutical case, same copy paste. Instead of there it was some medicine or something, here it is dress. See, chiller questions, guys. If you write this and still fail, go to the mirror and I don't know, I don't want to say, but go to the mirror and see yourself. That's all. Alright, but then you have to write and practice. Write and practice, then you will come. What is this? Invitation to offer. It's a mere invitation to offer. Shopkeeper displaying the pair of shoes is invitation to offer. You going and asking that please pack it up is an offer. That will amount to rejection of offer. No contract is it. Seeks your advice whether she can sue the shopkeeper. No, that's all you. Basically provisions, analysis, conclusion. Provisions will be first an offer is what? What is an invitation to offer? And invitation offer results, can it be rejected? And then whether, then analysis, in the analysis what it is. That is pharmaceutical, one case law was there, no? That one. I said no need to remember the case law name, but this concept is important, right? So that is what? Doctrine of caveat emptor, Sale of Goods Act it is. Partnership Act. Very easy it will be, guys. Simply it look huge. Sale of, very easy it will be. Explain the modes of revocation of offer. How can you revoke the offer? Yes, all those. That basically how the offer can, no, this one. Modes of revocation of offer means what? Notice of revocation, lapse of time, all those things. State any grounds on which the court may dissolve a partnership. Okay, that you leave partnership, that's fine. This is internal management, doctrine of indoor management in Companies Act. Then, okay, Hindi version will start. I'll just open all the papers and show you. The three we have already done, others also, just so that you will have an idea. First question will always be Indian Contract Act. Answer this, guys. 4 marks. Sohan Lal, answer. Answer this very easy question. Four marks question. Very, very easy. Read, no problem. Sorry? Which one? Consideration. Which one? Come on. Consideration to third party. Correctly tell me. Consideration, can it move to a stranger? Can it benefit a stranger? Yes. Second one, this is a covenant running with the land. What are you saying? Covenant, benefit or restriction. Gave you an example, no, where one is that spiritual activity, then school, then college, then it went to bar and restaurant. So here there is very, very clear. They have written what? 9 acres your choice, 1 acre should be used for the son for carrying out farming activity. It's a covenant running with the land. So obviously as long as the land is there, 1 acre has to be given to that guy. Yes, total all. So that is a term of the contract, a covenant running with the land. Even this fellow may die, but the covenant will continue. See, you have to apply and answer. Correct? Good question this is. This is slightly tricky one. 2 concepts you have to add. You have to remember this. Yes. Mere silence is not somebody's boyfriend is texting, calling. Same again. Mere silence is not fraud. But there are some circumstances where silence is fraud. Explain. Which one? Silence is equal to speech. Then where is duty to speak? Neatly with examples you have to explain. They have given explain. 7 marks. Basically first is what is fraud. and how mere silence is not fraud, and what are the exceptions to where silence is also fraud. Duty to speak with examples. Any example you can write. Correct? Any relevant example you can write. This was a tricky paper. May 19 was little tough. See this. Mr. Rich aspired to get a self-portrait made by an artist. He went to the workshop and whether he could sketch. 50,000 full payment. It will be completed in 10 sittings and it shall take 3 months. On reaching the workshop, C had become paralyzed and would not be able to paint. Mr. C had a son who was still pursuing study and not taken father's profession. Can Mr. Rich ask Mr. K to complete the artistic work? What do you think? No. Can he ask for refund? Yes. Why? Is a void agreement or void contract? Void agreement or void contract? Void contract. Initially valid, later becomes void. So if you see, it is very easy. Of course, you need to learn how to write. You can go to the suggested answers and check out how they have given the answers. Caveat emptor. Discuss the essentials of undue influence as per the Indian Contract Act. Answer. Dominating will, using the will for unfair advantage of other. And then the next 2 points, that is having a real authority, apparent authority, fiduciary capacity. Next one, where the, when his mental or bodily or age or illness, when his mental capacity is disturbed, that you have to write thing and explain with example. 5 marks. So direct theory question will come or the case study based questions will come. Case study based questions will come. Then your BCR will start. Next, May 19 done, November 9. November 19 we have done actually. X found a wallet in a restaurant. He inquired of all the customers present there, but true owner could not be found. Quasi contract, yes, finder of lost goods point. We have seen that. Define consideration. What are the legal rules relating consideration? When at the desire of the promiser, the promisee or any other person has done or does or do or will do or abstain. Such act, abstinence or promise is called consideration. Then rules regarding consideration must move at the desire of the promiser. It can benefit a person, move from a stranger, benefit a stranger. It need not be adequate. It must not be illusory. It should not be physically impossible. All those things. Yes, it should be legal. Yes, very good. 7 marks. Correct? Need not be adequate. Need not be adequate. Yes. Mr. Sonumal, a wealthy individual, provided a loan of 80 to Mr. Datumal on 26/2. The borrower Datumal asked for a further loan of 1,50,000. He agreed but provided the loan in parts on different dates, 1,00,000 and 50,000. While paying parts and inches, lender should adjust. Okay, this one you will understand today only, priority of payment. Then I will solve that question at home, you will understand. This is what you have given me, different loans on different dates. I have given you one bulk payment. You will adjust it against the first loan or the most recent loan. That is the order of payment we will discuss now. No problem. That's easy. Explain the term coercion and what are the effects of coercion. Full thing you have to explain. Coercion, physical force, mental force, threat, and then detaining the property or threatening to detain, then committing a crime or threatening to commit, asset may or whatever you do, it is immaterial whether IPC was applicable or not. All those things you have to write. November 20. Basically, I am solving quickly all questions so that you will know, you will have that confidence. And now you tell me, that fellow told, no sir, people told me 3 marks will come in Contract Act. Every paper you are seeing minimum 20 marks. Correct? First question is anyway Contract Act. Mr. X, a businessman, has been fighting a long-drawn litigation with Y, an industrialist. To support his legal campaign, he enlists the service of Mr. C, a judicial officer, stating the amount of 10 lakhs would be paid if he does not take up the brief of Mr. A. Yes, restraint of trade. Restraint of not legal proceeding, restraint of trade here. Why? Because I am telling that fellow don't take up the job. So it's restraint of trade for him. And also at the end of refuses to pay Mr. C, decide whether C can recover the amount. So first of all, it is restraint of legal proceedings, it is stifling the prosecution. Second of all, most important for Mr. C, it is restraint of trade. You have to take up the case, what I am paying 10 lakhs and I am telling you not to, does not take up the brief of Mr. Y. Imagine. So you are going him and not saying you please work for me, don't work for him. That's okay. Guys, if you are my lawyer, will you be that fellow's lawyer also? No. This is not that case. I am going to him and saying, I'll pay you 10 lakhs, don't go to him. That is an agreement and restraint of trade. Define misrepresentation and fraud. Explain the difference between fraud and misrepresentation. With examples you should give. First you should define. That's why I am saying in that chapter, definition of coercion, fraud, misrepresentation, mistake, undue influence are very, very important. Every single paper, one question is coming for sure. So when you see the question papers, you will know, okay, what we have been studying all this while. This is performance of contract. Now we'll do this. But anyway, try to read. Mr. S and Mr. R made contract wherein Mr. S agreed to deliver paper cup manufacture machine to Mr. R and to receive payment on delivery of the goods. On delivery date, Mr. R didn't pay the agreed price. Decide whether S is bound to fulfill the promise. What do you think? R did not pay. Should he deliver? No. Why? It's not sale of goods act. Asking about contract act. Why? There is a breach of contract. This concept of breach of contract. Breach can happen on the delivery date also. So is it like actual breach or anticipatory breach? All that you have to do it. We'll see that. Correct. Mr. Y gave a loan of INR 30 lakhs. Mr. G defaulted on due date and debt became time barred. 3 years over. After the time barred, Mr. G agreed to settle the full amount to Mr. Y. Whether acceptance of time barred debt is enforceable in law? Yes, exception to no consideration, no contract, payment of time barred debt. Easy? Yes. A and B entered into a contract to supply unique item, alternate of which is not available in the market. A refused to supply the agreed unit item. What directions could be given by the court for breach of such contract? Contract of specific performance. I told you, when monetary compensation is not an adequate remedy, then specific performance. These 3 questions we will be doing it now, the concepts, right? Yeah. Next is what? Okay, Sale of Goods Act, Partnership Act. Again, enumerate the difference between wagering agreement and contract of insurance. And guys, they have told enumerate means what? You should write as numbers. Enumerate means number, numerical number. So basically it is better if you put a T format and that have the differences. That is enumerate. See this, age 58 years in a government department, going to retire after 2 years. I gave him 10 lakh rupees to retire now. Sale of public offices, agreement opposed to public policy. You have to explain that. Agreements opposed to public policy. Alright, yes. So cumulative remuneration, etc., whatever it is void. Define the term acceptance under Contract Act. Explain the legal rules. First one, acceptance should emanate from an offer. Second, acceptance should be unconditional. Very good. Any condition added will be counter offer. Next, only to the offeree. Then all that Bolton versus Jones and all these things. Terms of the offer must be maintained. It must be in the prescribed mode. And in a general offer, no need to communicate the acceptance. In specific offer, you have to communicate the acceptance. Along with case law names, you explain 7 marks. In at least 5 you will get for sure. So it's very easier said than done. You need to write and practice. Do not make the same mistake you made last time. This time at least write and practice. This is letter of acceptance, condition, warranty, doctrine of indoor. General rule is that agreement without consideration is void. Discuss the cases where agreement without consideration is valid and enforceable. Answer. Same. WB 2P 3C. Same stuff. No change. July 21. 2-3 papers will finish and then we'll finish off the other areas. Are you getting the confidence that at least, okay, something I know? Then you have to write. Writing, but at least you know the answers. That's all. Before you will be like, what is this? Which question is this? Which chapter? But now at least you know from which area it is coming. That is most important. State with reasons whether the following agreements are valid or void. A clause in the contract provided that no action should be brought about in case of breach. Void. A restraint of legal proceedings. You cannot say that, if there's a breach, you cannot go and put a case. You are actually taking away the right to sue. Where two courts have jurisdiction to try a suit, an agreement between parties, the suit shall be filled in only one of these courts alone and not in the other. Same. Agreement and restraint of legal proceedings. X offers to sell his Maruti car to Y. Y believes that X has only Wagon-R but agrees to buy it. No consensus ad idem. Void. X, a physician and surgeon, employs Y as an assistant for 75,000 per month for a term of 2 years, and Y agrees not to practice as a surgeon and physician during these 2 years. Obviously, it is valid. It's like an employment agreement. I am a surgeon and physician. You are my assistant. You also will be physician and surgeon. I am telling you, do not work elsewhere. Fair enough. 75,000 per month you are getting. Right? Simple. Explain the term contingent contract. It's like they also don't know what to give. Same thing. They'll keep giving. Indian Contract Act also discuss the rules relating to enforcement of contingent contract. This one is jointly borrowed. This we will see now. Right now, performance of contract. What happens if you jointly borrow? Can one person ask the other person to pay? Very simple. Right now, we'll do it. What do you mean by supervening impossibility? That is called doctrine of impossibility. We will see that right now. That's it. Then lost. May 22 we have done. December 21. See, all papers you have solved. So everything is there. Check this. Same joint promise. We will see this. 4 partners are there. They jointly promise to pay 6 lakh rupees. In that, 2 people have become insolvent. One fellow has paid on behalf of everybody. Can he sue the others and recover is the question. Answer is yes. So we will see that now. So that is the 4-mark question. Explain any 5 circumstances under which contracts need not be performed with the consent of both the parties. Means, what is this? Contract need not be performed with the consent of both the parties. Yes, termination of contract. They are asking about actually, what do you say? Discharge of contract. If you see in my notes, we will check that now today. All this we are done. If you see, all this later. What you have to write for that 7 marks is you need to explain this part, modes. Page number 24. Ways in which without performing, in that not even first point, second onwards. With the consent of both the parties, how can I end the contract? That is by lapse of time, operation of law, mutual agreement, especially this, novation, rescission, alteration, waiver, remission. All that we need to explain. This you have already written. December 21, you wrote the answers yesterday. What is meant by quasi-contract? State any 3 salient features of quasi-contract. What is quasi-contract? That full paragraph that I had given, you have the principle of unjust enrichment. So salient features, again with examples you can explain. Like finder of lost goods will be called as a bailee. Then your, especially if anything delivered under for mistake or coercion must be returned. Those features you have to explain. Easy guys, very easy. Subsidiary company is the next question. So, and May 22 we have already solved. We have seen the question. So all the papers solved. If you see every paper minimum 20. First question guarantee contract act. And 1 7 mark, 1 6 mark, 1 5 mark will come. Overall 20 to 22 every single paper. 1/3 of your paper will be Indian Contract Act. That's why, whatever time was there with us, I wanted to finish this chapter, because other things you can do on your whatever. Either, I don't know whether I will come or whoever will take, a KM sir will take, I'm not sure. But whatever it is, it's going to be like that. So if you see, let's go on top. Performance of contract. Performance of contract takes place when the parties to the contract fulfill their obligations arising under the contract within the time and prescribed manner. Duties of the parties are what? You should either perform the contract or even offer to perform the contract. Performance will happen when I fulfill all my obligations. Duties will be what? I should either perform or offer to perform. For example, if the class is today 2 p.m., I come to class, none of you are here. Correct? Mass bunk. Correct? Legend Part 2 movie has released, you have gone first day, first show. Correct? Then, when I am sitting here 2 to 3, I wait for you, nobody comes. Can I ask my hourly rate from KSA? I am paid hourly rate. Can I ask KSA, pay me my hourly rate? Why? Can KSA say you never taught? Yes, I will say, boss, I am ready to perform the contract. If that person is not there, I can't help it. Correct? If that person is not there, it is, if you are there already, that's it. So one is what? Perform is one. Second is what? Offer to perform. Offer to perform. And offer to perform, if I am ready to perform the promise and the other party is not there, I cannot help. Right? Like for example, you go to a, psychiatrist or somebody, that person charges by the hour. If you don't go that day, they'll say, boss, or in a doctor's appointment, generally speaking, generally they have the right to do. Will they do it though? No. But if a doctor is coming only for you from all the way from some other place, and if only for you are coming and you do not obviously, what do you say, arrive on time, can he charge the full hourly rate? Yes. can be done. So that is perform or offer to perform. There are 5 conditions. First, it should be unconditional. What? The offer to perform, it must be unconditional. No conditions attached. It cannot be a counter offer. Made to the promisee or one or more joint promisees, or even to the authorized agent of the joint promisee. So basically, promisee means one person. Joint promisee means what? 3-4 people come together, and that's called as a joint promisee. Who is the authorized agent? Whatever I can do to you, whatever I can offer to you, I can also offer to your agent. All your official things can be shifted to somebody else. It's called as the authorized agent. Made at the proper place, proper time, proper form. Made at the proper place, time and form. Means what? If I have entered into a contract to come here at sharp 2 o'clock, I have to be there at AGR 3rd floor, yes, and form. Form is face to face. If all the 3 are done, then yes. I cannot sit in my room and log in and say, I am ready to perform the contract via Zoom. No, that is not unconditional. You are adding conditions. What was agreed was face to face. Correct? So, made at the proper place, time and form. Form means what? Face to face in this example. Mode, yes. Promisee should have reasonable opportunity to ascertain that promiser is able and willing to do the whole of his promise. What do you mean by this? Should have reasonable opportunity to ascertain that promiser is able and willing to do the whole of the promise. So if you should have an opportunity to ascertain, because these are all the conditions, you should know that I am ready to fulfill the promise. Even at the slightest hesitation, if you feel that I am not ready to fulfill the promise, then it will not amount to offer to perform. Ultimately, you should see that, okay, tomorrow when you come, let's say you come late, I'll charge what, like for example, with KSA, I'll charge 1 hour. They will say, they will ascertain whether I was able and willing to do the whole of the promise. They will say, 1 hour were you sitting here, or you went down, had coffee, had fun, and then came and claiming 1,000, whatever it is, 1,000 rupees, 10,000, 5,000, whatever hourly rate. Are you charging with KSA from KSA by actually showing that you are not at all willing? One of you only have message, sir, we'll all be in the movie, do not come. But I come here, and I know that you will anyway not come. I wanted extra money. So what I do? I'll come here. I'll keep my bag here. Then go down. I'll have a nice coffee. I'll go to the faculty room and sleep off for 1 hour. And then I'll come to KSA and say, pay. I was ready to perform. No. That's what they say. Whether they are able and willing to do the whole of the promise. In case of delivery of goods, promisee should be given reasonable opportunity of inspecting those goods. So I am ready to perform the promise. I have performed also. When will I get the payment? What are the conditions? First of all, you should see whether the goods, whatever I delivered, are correct or not. So if you, let's say I had ordered books for you, the books come. Directly will they release the payment? No. First they'll check the books on a sample basis, or they'll distribute to you. Then 3 of you will stand up and say, sir, in this pages are missing. So will you pay for all the books? No. So that's what. It should be given reasonable opportunity for what? Inspecting the goods. Effect of neglect of promisee. The promisee is bound to afford reasonable facilities for the performance. If you tell, sir, please come to my home and do this personal coaching for 3 hours. I come to your house, assume, correct? And then what happens? You are not there only. You have gone out for some movie. Or you have gone out with your girlfriend, boyfriend and all that. I am standing there like a chaprasi in front of your house, waiting. Correct? Now I will call you, you don't pick the call. Can I charge whatever rate we had agreed for 3 hours? 100% yes. Because the promisee is bound to afford reasonable facilities for the performance of the contract. Some people hire singers and all for home. Have you seen? Like for example, if you have some marriage function or some function in your home only, some puja will be there. So they'll organize music. bhajan, kirtan and all they'll organize. So the thing is, so when kirtan is organized, obviously you should give them a place to sit. Correct? Full seats everywhere are there. That bhajan fellow will come. Okay, sir, sing. What will stand and sing? Where? Correct? For sitting down, you should give some space, and you should give, an entire decent acoustic area. Something, at least some mat you put, at least something for him to sit, so that he can perform. See, mic etc. are different. For bhajan, at least you should have an area to sing, and he would have specified, I want harmonium, basic stuff, or that instrument, just to, tune your shruti, that is your, that this instrument will be there, no? Shruti box, it will be doing, that box. So that box should be there. Correct? You have not given anything. Then how can you say that you have made the promise? Then can that fellow say, sir, I wasted my time coming all the way, give me my payment. No bhajan, no kirtan, give me payment. Correct? Yes. So if you see, if the promisee does not provide reasonable facilities, promiser is excused from such neglect. You cannot say, I have committed I have neglected here. I have come all the way. I am ready for you to give me the at least facilities so that I can perform the contract, as to any non-performance caused thereby. Who can demand performance? Obviously, if I have promised to you, only you can demand performance. Only the promisee can demand performance. What are the exceptions? Exceptions are the same as doctrine of privity of contract. We have seen. If a trustee dies, for example, can the beneficiaries do it? Yes. And in that case, marriage settlement, father and father-in-law, in that father dies, can the daughter-in-law still sue the father-in-law? Yes. All those things. Same. On the death of the promisee only dies. Then if it's a personal contract, it becomes void. If it is related to sale of goods, etc., representatives can demand the performance. If you see that example where he was drawing a portrait and he was paralyzed, then representative cannot demand performance. But if it's a sale of goods or something related stuff, yes, definitely can demand performance. Who can perform? Only by promiser, especially if it is facts of the case, personal skill or personal confidence. Nature of the case, personal skill or personal confidence. Who will do it? Only the, like for example, that's what. If I ask somebody to come and train, if you hire somebody to become your cricket coach or anything for that matter, only that person should come and do it. Nobody else. That was the foundation of Bolton versus Jones also. I went and said, I want to buy leather from you only. If somebody else supplies leather, will it hold good? No, it will not hold good. It will not hold good. Performance by joint promisers. Who is joint promisers? 4 people or 2 or more people promise a set of people or one person something. So, if it is a promise by joint promiser, on the joint lives, all of them are liable. So it's a joint promise. For example, forget about KSA. If 4 of us come together and say, look, these 4 subjects we will teach you. Not like an academy, but 4 together, jointly we are promising to teach you 4 different subjects. And until we are alive, all of us have to perform the contract. One of us die, one of the promisers die, then still, if it's especially related to sale of goods related stuff, if it relates to sale of goods, 4 people jointly decide that they will sell the goods to you. If one of the person dies, representative plus others, legal representative plus the other living people. So if A, B, C, D have agreed to, or you have a joint promise to sell goods to E, if A dies, then B, C and D and the representative of A should do it. Death of the last survivor, A, B, C, D all die, then the representatives of all promisers should come. Very, very simple. What happens to the liability, guys? since it's a joint promise, liability is joint and several. What do you mean by several? Individual. Several means individual liability. Not only the liability is joint, but also it is several. Individual liability. Default by one promisor. One fellow does not provide the goods, others have to bear it. Others have to share the loss equally. Others have to share the loss equally. A, B, C, D jointly have promised E. A doesn't have money. He has become insolvent. A will come and beg Mr. E, saying that, sir, please release me. Otherwise, court case and all will happen. I don't want you to get involved. Please relieve me because I really do not have money. So E will say, okay, you need not pay. He will tell A. But the liability of A, B, C, D is joint, right? So A, B, C, D together have to pay. If A has been released, who will pay now? B, C and D. Release of one joint promisor. Will it release the other three also? No way. Does not release the others. Released promisor is liable to other promisors. Obviously, A has been released. B, C, D have paid on his behalf. Obviously, A is liable to pay B, C and D. Same question was there in the paper. 60,000 something, then he gave it to somebody. So now basically one fellow became insolvent, others only paid. So when the other people, and whoever paid, can he recover from the remaining people? Yes, that was the question. So this you have to write. This is 4 people promising one person. What if one person promises to 4 people? The same thing, transferring of goods to 4 people. Then on the joint lives, it is all of them are liable. Death of one promisee, same, representative plus others. Death of last survivor, representative of all promisees, same stuff. But the right of suing is not individual, right of suing is joint only. All of them jointly can sue. When a person has made a promise to 2 or more persons jointly, these persons are known as joint promisees, obviously. Correct? Unless a contrary intention appears, the right to claim performance rests with all the joint promisees. As I told you, right is joint only, not several. It is joint only. Unless the contract says everybody can, even one person can lodge a case. Next question is a simple question. What is the time and place of the contract? What is the time and place of the contract? I have ordered a refrigerator from Chroma. I have ordered refrigerator from Chroma. I have promised to pay whatever amount. I have paid the down payment. Remaining, I will tell you, please deliver. Then I will definitely make the payment. I will definitely make the payment. Who has or let's say you have made the payment also. It's okay. You have made the payment. Who is the person who is going to, what do you say? Who has promised to pay you the goods? That is the Chroma. Chroma is the person who has promised to pay you the, send the refrigerator to you. They have promised to send the refrigerator. Now, who is the promisee? You. So, Chroma will say, sir, where to deliver, how to deliver, you tell me, I will come at the respected time. You have not told anything to Chroma fellows. Will he come? Can you sue him for not coming? No. So if you see, promiser, that is you, Chroma has not undertaken to perform without application by promisee. Double negative, has not without, convert to positive. Chroma has undertaken to perform only with the application by promisee. I repeat, Chroma has undertaken to perform only with the application by promisee. Means what? Chroma is telling, we will deliver the goods only if you apply. Apply means what? Tell us the time, place, date, we will come. Then it is the duty of the promisee, that is you, to apply for proper place and within business hours. It is your duty to apply for proper place and business hours. When no application is made, what will happen? When no application is made, and especially time is also not specified, perform within reasonable time. Perform within reasonable time. Reasonable time means what? Depends on the facts of the case, depends on the goods also. If for example you are selling bun or bread, what is reasonable time? 30 days? No, within 3-4 days it will go stale. So reasonable time will be 2 days. It will go stale. It will not, it's a perishable item. What if it's like bananas? What if it is mango? Same thing. Depends on perishability of goods. Otherwise, generally it is 30 days. But then depends on perishability of goods, right? So perform within reasonable time. If the day is specified, perform during normal business hours. Correct? If one specific day they have given, during the business hours you have to perform. If you say come on like Saturday, you should go on working hours. You can't call them at 11 p.m. at night for delivery of goods. It will be normal business hours. Generally 10 to 6 it will be. 9 to 6 or 10 to 6. That's it. You cannot go beyond that, ideally speaking. Place also not specified means how will I deliver, guys? So obviously promise her to apply for appointment. So the chroma fellow will call and say, sir, please let me know. Yes, that is for time and place. Very, very simple. Next, time is the essence of the contract. Classic example, contract between KSA and fast track students. What is the time? When should the contract be performed? At least before December exam. Correct? At least before December exam. Before exam it has to be completed. Performance of promise is to be made within the specified time period. Performance to be made within the specified time period. What is time period in the example between you and KSA before your exam? Upon default, let us say they don't fulfill, the party, that is you, can rescind the contract. Means what? Cancel the contract and claim damages. What are the types of damages? We'll see. You can claim damages. When time is the essence, as of now, at the option of the promisee, the contract or so much of the contract which has not been performed becomes voidable. Means what? Now let us say I have finished 80% of the crash course, 20% not done. All subjects 20% pending. You have paid, let's say 1000 rupees. I'm just saying 1000 rupees, 80% done, which means 800 rupees worth of services they have given. 200 rupees worth of services they have not given. Now time is the essence of the contract. Can you cancel the contract or not? Yes, you can cancel, or you can demand specific performance, because you will say money I don't want, perform the contract, but leave it, that you don't want, you want money only. So now the question is, can you cancel the contract? Yes. At the option of the promisee, that is you, the contract or so much of the contract that has not been performed, 20%, will become what? Voidable. Means what? You can make it valid also, or you can make it void also. How will you make it void? You will say, sir, that for that extra 20%, please give me refund. And not just that, because of I trusted you and you did not complete the portions, I will sue, damages also. What is making the contract valid? Performance also if it's not there. What is that? I will tell you, December exam will be very difficult. I'm just telling you, I'll tell this December exam will be very difficult. Why don't you write in May? Example I'm telling, December exam will be difficult. Why don't you write in May? You will say, okay sir, anyway I was also thinking, for you good only. Abba, who will sit and practice? We can aram say write, we easily will write, you will think. You will agree, okay fine. Now tell me guys, can you cancel the contract for not performing the contract? No. Because you have agreed for delayed performance. That is making the contract valid. What is making the contract valid? Agreeing for delayed performance. Agreeing for delayed performance is making the contract valid. Next, last part. Compensation cannot be claimed if the promisee accepts delayed performance. Obviously, you have agreed to write in May. Can you claim delayed performance compensation? No. Yes, when notice was already given, however, compensation can be claimed if there is some concept in the agreement itself saying that for delayed performance a notice has to be given, and once notice is given you can claim compensation, then it's a different thing. When time is not at all the essence, let's say you are writing November 23 batch. November 23 batch. The proposed completion was December 22. They have not done. Is time the essence or not? No. Because you are writing next year. If that be the case, will it become voidable or not? Not voidable. But one extra thing, promisee, that is you guys, will be entitled for what? Compensation. Promisee will be entitled for compensation. These are all the important rules. This example they had given, this joint promise is one of the question papers. Then one question paper that I showed you, he gives loans on different dates. Which loan to set off? Different dates he will give loan. That is point number 11, last point. Appropriation of payment. When a debtor owes several distinct debts to a creditor, in 1 year, January he'll give one loan, February he'll give one loan, July he'll give one loan. So first loan is 10,000, second loan is 20,000, third loan is 35,000, like that. This was, let us say, in 2019, 2020, 2021. Now we are standing in 2022. I have repaid today 30,000. This 30,000 is towards 10k, 20k, 10 plus 20, or is it 10 plus 20 out of 35? What? We don't know. That's why first rule, debtor should intimate the order. Who should intimate? If you are repaying, you should tell, sir, this is the structure. In that, please recover 10,000 first. And from this 10k, please recover 5,000. And from this 35,000, please recover 15,000. Whatever you want, you can tell. What if you don't tell? No, this guy, creditor can do whatever he wants. Creditor can do whatever he wants. If order also not given, creditor also doesn't do, then chronological order. FIFO, first in, first out. First in, first out. What if, one example, what if this was a 2015 debt? Time barred debt. Now, the debtor doesn't tell anything. Can you recover against that? Law says yes. Law says yes. See, creditors can apply the payment against time barred debt also if the debtor does not intimate. If the debtor does not intimate, you can claim against what? Time barred debt also. They say apply the payment first against interest payment, and when fully paid, apply the payments against the principal. First payment should be what? Against interest. Second payment, principal. Obviously, principal payment will be later. First will always what will go? Interest portion will go. Interest portion will go. Right? So these are very, so that question they had asked was this only. He had given on different dates. And one bulk payment he made. They asked a question, what is the order? What is the answer? Debtor intimates the order, follow the order. If order is not there, discretion of the creditor. Otherwise, chronological order. And first what will he recover? Interest. Then what will he recover? Principal. Got it? Yes. So let's watch a video. After the video, discharge of contract and what? Breach. Discharge of contract and breach. So we'll try to finish as soon as possible, and if you have any doubts we can clear. That's it. Because I don't want to start any new chapter, because if I do not get any class, I don't want to hang you in the middle. So let's not do anything. because I don't know. If it's there, anyway we can take other things. I simma don't want to tell last class guys, see you in inter, all that dialogues I'll not give today. Yes. Alright. Let's watch Nityananda now. Let's watch Balaya video. Yes, Balaya. This is what? If you watch his movies, that's all. Yes. Right. So, let's see. Discharge of contract. So, if you come down to this, one chart is there here. Here, just come down here. There, see this, check out. Page number 30, 30. There's a chart, page number 30. If a promisor agrees to perform the contract, then to the promisee, then for promisor-promisee agreement, it becomes an agreement. No problem. If the promisor has performed the contract, you have to ask the question whether it is a yes or a no. If the promisor has performed it, next question is, has he performed within prescribed time? If that is also a yes. Next question, prescribed mode. Yes. Then it is performance of contract. For example, I have promised to torture you. Have I tortured? Yes. Within the prescribed time? Yes. As per prescribed mode, face to face? Yes. Then it is called performance. On the other hand, if I have not performed the contract, next question is it impossible to perform? If it is a no, it was not impossible to perform, but I still didn't perform, then it amounts to a breach. Breach means violation of the agreement. Is it impossible to perform? No. Is it impossible to perform? Yes. Correct? Let's say I am incapacitated, I am not well, whatever, it's impossible to perform. Then contract is excused. On the other hand, here, was it done within, has it performed? Yes. But did it happen within time? No. Still it's a breach. Was it as per prescribed mode? No. Still it is a breach. But before a breach, you may agree to you may say, okay. Like if I say last few days, or because of that chicken pox, whatever it is, you had some online classes and all, no? So that again is what? It is not a breach. It would have been a breach if if they had not communicated to you and obviously informed you and requested your cooperation. Otherwise, it would have been a breach because the classes are face to face. Now, due to circumstances, it may be shifted to online, and of course, they would request and they would do the needful. So, if you see breach, that is violation. In all these cases, here it is a breach, and then what will happen? The contract will get discharged. Contract will get discharged. On the other hand, in this case also, contract will get excused. That will also relate to discharge. Means contracts come to an end, either via performance or via breach, or the contract becoming impossible to perform. Contract becoming impossible to perform. This is called as what? Discharge of a contract. So what are the modes of discharge is what we have to see now. Check it out here. Modes and then breach. Types of breaches and remedies for breach is what is pending. See, discharge of contract. The various types of discharge of contract are: first, by performance. Various modes of discharge of contract is what? By performance. What do you mean by performance? When the contract comes to an end. When two people are entering into a contract and the contract eventually comes to an end, then it is called performance of the contract. So when the crash course ends, all the classes are over, the contract between you and KSA are executed, performed. So contract is discharged. Discharge means what? Comes to an end. Simple. Second, by lapse of time. If there was a contract, let's say you had made an offer and you should have, let's say you have a voucher, 1000 rupees voucher of Amazon, you should have accepted it within one month. Let's say you have accepted also. Now you have added it to your wallet. It is going to expire within 1 month. You have already accepted. Now you have to buy something. You need to buy something. you will take your own sweet time to buy. After 1 month, that 1,00,000 rupees will go off. What do you think? Is it discharge contract? Yes. Because 1,000 was cashback or whatever amount was credited to your account. You had all the time in the world to actually just buy something, but you didn't do. Contract will be lapsed. Lapse of time. Next, by operation of law. By operation of law. Obviously, in a personal contract, one person dying, what will happen to the contract? Come to an end. One person, death of a person will put an end to the entire contract. Similarly, insolvency. If one person's liabilities are far in excess of the assets, if he is insolvent, the contract will come to an end. Nothing can be done. Merger of rights. Merger here is merger of rights. If I take, for example, AGR third floor, this as on rent, I will take it on rent and I am paying rent to KSA. I am taking it in my personal capacity and paying rent. Do I have a right of ownership or do I have a right to use? Right to use. I do not have a right of ownership, I have a right to use only. Fair enough. Next, I'll be paying rent to KSA. Let's say 6 months later, I buy this full building. I buy this building. Now, do I have a right of ownership or right of usage? Both. Right of ownership and right to use also. Now tell me, will I pay rent to myself? Rental agreement, it's still in force, but because of me buying this entire land, entire building, will the rental agreement stay or will the rental agreement, be cancelled or discharged? Discharged. That is called merger of rights. What is the inferior right? Right to use. What is the superior right? Right of ownership. The inferior right will merge with the superior right. That is called merger of rights. The inferior right will merge with the superior right. That is called merger of rights. Unauthorized alteration of terms and conditions. Unauthorized alteration means if you do some forgery without authorization, if you alter the contract, this will all end to breach, that is discharge of contract. It will be violation of the entire contract. So unauthorized alteration is also called as breach of the contract. Lastly, vesting of rights. Vesting of rights means what? Vesting of rights. A has to pay B 200 rupees, B has to pay C 200 rupees, C has to pay D 200 rupees, D has to pay E 200 rupees, eventually E has to pay A 200. Through a circular motion like this, whatever the person who owes money and the person who's owed the money, if they are same, what happens to all the old contracts? 200, cancel, 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 cancel. So this fellow has to pay 200, receive 200. If on the other hand, if it was some higher amount to the extent of 200, it is cancelled. Remaining 100 he has to pay. So that 200 through this circular motion only, it will get cancelled. That is called vesting of rights. That is called vesting of rights. Correct? Death, insolvency, merger of rights, unauthorized alteration, vesting of rights. Then next one, mutual agreement. Mutual agreement. You have many things here. One is novation. Nova means something which is new. Nova means something new. Novation means what? New contract will come in place of the old contract. So novation. Here parties also may change. Parties may change. If I am handling CA classes in some college, midway, I have my training academy will be handling CA classes in a college. Midway they'll say, sir, I'll go and say, sir, sorry, from today I have stopped his entire teaching, etc. Don't worry, I have one more friend who will now take over from me. So now I will introduce KS Academy. They'll say KS Academy will take over from here. Now the contract has to be changed or completely new? New has to be done, no, within KS Academy's name. So when the parties to the contract will change and a new contract will come in place of the old contract. It is called contract of novation. What happens to the old contract? Discharged. Discharged. Rescission means what? Termination. Mine and your contract is going on and they are not happy with my classes, so they'll only come and say, mutually let us say that let's end the agreement. This also was an exam question, 7 marks. Explain the various modes of discharge by mutual agreement. How can they mutually agree to not fulfill the contract? These points you have to explain. You have to explain what is novation with an example. Any example you can take. Then you have to explain what is rescission. Rescission means termination. Things are not working out, so let's cancel the contract. Fair enough. Cancellation. Mutually they are cancelling. Mutually they are agreeing to close rather than go ahead and simply waste time, me suing you, not happy with the performance. Instead of that, let's shut down. Third, alteration. In alteration, what I'll do? Change the terms and conditions. Guys, in alteration, parties will not change. Parties will remain the same. In novation, parties may change. And it's a brand new contract in place of the old contract. Here it is merely changing the rate. By mistake or rather old GST rate, let's say, was 18%. New GST rate, if they change it to 25%, I have written 18% in the contract. I need to alter. Because otherwise I'll have to pay 7% extra to the government from my pocket. So I will tell them, sir, sorry, let's change the agreement. Parties will remain the same. Some terms and conditions will change. That's why it's called contract of alteration. Then what is remission? Remission means what? It is accepting lesser fulfillment of the promise. Remission means what? Accepting lesser fulfillment of the promise. For example, I have taken 10 lakh rupees for 2 years at the rate of 15% per annum. This is one. Because I am unable to sort of pay, I will tell, can you please make it 9 lakh rupees? 1 lakh, can you give me like a discount? Is this remission? Yes. Remission means what? Accepting lesser fulfillment of the promise. Accepting lesser fulfillment of the promise. What is the lesser fulfillment here? 9 lakh. Or I can do one more thing. I can keep this 10 lakhs. I can keep this 10 lakhs. This 2 years, I can give extra time, 3 years. This 2 years, I can give him extra time to pay. 3 years I'll give. Rate I'll keep the same, 15%. This is also remission. This is also remission. Third one, I will keep it 10 lakhs. 2 years only I'll keep. Interest rate I am going to reduce. Everything is an example of contract of remission. Remission means accepting lesser fulfillment of the promise. What if I say, because there is bad time and because I have lot of money, no problem, and because you are a good friend, do not pay this 10 lakhs only. No need. What is that called? Complete remission. You would have seen farm loan dash waiver. Waiver. Waiver is what? Relinquishment of right. Waiver. Relinquishment of right. Relinquish is to give up. Waiver is what? Relinquishment of right. That is the meaning of waiver. Relinquishment of right. Impossibility of performance. Impossibility of performance. There are two types of impossibility. One is inherent impossibility. One more is subsequent impossibility. Very simple. Inherent impossibility is of two types. Inherent. Second, subsequent. Inherent impossibility means what? Impossible from beginning, that is void agreement. Inherent means what? Void agreement. Subsequent means what? Void contract. Subsequent means void contract. Initially possible, later it becomes impossible. This we have already taken the examples of what are all the subsequent death of the parties, destruction of subject matter, all those things. Then contract becoming unlawful later, law changing, government policy changing, all those things are subsequent. Inherent impossibility is what? Void agreement. This also we know. Agreement with minor. Then you see example, A agrees with B to discover treasure by magic, all these things. Subsequent impossibility is also called supervening impossibility. Supervening impossibility. Subsequent impossibility is also called as doctrine of frustration. Doctrine of frustration in English law, or also called as doctrine of supervening impossibility. Doctrine of supervening impossibility is also referred to as doctrine of frustration. It means a premature termination of a lawful contract due to certain intervening events or change of circumstance, which fundamentally strike the foundation of contract. Because of some events or conditions, the main foundation of contract only will go for a toss. Doctrine of frustration. Contract is deemed to have become impossible and thus void under the following circumstance. We already know, guys: death of the party, destruction of subject matter, non-existing of condition, change of law, declaration of war. We know all these examples. So automatically it becomes void. So in all these cases here, in all these cases, contract will become void. In all these cases, contract will become void only. It will become void. In all these cases, it will become void. Right? It will become void. Next, non-existing of conditions. Like A and B contract to marry each other. Before the wedding, A goes mad. Contract becomes void. Void ab initio. Or initially it was valid, but later it became void. Not void ab initio, void contract. A and B contract to marry each other. After the wedding, A goes mad. Contract becomes valid. Yes, valid. So change of law. Change of law also, if the law is changing, of course, liquor ban, whatever it is, contract becomes void. Declaration of war also, same thing. But guys, some examples. Let's say you become a chartered accountant and you will say, I want to go on a helicopter ride. That is my dream. Go on a helicopter ride. Let's say Chennai offers helicopter rides also. Bangalore definitely has helicopter rides where to the airport. Like that, Chennai also has helicopter ride to the airport. You are a CA, for you no tension. Helicopter ride will cost 5,000 rupees from whichever place to the airport, and from there you take a flight to Bangalore. That is some 3,000 rupees. That's the best part. To reach the airport, 5,000, and from Bangalore to Chennai, 3,000. But it's okay. You go to the Bangalore. Let's say you want two objectives. One, you want to ride the helicopter, and then you want to see Chennai city from close quarters, not from the flight, but it's from closer quarters. You want to see Chennai city. That is first objective. Second objective is you want to travel from Chennai to Bangalore by flight. Fair enough. You are reaching the airport only because you have a flight to catch. Now you are mid-air in the helicopter, you are enjoying everything. Suddenly you get a message, flight cancelled. Can you tell the pilot of the helicopter, Anna, here only drop off, Anna, here, right side, drop, correct? What, it's on auto, correct? Anna, signal you drop there only, yeah, correct? No. Or can you tell, I can see my house, I'll jump from here only. Should you pay that 5,000 or gone? Have to pay, you have to pay 5,000 rupees, no choice. Is it, now this has become impossible, this is still possible, no? Is it partial impossibility or what do you say? Full impossibility, partial. partial impossibility is not supervening impossibility. RCB versus CSK match is going on. After 3 overs or after half the match, it starts raining. Correct? Then it's washed out. Is it partial impossibility or full impossibility? Partial. Partial, because half the match is over. So what do you think? Can you cancel the contract? No. So if you see here, partial impossibility is not supervening impossibility. So read, A let out a boat to A to view the naval review at the king's coronation. So after party died, the other fellow is becoming the king. He's already become the king. So when he was becoming the king, that ceremony also I want to watch. Plus I also want to watch the entire procession etc. that they carry out. Because of the king's illness, the ceremony was cancelled, but procession still happened. Can you cancel the contract? No. So held the contract can be discharged, cannot be discharged. Cannot be discharged. Contract cannot be discharged. Next, commercial impossibility. Commercial impossibility. What is this? Commercial or even difficulty of performance. Can you say because of COVID, suppliers are not there, these people are not there, those people are not there, I cannot fulfill the contract? Sorry, no. When you entered into a contract, you should have taken into account all the ifs and buts, all the possibilities. Just because now it has become commercially unviable, you cannot cancel the contract. Commercial impossibility or difficulty of performance will not amount to supervening impossibility. You can read these examples later. In all the cases, can the contract be discharged? No. Contract cannot be discharged. Cannot be discharged. Default of a third party. Sir, supplier did not supply the goods to me. I know I was supposed to print this many books, but paper supply only is not there. Customer will say, I don't care. What, in the entire world only one supplier is there? Huh? No, many suppliers are there. Go get it done. So A is definitely discharged and is liable for damages. Like all these things you cannot do. This we have already seen. Merger of rights, unauthorized alteration, all that example. Last two concepts, guys, done. What is that? Last concept, breach and remedies for breach. So you can go early, good or bad. Yeah, so decently 20 minutes, sit properly, I'll finish this, then you leave. Breach. Second, what I'll do? Second session, over. That's it. Oh, go home. Breach. Oh, over. Okay. If you attend properly, then no second session. If you shout, talk and all, I'll do again contract act, revision of revision. For me, what? I'll get paid for that thing, but I don't want to simply do that because I wanted to go home and study. In 2 hours, I cannot revise any other chapter. And I don't want to, stop a chapter midway because I don't know the future, this thing. Because that day when they said you only have 7 classes. In that, this is the 6th class, which means the next class is the second session. So the thing is, I don't want to later, say them telling that this other small portion also, I cannot finish any revision in one class. A partnership act cannot be finished in one, or anything, LLP cannot be finished in one. There are needs, lot of, and for LLP I have to do Companies Act first. I cannot blindly start LLP. And Companies Act requires minimum 2-3 classes. So I don't want to start something or left in the middle. That's not my idea. So they said one chapter I finished. Now I am not a person who will sit and drag. 2 o'clock class coming at 2:30, drag, make you write. I am not like that. So I will come on time, leave on time. That's it. You have already seen. Only if there is any technical issues, I cannot help it. Otherwise, it's always time to time. So if we drag, I can still go finish easily, but that's not the point. You go home and you study. I want you guys to bloody clear. Enough of flunking. So, just pass the exam. Correct? So when I finished, my thing was to finish Companies Act. I'm doing it. If it is doing it on time, by covering everything, including the paper, I don't want to hold you back just for my early payment, and I'm not that kind of a guy. So you guys go home, you study. That's it, right? Those who will study anyway, but you will get that extra 2 hours. I will go chill. For me, no tension. Yes. I'll go to the couples beach. Single I'll go. Yes. Yeah. Beach. Correct. Ah, okay. You are more excited than me. Okay, fine. Breach. Breach is one breach. Then one more what? Remedies for breach. One is breach. Another one is remedies for breach. Breach of contract means what? Breach of contract means violation of contract. Breach of contract means violation. Breach is of two types. Actual breach. Next is anticipatory breach. Sheila breach. Correct. So actual breach and anticipatory breach. Actual breach and what? Anticipatory breach. Actual breach means what, guys? The breach or violation happens on the date of performance, or actual breach, what happens? It happens on the date of performance or before. Or before or during, not before. Before is anticipatory. This is on the date of performance or during the course of performance. One example they had asked, no, that person decided to transfer certain goods and pay on that day. On that day, that fellow did not pay. Is it actual breach or anticipatory? Actual. Actual breach happens when? On the due date or during the course of performance. On the due date or during the course of performance. That is actual breach. Actual breach happens when? On the due date or during the course of performance. What is anticipatory breach? Before the due date. Anticipatory breach is before the due date. Which means what? Basically, let's say you are enrolled for a crash course, with me, and 3 days before the crash course, you will get one TV notification where I am holding slate in the jail. Yes, they say, this fellow, claimed that he is a chartered accountant. Correct? Claimed that he is a chartered accountant, but he is not a chartered accountant. Scam. One slate I am holding. Then number slate. Then side pose, this side pose, everything. So now, I have taken money from you already. I have already taken money from you. What will happen? Can I continue or not? No. Already taken money, gone. Nothing can be done. So what will happen to that breach? It is called anticipatory breach. Before the due date of performance. Before the date of performance. On the due date, before the due date is one. On the due date, during the course is one, and before is the other one. On the due date, on the date of the crash course, I will say I will not perform the contract. During the course of the agreement means midway I will stop. So all these are examples of breach. So that's what is given here, anticipatory breach. And what are the consequences of anticipatory breach? If I do it before only, what is the consequence? Where a party to the contract refuses to perform his part of the contract before the actual time arrives, the promisee may either do what? Rescind the contract. Means what? Cancel the contract and treat the contract as having come to an end, and at once sue for damages. So they can what? Rescind the contract, cancel the contract, and treat the contract as having coming to an end. So before that breach, anticipatory breach only, what happens? I can cancel the contract. I can cancel the contract and say it is coming to an end. Or I may choose not to cancel. He may elect not to cancel, but to treat the contract as operative. Treat the contract as operative and wait for the performance, and then hold the other party liable. He may choose to rescind. He may choose not to rescind. If he chooses to rescind, that's it, sue for damage now. Or he may say, okay, you have committed a breach, no problem. You continue. After some time, After the contract is over, then we will see. See an example, please read this example. In actual breach also same thing. Read. Please read this example, important. Asked in the exam. Read. Come on guys, read, read, read. Guys, please read. Read that example. Yes, read. X, a singer, enters into a contract with Y, the manager of a theatre, to sing at his theatre 2 nights every week for the next 2 months. Y agrees to pay her 100 rupees for each performance. 100,000, 10,000, doesn't matter. On the 6th, that X willfully absents herself from the theatre. In this willfully absents, on purpose. In this case, Y has the following 2 options. Y may rescind the contract and claim compensation. So, Y may cancel the contract and pay the compensation for the loss occasioned to him. Or what can Y do? Or what can Y do? Y may permit X to sing on the 7th night and claim compensation for the loss from X by giving a notice to X of his intention to do so. So, I can say that first I can cancel the contract. I can cancel the contract and claim compensation for the loss done to that person, or I may permit that person to sing on all the nights, and first the 6th night you have incurred a loss because people have come to watch and they have to refund them and have to explain to them many things. That's what. So then I can cancel the contract. So the last part, remedies for breach. These are all the remedies for breach. What are they? Let us see. Rescission, we'll see that. 1 second. I'm just telling them about the next session. Hold on. Right, come on. Remedies for breach, one by one. Remedies for breach. First, rescission. Rescission means what? Yes, cancellation of the contract. Rescission means cancellation of the contract. Next is damages. Claim damages. What type of damages are there? Ordinary damage, special damage, vindictive, nominal, remote, liquidated. Everything I'll explain. Next is specific performance. Next is what? Injunction. Next is QM. That is what? Quantum meruit. QM is quantum meruit. Quantum meruit. Quantum meruit. So various types are there. First is what? Rescission. Rescission means what, guys? Cancellation of the contract. When persons are entering into a contract, because of mutually discussing, they will end the contract. Contract of rescission. There will be remedy. Whatever amount to be written there, they would write and they will close the deal. So remedies for breach is what? One is rescission of contract, cancellation of contract. Next is what? Specific performance of the contract. I have already explained. When the amount, that is the refund, is not an adequate remedy. When refund is not an adequate remedy, I will go for what? Specific performance. When refund is not an adequate remedy, I will go for specific performance. So here I don't want money. Money is not important to me. I want you to fulfill the contract. So when I want you to fulfill the contract, that will become an adequate remedy. So that only is an adequate remedy for me, not money. Money is not an adequate remedy, but you fulfilling the contract is an adequate remedy. So what happens to this then? What happens to this? Then in that case, you have to do what? You have to perform the contract. Next, injunction means what? Stay order. Injunction means stay order. Generally this happens in movies. When I say in movies, means producers will enter into contract with film actors and actresses saying that, boss, you cannot act in any other movie. You should do 3 movies with me, 2 movies with me, 5 movies with me, like that. After 1 movie or 2 movies, if it becomes a flop, generally the actresses will move out to other movies. Can the producer bring about a injunction? Yes. Injunction is called as a stay order. So first is called rescission. Rescission means cancellation of the contract. Next is injunction. Injunction is what? Stay order. Next we have damages. Then we have, we'll come to damage. Specific performance. Specific performance done. So rescission done, specific performance done, injunction done. Now as far as damages are concerned, there are various types of damages. Ordinary, special, vindictive, remote, nominal, liquidated. What do you mean by ordinary damage? What is ordinary damage? Normal damage means basically I have entered into a contract with you to purchase goods worth 100. I have taken a contract with you to take goods for 100 rupees. 100 rupees I have taken. Now have you done it? Have you given me the contract? No. 100 rupees I have told that I am going to do. 100 rupees I have agreed that I will do. You will say, okay, 100 rupees, fine. 1000 quantity you supply to me, 100 rupees, fair enough. Now what happens, guys? Very simple. 100 rupees I have told you already. Now what happens? Very interesting thing happens. You will not perform the contract. You will not perform the contract. Because you will not perform the contract, I have to go and buy from outside somewhere. I have to go and buy from outside. I will buy at 120 rupees. Can I sue you that extra 20 rupees? Yes. This is called ordinary damage, that is extra 20 rupees I can sue. Basically ordinary damage is the difference between market price and contract price. Market price and contract price. Obviously market price will be higher. You would have taken at 100 rupees many months ago. The market price will be higher. What if the market price is lower? Then no problem. Market price is higher, then only is a problem. So if market price is higher where I have to spend extra 20, then what happens? Then it's called as ordinary damage. Then what is special damages then? Correct? Yes. Over and above ordinary damage. What do you mean by that? getting more than 20 rupees. So in that case, what is that more than 20 rupees? You would have spent a lot of time in researching for this 120. You would have dedicated few resources towards it. You would have put a person on it to search. Plus, even in the contract, you would have mentioned that if anything happens, you will have to pay some extra payment. That extra payment is called special damage. Special damages should always be communicated in the contract. Special damages should always be communicated in the contract. One is contract of rescission, then you have ordinary damage, then you have special damage. Next, third one, vindictive damages. What are vindictive damages? Vindictive is mostly, when I say vindictive, it is punishment in nature. Punishment. Vindictive means punishment. I am going to punish that person. How? This is only for two things, guys. Only for two things. Breach of promise to marry. Breach of promise to marry. Here, vindictive damages is only for two things. One is breach of promise to marry. I'll write here. Breach of promise to marry. Breach of promise to marry. Second, what? It is wrongful dishonor of check by banker. Wrongful dishonor of check by banker. Checkbook. I would have given a check. Money is there in the bank account and I have signed a check and given. I have money 20 lakh rupees in my bank account. I have given 1 lakh rupee check to you. You have deposited that check in the bank. Correct? So what happens? What happens? Basically I have given a check to you, and what happens there? They will by mistake cancel the payment. The banker, when it comes to me, when the banker receives the checkbook, he will say, okay, I have to pass this payment, and by mistake what happens? They will cancel the check, and in the cancellation of the check they will write, they will say, that is, what do you say? Rather than telling, let's say the signature was not matching, so they cancelled the check. Check cancellation is nothing but check bounce. Check bounce can happen due to various reasons. Signature mismatch, date mismatch. So rather than writing signature mismatch, the banker by mistake will write insufficient funds. So it will go out in the market saying that this fellow doesn't even have 1 lakh in the account. Imagine the social stigma. Imagine the, what do you say, bad name that goes out in the market. Very, very bad name. I come to know, I will go to the bank and said, who the hell are you to say I don't have money? So boss, I am going to sue you. What is that damage called? Vindictive damage. One more other damage is called breach of promise to marry. Breach of promise to marry. Once you make a promise to marry a person and then you commit a breach, you can go and sue for vindictive. Vindictive are punishment in nature. Vindictive damages are punishment in nature. Right? That's what it is. Rescission, damage, special, ordinary, vindictive. What are nominal damages? What are nominal damage? Namesake. What is namesake? Not getting that much. Means what? What do you mean by namesake damages? Instead of getting 20 rupees, less than 20 rupees. Okay, then wouldn't have. Okay, then one second, I'm just texting this, I'm informing them, because if they say that I have to take, then I'll take. I don't have a problem. 1 second. Alright guys, come. So if you see, again, vindictive damage done. Nominal damage is just namesake. In your library, they used to say, if you don't pay this, bill, if you don't give it on time, then damage would be 1 rupee, 50 paisa, 1 rupee per day, 1 rupee per month. These are all namesake damages. Just for the heck of it, they'll give. That damage is called as nominal damage. What are remote damages? Remote damages